ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಬರ್ದಿಲ್ಲ ಬಂದು ಬರೀತೀನಿ ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸ್ಕೂಟಿ ಕರೆಕ್ಟ್ ಆಗಿದೆ ಎಲ್ಲಾರು ಕೇಳಲ್ಲ ಫಸ್ಟ್ ಸ್ಕೂಟಿ ಕೊಟ್ಬಿಡಿ ಅದೇ ಬೇಗ ಪೆಂಡಿಂಗ್ ಏನ್ ತಲೆನೋ ಇಲ್ಲ ಸ್ಕೂಟಿ ಬರ್ತೀನಿ ಬರ್ದಿಲ್ಲ
B group. ನೋಡಿ ಚೆಕ್ ಮಾಡಿ which year? 23 minutes. Intermodal was not extended. Intermodal was not expiring. Intermodal was not granted. Some any dates. 17 NEB 17 NEB ಅನ್ನೋದು ಇರ್ತದೆ.
For adjournments, page number 16, seal number 70 and 71, page number 17, seal number 72 to 74, page number 18, seal number 75 to 81, page number 19, seal number 82 to 85.
ಅವ್ರಿಗೆ ಹೇಳಿದಾರಾ? Release finally.
List number 2.
On that day, there's no settlement.
Released.
First April. List number 2.
What is you can't move. Hearing on A. Please wait. Seal number. In withdraw ಮಾಡ್ತೀರಾ? ಇಲ್ಲ first time. Two weeks time is granted to do the needful. Element result.
Advara.
I have granted you 2 weeks time. Whoever wants to comply. You comply with the objection, take it up. I'll collect at 4:30 then. ಯಾವ್ದು ಬೇಕು 4:30. I've granted you 2 weeks time. Whenever you comply, it will be posted. See, once I give a date, they'll post it. Honestly, they'll come. If you not complete, again I'll have to adjourn it. You complete and then move if you want. What do you want? 4:30, come at 4:30. Four-thirty, error complement urgent ಇದೆ 4:30 ಅಂತ numbers ಕೊಡಿ 4:30 ಕರೀತಾರೆ.
For preliminary hearings, list number one, seat number one, Shri Rajesh Gowda.
ಇದ್ರ ಅವರು I'll pass it over.
Seat number two, Shri Geeta Ramesh.
ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ ಕಾಪಿ. Are you ready today? Are you ready now? No, because he says there is some problem there. If all of you agree to maintain status quo, I will not do anything. Or else I'll consider and either I should grant a minute or more. Until then, if you promise me not to do anything.
There is nothing happening. Nothing should happen. Nothing is happening. Nothing should happen. Why are they so good? What is, no, I don't know what is the allegation against you.
Do you want me to pass an order to maintain status quo till day after tomorrow, or will you undertake that you will not do anything? It's up to you.
Status quo regarding permission.
Whatever is the status quo, maintain the status quo.
Revenue proceedings.
You cannot use these proceedings to alter the nature or the character, and you can't do anything there. If you say that you will maintain status quo till day after tomorrow, I will not do anything. Or else I'll pass an order.
I believe a connected matter is coming up on 25th of March. It is not connected to how the other submission. The revenue records, the status of the.
What is the challenge that you made here?
The civil pending, which is gone, but the civil court has said that it does not do its side. Let them go to the civil court against which the RFPs have been filed. RFPs are pending. So what happens is. It is dismissed. Injunction is granted in my favor, but declaration is rejected.
You are challenging annexure here, na?
It depends, why one application goes as a commissioner and another application and so what of persuade the deputy commissioner to take action. Deputy commissioner's proceedings problem. There is no proceedings initiated, all proceedings have been started by the defense. I don't know what means also. Now the assistant commissioner saying I'm going to pass orders. But I believe my colleague points out that in the other matter, 2501. That's not your part. No, your lordships have already directed tagging this matter on the tagging is there because they made a submission. Yes, I am also not aware. They made a form submission to the court saying that tag that with this. Doesn't matter. It may be called on 25th till then the revenue status quo can be maintained. This is not the next date of hearing on 25th. But my main submission would be that there is a recording by a civil court, a finding of fact by the civil court that the grants.
Who initiated proceedings with the DC and 136.3? What was it?
So,
For what?
because it was found that there is a civil court order which says that the grant certificate on which the petitioner is relying upon is fake. A civil court's finding.
136.3 is a revisional jurisdiction for him to examine the veracity of the entries.
Yes.
On whose complaint you are saying suo moto?
He came to know about the existence of a civil court's order.
What is the revenue entry that he doubted?
The revenue will be the name of the petition.
And what has he done under the impugned order?
You know,
Using the letter
he
sent
says,
by-
I have to follow the civil court's order.
Please see the letter sent by-
I'll go through them.
I'll put it on all the facts.
May I make this submission? Lordship, we can call this on 25th along with that other matter. In the meantime, I will serve a copy of the objection that I have filed. I will also file it in the registry. Till then, the status quo of the revenue entries as they stand as on today, they will continue.
Well, what proceeding? But they initiate proceedings, first the deputy commissioner, then the deputy commissioner, I drop proceeding. What proceedings have you dropped? I have not initiated.
What exactly is the, why did he initiate the proceedings? Come to the first paragraph of his order. For examining the genuineness of the grant records in respect of land bearing number 1, measuring an extent of 4 acres situated so and so, so and so. What is the finding that he has given? Does he say that the record is fake? Then what exactly has he done?
Case is done. It's already decided. The same case in the open.
No, the proceedings initiated to examine the genuineness of the grant. Does he say that the grant was genuine or not genuine? Then what is he saying then? Is he saying that as per the RFA and as per the judgment, what is it to
No,
be
my lord.
done?
Page 34, my lord.
Yes.
After records were produced by the respondent number 2 and 3, my lord, therein shows that the land in unnumbered paragraph, my lord, 4. By considering the material documents available on record more fully, the documents placed by the respondent number 2 and 3, it shows that land in question is part of the survey number 1 and Savarline village. The said land has been acquired as per the proceedings conducted by the government of His Highness of Maharaja Mysore, which is evident by the gazette notification proceedings placed by the respondent number 2 and 3. Further, it reveals that after the independence by virtue of the Article 295 of the Constitution of India, the subject survey number land was transferred to the Union of India, that is Government of India, Ministry of Defence. Accordingly, the land in question is occupation of the respondent number 2 and 3 herein. Further, on careful examination of the judgment and decree in OS number 2403 of 2006 produced by the respondent number 2 and 3, have substantially justified that the entire extent of land in survey number 1 of the Savarline area is within the possession and enjoyment of the said respondents, and the acquisition of title and taking possession of the said land is considered in the said judgment, which is binding on this authority as the revenue department is a party in the said proceedings. Further, my lord, further on careful examination of the judgment and decree produced by the respondents 2 and 3 in RFA number 699 of 2002 and the Military Lands Register, Karnataka State, containing that finding of the Honorable High Court also substantiate the entry in Military Land Register is an official document maintained by the Military Department, and the entry in the Military Land Register are entered based on the acquisition of title, and the register maintained by the Military Department is maintained by the authority as evidentiary value, and the said findings of the Honorable High Court also substantiate this same. Therefore, my lord, the proceedings against respondent number 3.
Then is the grant genuine, not genuine? What is the finding then?
Based
He
on
has only recorded what they have said, accepted whatever they've said. Then what is the purpose of this? If he is dropping the proceeding, that means he is accepting the grant is genuine.
in favor of
He initiated the proceedings on the premise that there's a doubt about the grant.
yes, my lord.
If he does not record any finding and proceeds to drop the proceedings, then what is it that should be inferred?
Because this order is came to be passed on the basis of the documents produced by the respondent number 2 and 3, my lord.
No,
which
my lord,
clearly
what is the effect of this order? Shall I take it that the grant is accepted? That is the only inference that I can draw.
Order does not speak, my lord, about the genuinity of the grant, my lord. It is not examined.
Then why did you invoke 136(3) if you don't want to give a finding? If you were to say that the entry is doubtful, the entry is based on some order which is non-existent, therefore the entry is bad, that is one thing. If it drops the proceedings, that means whatever entry is there is the correct entry.
No, my lord, that has not been observed, but the documents of the,
Please wait.
yes, my lord, that is not forthcoming in the order, my lord.
So
With
I will
regard to
take,
the genuine-
I take that and conclude the proceedings.
No, my lord. But the documents clearly shows, my lord, the petitioner is not.
I read the order. I also understood. If he has initiated the proceedings for examining the genuineness of the grant,
Yes, my lord.
if he does not give a finding and yet proceeds to drop the proceedings,
Yes, my lord.
then the entries are genuine.
I will secure the records. Because order does not.
Yes.
Two things to look at, like, Number one, there was a suit in OS number 2403 of 2006, which was filed by the third issue. And in that, there is a finding of fact which is recorded by the Supreme Court, that the grant on which the third petitioner is relying upon is a fake one. And that
What is the suit for? What was the suit for?
The suit upon the.
And in that a finding is recorded.
Yes, and this fact has been separated. And in my statement.
Then what does he say? Does the DC accept?
DC refers to that and he said, Supreme Court not very on it. But it is not very happily worded, but here what's it?
Not worded at all. Forget about appeal. It's not worded at all.
Page 35, he says, but page 35, it says on careful examination of the judgment and degree.
Where is the examination here? He should say, ನಾನು 3 ಸಲ ಓದಿದ್ದೀನಿ ಕಮಲ್.
Careful examination of the judgment and degree invoice 24/0/2006 produced by respondent to it, that is me. I have substantially justified that the entire extent of survey number 1 of Sovereign India is within the possession and enjoyment of the.
Is that the scope of his inquiry?
Position of right.
Kamath, is that the scope of the inquiry under 136(3)?
He is indicating this, that when the civil court has already held, it does not specifically refer to, but he is saying the civil court's judgment is binding on me.
Then I'll go with the inference that he has dropped the proceedings, therefore he does not doubt.
No, the
Then-
proceedings is against me. He says not
No.
against R1.
No,
But
this
he
is against,
says-
it was initiated against 3 people.
Yes, second and third is me. He says.
What does the entry stand now? In whose name does the entry stand now? In the revenue entries.
Entry in the name
So
of
then
the
let it continue in his name.
He says proceedings against R2R.
ಇಲ್ಲ ಬದುಕಕ್ ಬಿಡ್ಬೇಕು ಇಲ್ಲ ಸಾಯಕಾದ್ರೂ ಬಿಡ್ಬೇಕು. ಎರಡರ ಮಧ್ಯದಲ್ಲಿ ಹಿಂಗ್ ನೀವು.
Lord, the order says, my lord, originally the proceedings was initiated against the petitioner, my lord. Subsequently, my lord, the respondents were impleaded. And they produced the documents, my lord.
They have to know status could be maintained till then.
And it is present. Or we make the submission, Lordship sir, anyway, granted in order of status.
Post on 25th.
Make this.
25th.
The RFA, not in regular. The RFA.
What is the RFA against?
Is right in this one. Right in this.
Filed by whom?
The same property.
So if you, both of you agree, I'll say that let the interest continue till the disposal of, that way this,
They will be subject to our.
obviously. This is an order I am passing by consent. Are you sure you have instructions?
This is my suggestion. Let it be a court order. For experience, you are not with it.
Let both.
Ultimately. you are not
ಬೇರೆ ಯಾವ್ದಿದೆ?
going to-
Apart from this, there are other proceedings also.
Just becomes, they put one more application for the-
For what?
challenging order of the Tashkar of voting. Challenging revenue issues.
Then what is the other proceeding with the DC? You said there's one more pending apart from. Yark Manchnath, why are you people doing this?
Same case is reopened where Tashkar gives the DC sentence and Tashkar says, go to full court and prove your right.
Plus, our 26th period now. That's what we call it, 26th. Till then, we can make a list of. what all is there.
Meanwhile, status for the right.
Status two.
Seal number 3 is Sagar V. Shastri.
What are you challenging? Next, L and F. One 136 ತಾನೆ?
Yes, my lord. Page 46, my lord, the deputy commissioner's order, based on the sale dated, my lord, 15/5/1972. Concurrent findings, my lord. The assistant commissioner's orders at page, next, sheriff, my lord, page 27. The assistant commissioner directed the Tahsildar to
Read
Okay.
page 48. ಲಭ್ಯ ದಾಖಲೆಗಳ ಪರಿಶೀಲನೆ. You had sold the property.
Sold the property.
Your predecessor interest had sold the property. Civil court is the authority. Like you've been in possession. No, all that they have done is they have asked the mutation interest to be made in accordance with the registered sale deed, which you are now disputing. At that time, you can dispute. An appeal was preferred. An appeal was preferred against an order of the assistant commissioner. Sorry, the assistant commissioner in an appeal under section 136(2) set aside the mutation made in MR number H for December 28, 2018-19 and directed the records to be mutated in accordance with the earlier mutation in MR number,
SR number.
sir,
SR number ಅಂತ ಇದೆ.
MR 34/70 to 73.
288.
The assistant commissioner came to the conclusion that there was a sale deed dated 15/5/72, registered sale deed dated 15/5/72 by document SR 288/70 to 73, and the mutation was also made pursuant to the said sale deed, but the same was not endorsed in the revenue records, and therefore it was necessary that the revenue entries reflect the effect of a sale deed. This order was challenged by way of revision, and the deputy commissioner has confirmed the said order, as against which the petitioner is before this court contending that this sale deed is not an admitted document, and therefore the entries as it stood prior to the sale deed should continue. In the light of the fact that there does exist a registered sale deed dated 15/5/72 and also an MR 34/70 to 73, both the authorities were justified in giving effect to this MR 34/70 to 73 and not going by the subsequent inheritance proceedings amongst the vendors. I find no reason to entertain this petition. Petition is therefore dismissed. It is needless to state that the petitioner would be at liberty to approach the civil court and secure an appropriate decree regarding the sale deed. And if such a decree is obtained, the entries shall abide by such a decree.
Seal number 4.
I will take notice for respond number 1 to 4, my lord. The previous matter. I will take notice for respond number 1 to 4. 5 is the private.
CJ to take notice for 1 to 4. ಏನ್ ಮಾಡಿದೆ ಏನ್ ಚೇಂಜ್ ಮಾಡಿದೆ? What is annexure H?
As per the sale deed, my lord, the is was directed, my lord. Further, the order says, my lord, to approach civil court, my lord. Page 48, my lord. ನ್ಯಾಯಾಲಯದ ಆದೇಶವೇನು? Paragraph 5.
ಸೇಲ್ ಡೀಡ್ ಇದ್ರೆ ಮಾಡ್ಲೇಬೇಕಲ್ವಾ? 58ನೇ ಇಸ್ವಿ ಸೇಲ್ ಡೀಡ್.
29/5/1958 sale deed.
And that was not given effect to for.
What's it? I will take notice, my lord. I will sit.
CJ to take notice for respondents 1 to 3, issue notice.
4 to 8, my
4
lord.
to R8. status quo regarding entries to be maintained. Earlier case only AG to take notice for us.
Seal number 5, Shri Raghavendra Ravi.
Will take notice, fresh matter. Page number
ನೀವು ಎಂಟ್ರಿ ಮಾಡಿಲ್ಲ ಅಲ್ವಾ? AG to take notice for respondents 1 to 3. Issue notice to R4 to R6. Sir, now how can I prevent them? You're only questioning the entries. How can you ask them not to initiate any proceedings? It's a violation of the grant. ಇಲ್ಲ ಅವ್ರ ನೋಟಿಸ್ ಕೊಟ್ರೆ ಆಮೇಲೆ ಚಾಲೆಂಜ್ ಮಾಡಿ ಈ 136(3) ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ I ask them to not to take any steps, I'll be exceeding my jurisdiction.
Seal number 6, Shri Janardhan Ravi.
Seal number 6, my lord. Endorsement has been issued, my lord, on 3/3/2025, my lord.
Challenge ಮಾಡಿ ಅದನ್ನ. No, challenge this. They have rejected your application.
ಅದು earlier direction ಆಗಿತ್ತು, ಅದ್ರ ಮೇಲೆ ಮಾಡಿದ್ದು. Next F ಆದ್ಮೇಲೆ Annexure F, my lord. There was a direction issued by this honorable court. After verification, my lord, the endorsement has been issued on 3/3/2025.
Next year. See, para 5,
Annexure.
page 25.
Annexure F, my lord, is also produced along with the endorsement issued by my lord. No. There was a direction by this honorable court, my lord, to comply the, my lord, request of the petitioner. My lord, after due verification, my lord, this is, my lord, endorsement has
Read
been
para
issued.
5, read para 5.
Para 5 is contention of the, my lord,
No, page 5, para 5.
consequently, the terms and earlier so petitions. My lord, this was, my lord, considered.
No, please read that.
Please, I read, my lord. Therefore, my lord, I produced.
Disposed of.
Please,
The settings say the impugned order ends so.
yes.
And collect the arrears of land revenue and formally pass an order of cancellation of forfeiture. The Tahsildar shall pass necessary orders intimating the petitioners to the arrears of land revenue and on payment of the said arrears of land revenue, the Tahsildar shall pass necessary orders for cancellation. This is the direction. He is going over this order.
My lord, what happened, my lord? Up to 2014, my lord, the application can be considered, my lord. The extension was made.
So you are saying this
2000
order is wrong.
But I'm not saying that.
Then what else are you saying?
Lord, in which, my lord, it is considered in accordance with law, my lord, they considered.
No. The Tahsildar shall pass necessary orders intimating the petitioner as to the arrears of land revenue and on payment of the said arrears of land revenue, the Tahsildar shall pass necessary orders for cancellation of the order of forfeiture. How can you
Unless,
say in accordance with law?
unless and until, my lord, the extension of by the, my lord, government to, my lord,
You're not bound by the government, you're bound by this order, isn't it?
Yes.
So how can you ignore this order?
will get instructions further, my lord, I will. 10 days time, my lord, I will. Unless, my lord, what happened? 2012, my lord, the order has been issued by the government. That was extended to until 2014. Within that period, my lord, who are filed the applications for, my lord, the pada is restored. My lord, that was considered.
No, Mr. Reddy,
Whereas
what-
this
if the-
petitioner,
if the land revenue is not paid, what is the ultimate effect?
my lord, it will comes to, my lord, the pada, it is resumed to the government.
All right. Then
But
what is
that
it?
was,
Then what is it that you can do? You can sell that land to recover the arrears of land revenue. If before you sell, somebody comes and tells you, please collect your land revenue. You'll say, no, I will not
For-
collect land revenue.
for which, my lord, the government has considered
Forget
and
about
extended the
government.
time.
What does the law say? Does the law say that once it falls pada,
Please.
it belongs to you for all time to come?
Lord, till, my lord, as the government has considered to extend the benefit of the,
I'm not concerned with the government. I'm concerned with the Land Revenue Act. Does the Land Revenue Act state that if you pass an order of forfeiture, they lose the right to reclaim that land?
they have to pay the land revenue, that's all, that is.
That is why this court said, issue a notice, asking him how much land revenue you should pay. And once he pays that revenue, cancel that forfeiture order. And if you're saying that illa government order,
get-
then
I will get further instructions, my lord, 10 days, my lord, I will. My lord, my instructions is, my lord, by the concerned authority. Till for 2014, my lord, the extended the period. If within that period, my lord, who are all filed the application for regrant or the restoration, my lord, that applications are
see the
considered.
provision. I don't think there's any time limit for
Please.
that.
I will go.
And have it next Monday, get instructions by next Monday.
Please.
24th. Seal number 7, Shri Pradeep Nayak.
In this matter, my lord, last occasion, this court orally directed, my lord, to secure the page of the Xerox copy from the FSL department and issue the same by certifying, my lord. The officials has approached the FSL department, my lord. Within 10 days, my lord, it will be completed as per the direction of this honorable division bench, my lord. But they refused to give that report, my lord. After 10 days, my lord, it will be issued, my lord, to the petitioner. Because, my lord,
I'll call it after 10 days.
please, my lord, 2 weeks, my lord.
28.
2 weeks.
28. Seal number 8, Shri Gandharti.
What are you challenging? 136.3. 136.3.
19 for 2010 order.
2010 order. What has he done under next year?
Instance of one.
There is an observation in the order also, my lord. The entries will be subject to the outcome of the judgment of the civil court, my lord. That is OS.
Where is the order of the AC? What is your name? You were not a party before. And what is your right over this land? Grandmother purchased a property from whom? From whom? ಏನು AC ಮಾಡ್ಬೋದಾ?
My lord, page 25, my lord. My lord, the deputy commissioner order says, my lord, the petitioner's land has already been acquired by the society, my lord. Page 25, my lord, deputy commissioner's order, unnumbered paragraph 2, my lord.
Please read page 41. It's a condition of the appellants. The appellants are the.
40.
While mentioning the server number as server number 24/3, and instead of the same, it has been mentioned as 24/8. And what is purchased, the father of the applicant is land bearing 24/3 and not 24/8. Can you decide this question?
Lord, but my lord, the Deputy Commissioner's orders, my lord, page 25, my lord, unnumbered paragraph 2.
Respondents 1 to 5. Issue notice to respondent 6 to 15. Status quo regarding entries to be maintained.
For 9. And redeem.
Mention it at 1:30, you can't ask in the middle.
Serial number 9, I seek for further another 2 weeks time, my lord, because the endorsement has been changed, my lord.
Arrest Rito.
Issue Reddy. Petitioner's husband name.
This is number 50 to 54 ಇಲ್ಲಿ. 54 ಅಲ್ಲಿ. The endorsement talks about 54.
The 52, my lord.
ಇಲ್ಲ,
Page 2.
54 ಅಂತ ಇದೆ.
ಹೌದು, ಇಲ್ಲಿ ಮೇಲ್ಗಡೆ ವಿಷಯದಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 52 ಅಂತ ಬರೆದಿದೆ.
ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್ 54 ಅಂತ ಹೇಳ್ತಾರೆ.
ಹೌದು ಸರ್, ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್ 54 ಅಂತ ಹೇಳಿದ್ದಾರೆ, ಬಟ್ ವಿಷಯದಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 52 ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಫ್ 52 ಅಂತ ಹೇಳಿದ್ದಾರೆ, ಅದೇನು ಸ್ಟೆನೋಗ್ರಾಫಿಕಲ್ ಮಿಸ್ಟೇಕ್. ಸರ್ವೆ ನಂಬರ್ ಸೋನ್ಸೋ ಪೈಕಿ 33.12 ಎಕರ್ ಗುಂಟ ಜಮೀನನ್ನು ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ಡೇಟೆಡ್ 5/5/22 ರಲ್ಲಿ ರಾಜ್ಯ ಪರಿಭಾವಿತ ಅರಣ್ಯ ಪ್ರದೇಶವೆಂದು ಘೋಷಿಸಿ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಪತ್ರದಲ್ಲಿ ಪ್ರಕಟಗೊಂಡಿರುತ್ತದೆ. ಸದರಿ ಅರ್ಜಿದಾರರು
How did your name come about? Darkhast Melissa. The RTC that he has produced today indicates that his name was entered Darkhast Mulaka MR 4/8182.
Yes, my lord. As per the Darkhast, my lord, it was entered. I will secure instructions, my lord.
Now, shall I send it this order and ask him to reconsider in the light of this?
Tomorrow, my lord.
Because if he has not taken this into consideration.
Yes. Tomorrow, my lord.
Till number 10, Sri Prakash. Till number 11, Shri Trivikram.
In the year 2023 itself, my lord.
Application ಹಾಕಿದ್ದಾರೆ.
In the year 2023 itself, my lord, the deputy commissioner passed an order for eviction, my lord. This was not questioned. The petitioner names points, my lord, serial number 7.
ನಿಮ್ಮ ಹೆಸರೇನು?
Serial number 7, my lord is.
This has been rejected in 23 itself. You have not challenged this order.
Told. So I will put in.
Whether you receive it or not, that will be a ground to challenge. How can you go against this order? Then at AGA, places on record, the official memorandum dated 8/9/2023 and contents that the application of the petitioner for regularization
Please.
was rejected by the deputy commissioner. And this order has not been challenged, and therefore the consequential order of eviction cannot be questioned by the petitioner. Relist on stones.
24.
If it's been rejected, your case goes. They have been granted, yours has been rejected, what can you do?
25th. Serial number 12, Sri Shankar Reddy.
What is annexure? Annexure. Not consider what? Can ready or
Will take notice, my lord.
Start with survey number 41. Age with different survey number says we bracket land that claim was 41. Now not considered. Second case is like not adopted. Some other appeal
where is the order of the AC?
First page, survey number 41. 1 acre 27. Thereafter second page, he goes to survey number another page. Suppose the same he goes to land.
You challenge MR 6/2006, 2007. What was that?
They come to know that this law is there. Subsequently, they are into change the legal response to the the document because some of it is there. We notice what is designated in a different procedure. Therefore, we challenge the same.
You challenged after 12 years. Then I'll satisfy this order, let him reconsider on merits. Respondents here either.
Either. Private respondents are.
Now, was she notified about this?
As soon as I file a revision, then you know the issue, the endorsement.
We carried a second portion, you have server number and it is the same server number. Then why did you make that statement? Yes. That the order of the deputy commissioner basically says that you are claiming to be the legal heir. No. Kindly read the second paragraph of annexure F. And what exactly is wrong? I mean, can you determine as to whether you are the LR or No, you were agreed by MR 6/2006 by which the Khatedar's name was removed and his legal heir's name was entered. You also claimed that you were a legal heir and that person was not the legal heir. Irrespective of what is stated in the order, MR 6/6 and 7 was upheld, against which you filed a revision. Revision, the Deputy Commissioner ultimately says that there's a dispute regarding who the legal heir is. Think, why do you want to waste your time? Go to the civil court and. La.
Commissioner says that I have applied for 40.
You will unnecessarily fight here because ultimately AC can't decide this question as whether you are the legal heir or is the legal heir. I'll give an observation saying that that order will not come in your way to go establish. An order of mutation was made in MR 6/2006/2007 by which the name of Rajappa, the Khatedar, was deleted and his legal heirs' names were entered. An appeal was preferred by the petitioner in the year 2019 and this appeal was dismissed. It may be pertinent to state here that in this order of the Assistant Commissioner, though the claim was in respect of serial number 41 and MR 6/2006/2007, reference is made to serial number 113, which was unrelated to the dispute. This was an obvious error. Be that as it may, the revision was preferred to the Deputy Commissioner as against the said order. And the Deputy Commissioner has taken the view that there was a dispute as to who was the legal heir of Rajappa. And this question could not be adjudicated with revenue authorities and he has directed the parties to approach the civil court. In my view, even though there is an error in the order of the Assistant Commissioner, the ultimate order of the Deputy Commissioner is just and proper, since the claim of the petitioner that she is the legal representative, legal heir of the Khatedar and not Shantamma, in whose name the revenue entries were reflected, cannot be adjudicated by the revenue authorities. And the only remedy available to the petitioner would be approach the civil court and secure an appropriate decree that she has succeeded to the property of Rajappa. President liberty to the petitioner to approach the civil court to establish her assertion that she is the legal heir entitled to succeed to the property of Rajappa. The writ petition is dismissed. It is needless to state that in the event the decree is obtained by the petitioner, revenue entries will abide with the result of the said decree. For whom? Disposed of.
Seal number 13, Shajit Kalyan.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಯಾವಾಗ?
Please. 10/2/2025 endorsement has been.
Challenge it. The prayer in this writ petition is for issuance of direction to the second respondent to consider the representation dated 1/1/2025, whereby the petitioner was requesting for a mutation to be made in this revenue entries. So when the AGA places on record the endorsement dated 10/2/2025 and states that as per this endorsement, the claim of the petitioner was considered and was rejected. So in the light of the said endorsement, it is obvious that the prayer in the petition would not survive consideration, and therefore the petition is dismissed and become unnecessary. Liberty is reserved to the petitioner to challenge the endorsement dated 10/2/2025.
Seal number 14, Shri Manikanta. Okay, that's unnecessary. That's unnecessary.
My lord, in this matter, my lord, I pray for weeks time, my lord, to pass orders on the representation, my lord, because the RTC says, my lord, is a government land. Just now I secured the RTC, my lord.
Let him get instructions.
Please, my lord. Allah,
Your prayer is to consider the representation. If he
Yes.
says, I'm considering representation,
2 weeks. my lord.
First April. Seal number 15, Shri B.S. Lal Raja.
In this matter, my lord, it is under process, my lord. 3 months time may be granted, my lord. We will complete the entire process, my lord, conducting podium and duress, the entire thing, my lord.
the prayer in this petition is to direct the second respondent to place the petition applications with recommendation to the third respondent for conducting a podium and durasti pertaining to his land bearing number 92 measuring 3 acres. Then AGA, on instructions, submits that the application of the petition has been processed and within a period of 3 months, the podium and durasti proceedings will be completed. Correct?
Yes, my lord, 3 months.
According to said submission, that the podium and durasti will be completed, this was number 92, measuring 3 acres within a period of 3 months. The petition is disposed of.
Seal number 16, Shri Eviction.
In this matter, my lord, I pray for another 2 days accommodation, my lord.
The list.
Error this, 2 days.
2 days time ಕೇಳಿದ್ರು. 2 days time ಬೇಡ ಕೊಡಕ್ಕೆ.
ಅಲ್ಲ, ಹೊಸ ತಹಸೀಲ್ದಾರ್ ಬಂದಿದ್ದಾರೆ ಅದಕ್ಕೋಸ್ಕರ. ಅಲ್ಲ, ತಹಸೀಲ್ದಾರ್ ನಿನ್ನೆ ರಿಪೋರ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಲಾಸ್ಟ್ ವೀಕ್ ಅದಕ್ಕೋಸ್ಕರ.
20th. Seal number 17, Shri Dilip Kumar.
In this matter, my
Let us listen to it.
my lord, 2 weeks time may be granted, my lord. It was directed to conduct the survey, my lord. Because ಅದರಲ್ಲಿ ಕೆರೆಂಗಳ ಅಂತ ಬರ್ತಾ ಇದೆ, ಅದಕ್ಕೋಸ್ಕರ ಸರ್ವೆ ಮಾಡಬೇಕಾಗಿದೆ. ಅವೇರಿ ಎಲ್ಲ ಕೆರೆಂಗಳ ಅಂತ ಬಂದ್ಬಿಟ್ಟಿದೆ ಕೋಡಲ್ಲ.
Against whom was the decree?
Yes, that my lord, appeal is also preferring, my lord. State is preferring an appeal, my lord.
Where is the decree?
Page 23, my lord, annexure D.
ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ ನೀವು.
ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಅಪ್ರೂವಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಗೌರ್ಮೆಂಟ್ ಇಂದ ಅಪ್ರೂವಲ್ ಬಂದಿದೆ. Suit for declaration.
Actually, you are in contempt of law. Defendants 3 and 4 are hereby directed to restore the name of the original plaintiff in the RTC extracts of land in number 70 of Chunchangatte village.
Yes, my lord.
How can you get over this order saying that I will consider?
They have obtained approval, my lord. They are preferring the appeal against this judgment and decree also.
ಮಾಡಿ ನೀವು ಆಮೇಲೆ ಹಾಕೊಳ್ಳಿ 3 ವರ್ಷ ಆಯ್ತು.
My lord, along with representation, my lord, documents are also not.
Put this representation. This is a positive direction by the civil
Yes, my
court.
lord.
Directed to implement this order.
My instructions, my lord.
Your instructions can't be contrary to the decree, isn't it?
Yes, my lord.
What is this earlier writ petition?
That is also the for restore of.
See, this is the second writ petition.
When this order passed, my lord, then only that came to know about the judgment and decree, my lord. Because in that order, my lord, the FD also present, my lord. That was also the observation in the order. Paragraph 4.
You had appeared.
Yes, my lord, paragraph 4. Then only, my lord, we came to know about the judgment and decree, my lord.
No, you change the entries and make it subject to the result of an appeal that you file. So that way at least you will have some protection.
Monday, my lord, a request. Monday, my lord.
ತಿರ್ಗಿ ಅಷ್ಟೆಲ್ಲ ಅಪೀಲ್ ಆಗ್ಬಿಟ್ಟು ತಿರ್ಗಿ ಅಪೀಲ್ ಅಂತ ಹೇಳ್ಬಾರ್ದು ಅದಕ್ಕೆ. ಅವ್ರು ಗೆದ್ದು ಸೋತಂಗ ಆಯ್ತಾನೆ ಇವಾಗ. ಗೆದ್ದು 3 ವರ್ಷ ಆಯ್ತು. If they don't see their entries there. The prayer in this writ petition is for issuance of direction. Consider the representation of the petitioners dated 21/1/2025. Copy of which is produced the next year. It is a case of the petitioner that petitioners that they had pursued a suit in OS 5676/2012 against the state before the City Civil and Session Judge, Bangalore. And the said court by a judgment and decree dated 1st of December 2022 decreed the suit and held that the petitioners herein were the owners in possession of the scheduled land. The civil court in fact passed a specific order in the following terms, page 44. It is the grievance of the petitioner that this order has not been challenged, and despite the lapse of nearly 3 years, the decree has not been given effect to. It is also pointed out that the petitioners had approached this court earlier in WP 13486/2023, and despite an order passed by this court on 4th of September 2023, directing the authorities that decision will be taken within a period of 3 months, the decree of the trial court has remained unfulfilled in this issue of the matter, in my view, it would be appropriate to direct the respondents error
The respondent number
3 and 4
10.
to implement the judgment and decree passed in OS 5676/2012, by which they were directed to restore the name of the original plaintiff, that is Ramanna. Actually, ತಪ್ಪಲ್ವಾ? ಡಿಗ್ರಿ ಎಲ್ಲಾರ್ಸ್ ಅಂತ ಹಾಕ್ಬೇಕಿತ್ತಲ್ವಾ? Then it should have been. And implement the order of the trial court and ensure that the decree holders' names are reflected. Since the trial court directed the name of the original grantee, original plaintiff, that is Shamanna's name, to be restored, and since he is no more, it is obvious that the third and fourth respondent will have to enter the names of his LRs, that is plaintiffs 1A2, 1C3. This order shall be complied with within a period of 1 month from the date of receipt of a copy of this order. So it is over necessary to state here that if the state decides to file an appeal against this order, the entries that would be made pursuant to the decree passed in OS 15676/2012 will be subject to the result of such an appeal.
In the written statement, my lord, we have taken contention that it is a government anchor, but not adduced the evidence, my lord. That is the main.
Yeah, the normal thing.
80, Shri Shrikant Pratik.
That is why I said, if principal secretary is prepared to integrate their system with our court
Yes,
system,
my lord.
the moment the suit is there, at least the records will come. So then,
As per the direction of the Samba court, my lord, I have asked them to present, my lord, on that is matters are coming, my lord. They will be present before this court, my lord.
that will solve this kind of an issue.
Yes, ma'am.
AC ಏನಕ್ಕೆ ಮಾಡಿದ್ರು?
ಇದ್ರಲ್ಲಿ
No, where is the original order?
the suit, my lord, entry mode is also operating. That is also observed, my lord.
What is wrong? Now read the order of page 84. ದೊಡ್ಡಬಳ್ಳಾಪುರ ತಾಲೂಕು.
ದೊಡ್ಡಬಳ್ಳಾಪುರ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ನಾಗದೇವನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 108 ರಲ್ಲಿ 1 ಎಕರೆ 36 ಗುಂಟೆ ಜಮೀನು ಬಗ್ಗೆ ಈ ಹಿಂದೆ MR ಸಂಖ್ಯೆ T9/2021 ಡೇಟೆಡ್ 24/3/21 ಅನ್ನು ಮಾನ್ಯ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ತಡೆಯಾಜ್ಞೆ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಆಕಸ್ಮಿಕ ಕೈತಪ್ಪಿನಿಂದಾಗಿ ಮಾಡಿರುವ ಆದೇಶದ ಸಂಖ್ಯೆ ಸೋನ್ಸ ವಜಾಕರಿಸಿದೆ. ದೊಡ್ಡಬಳ್ಳಾಪುರ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ನಾಗದೇವನ ನಡಿ ಗ್ರಾಮದ ಸಭೆ ನಂಬರ್ ಖಾತೆಯನ್ನು ಇಂದಿನಂತೆ ಮೂಲ ಖಾತೆದಾರರ ಎಸ್.ಸಿ. ಜಯರಾಮಪ್ಪ ಅವರಿಗೆ ಪುನರ್ ಸ್ಥಾಪಿಸಬೇಕಾಗಿದ್ದು, ಸದರಿ ರವರ ಪ್ರಮಾಣ ಪತ್ರದಂತೆ ಎಸ್.ಸಿ. ಜಯರಾಮಪ್ಪರವರು ದಿನಾಂಕ 13/9/2020 ಮರಣ ಹೊಂದಿರುವುದರಿಂದ ಅವರ ವಾರಸುದಾರರ ಹೇಳಿಕೆಯಂತೆ ಪೌತಿ ಖಾತೆಯನ್ನು ಜೆ. ನಾರಾಯಣಗೌಡರವರಿಗೆ ಖಾತೆ ವರ್ಗಾಯಿಸಲು ಆದೇಶಿಸಿದೆ. ಈ ಆದೇಶವು ಮಾನ್ಯ ಹಿರಿಯ ಸಿವಿಲ್ ನ್ಯಾಯಾಧೀಶರ ನ್ಯಾಯಾಲಯದ ದೊಡ್ಡಬಳ್ಳಾಪುರ ಅವರ ಪ್ರಕರಣದ ಸಂಖ್ಯೆ OS ನಂಬರ್ 341/2019 ಅಂತಿಮ ಆದೇಶಕ್ಕೆ ಒಳಪಟ್ಟು ಸೊ ಅಡಿಯಲ್ಲಿ ಖಾತೆ ವರ್ಗಾಯಿಸಲು ನಿಯಮಾನುಸಾರ ಕ್ರಮ.
ಕೈತಪ್ಪಿನಿಂದ ಆಗಿದೆ ಅಂತ.
ಕೈತಪ್ಪಿನಿಂದ ಆಗಿದೆ ಅಂತ ಅರ್ಲಿಯರು
What
ಸೂಟ್
is
ಎಲ್ಲ
the
ಇರೋದು
DCC?
ಗೊತ್ತಾಗಿಲ್ಲ. ಸೂಟ್ ಇದ್ದಿದ್ದೆಲ್ಲ ನಾಲೆಡ್ಜ್ ತಂದಿಲ್ಲ.
ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಅಂತ ಹೇಳ್ತಾರೆ.
ಈ ಕನ್ಫರ್ಮ್ಸ್ ದಿ ಆರ್ಡರ್ ಮೇಲೆ
ಇಲ್ಲ ಅಲೋಡ್.
ಈ ಅಲೋಡ್ ದಿ ಅಪೀನಿಯನ್.
ವೈ? ನಿಮ್ಮ ಹೆಸರು ಹೆಂಗ್ ಎಂಟ್ರ್ ಆಯ್ತು ಅದರಲ್ಲಿ? ಅವ್ರ ಹೆಸರು ಹೆಂಗ್ ಎಂಟ್ರ್ ಆಯ್ತು? ಇಲ್ಲ ಕೈತಪ್ಪಿನ ಅಂದ್ರೆ ಯಾವ MR T9/2021 ಎಲ್ಲಿದೆ ಅದು ಆರ್ಡರ್? ಯಾವ ಆಧಾರ ಮೇಲೆ ಗೊತ್ತಾದೇನಾದ್ರು? Notice. Which he accepts notice for.
ಅಲ್ಲ ನೋಟಿಸ್ ಆಗಿದೆ.
Notice to.
Even Deputy Commissioner also, my lord, set aside the order of the Assistant Commissioner, he also observed ಮಾನ್ಯ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಬಾಕಿ ಇರುವ ವಯಸ್ಸೇ.
Now early, but what was the entry earlier? Why was it changed?
Yes, my lord. I will get instruction.
Entries been. Status.
Number 19, Srimati Vinita PC.
Avare.
We will take notice, my lord.
He accepts notice for respondents. Release preliminary on. ಏನ್ ತೊಂದ್ರೆ ಏನು ಸರ್ವೆ ಮಾಡೋದಕ್ಕೆ ಎಲ್ಲಾದ್ರೂ ಇಷ್ಟೊಂದು ಬರ್ತಿದೆ?
Some of the documents, my lord, it is not available in the issue register main, my lord.
7th. Number 20, Shom Shekhar KM.
In this matter, my lord, 6 for weeks time, my lord. My instructions are, my lord, the petition's application has been approved by the first committee, my lord. Now it is forwarded to the second committee, my lord. I 6 for another week's time, my lord, to. Now it is placing before the committee, my lord. I 6 for week's time on this.
Second committee, na?
ಅದಕ್ಕೆ I have to get clarification, my lord. Morning ಅವರು ಹೇಳಿದ್ ನನಗೆ instructions ಅದಕ್ಕೆ. I was securing the records, my lord.
24, Silver 21, Sri Chokkareddy.
Release ಅಂದ್ರೆ ಅದೇ. What is the next area?
That is the endorsement, my lord. ಗೋಮಾಳ endorsement, my lord, after 4 lines. ಪ್ರಾಣಿಗಳ ಪರಿಶೀಲಿಸಾಗಿ ಸದರಿ ಜಮೀನು ಮೂಲತಃ ಗೋಮಾಳ ಜಮೀನಾಗಿದ್ದು ಕ್ರಯಪತ್ರದಂತೆ ಖಾತೆ ಬದಲಾವಣೆ ಮಾಡಲು ಮಾರಾಟಗಾರ ಹೆಸರಿಗೆ ಪ್ರಸ್ತುತ ಖಾತೆ ಇರುವುದಿಲ್ಲ. ಪ್ರಸ್ತುತ ಪಾಣಿಯಲ್ಲಿರುವ ಖಾತೆದಾರರಿಗೂ ಕ್ರಯದಾರರಿಗೂ ತಾಳೆ ಇರುವುದಿಲ್ಲ ಎಂದು ವರದಿ ನೀಡಿರುತ್ತಾರೆ. As per this report, my lord, their request was rejected.
Number 22, Sri Shom Shekhar.
Imagine.
I will take notice, my lord. Fresh matter, my lord.
Accept notice for response. Realistic to the-
Seventh. Seal number 23, Sri Vasant Kumar HT.
In this matter, my lord, last occasion, my lord, this got directed to file an affidavit of the PDO and the president of Gram Panchayat, my lord. I have intimated, my lord, because I am not going representing the PDO because, my lord, they are not come under the state. They are personally present before this court, my lord. They are filing the affidavit, my lord, stating that it is fabricated, my lord, and they are also producing the specimen. The affidavits of the PDO and the president of Gram Panchayat. In the PDO affidavit, my lord, the PDO has enclosed the Xerox copy of the PAN card, my lord, and also specimen signature, which differs the signature in construction license, my lord. And the president of the Gram Panchayat also state, my lord, her signature is also forged, my lord. She has taken charge 1 year before, my lord. Annexure G is the license, my lord.
If I were to take cognizance of this and direct the criminal inquiry to be conducted. That I am not prepared to accept even for 1 minute.
Execution of gift deed also suppressed, my lord. They have paid tax. Entire thing has been paid by the petitioner. That has been suppressed. Last occasion, my lord, it was observed. They have suppressed all the fact, my lord. My lord, my instructions are, my lord, within 1 month, my lord, they have constructed overnight, my lord. Though there was a
You have not said any aspect, you have stated that, no, you are already consenting them, so your mother has already.
You want an order on merits now. So you want an order on merits, isn't it? Then I will accept this affidavit that this is a forgery. Direct a criminal inquiry to be conducted against you, and I'll ask him to demolish the house forthwith. I had given you a choice. You voluntarily make a statement.
There is a rule, the false information.
No, the false information is given to us, to this court, in not telling us that you were given this land, it was allotted to your mother under registered gift deed, and making an assertion that you are a landless person and you had constructed a house. The finding that I record in this case will seal your fate everywhere. I warned you last time. Your brother gets a site, your mother gets a site, your mother transfers a site. You suppress that, you have paid the taxes in your mother's side, and now you're acting like as a very innocent person, you had no house. That itself, I'll say, it's a fraudulent.
So my brother as well as me and my mother both have been definitely the. You put on Chupi and proceeding to grant the request to grant because my mother was granted, my brother was granted.
So every member of your family should be granted one site in the village.
My brother, my brother. Only is probably he's not because it's not because other things because they are limited, they are completely, they are consistent with the law, they give a notice. This would have stopped that, they will not never issue any notice. That is the mistake by demands.
So you applied for this building license, isn't it?
Yes, applied for, look at the options of the opinion, the other meeting of mass resolution, okay, encourage that.
ಎಷ್ಟಾಗತ್ತೆ ಮನೆ ಕಟ್ಟೋದು ಅಂದಾಜ್ ಖರ್ಚು?
ಒಂದು 6 to 7 lakhs ಚಿಕ್ಕ ಮನೆ ಕಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅವ್ರು ಬೇಕು ಅಂತಾನೆ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡ್ಲಿಕ್ಕೆ 6
So
to
I'll impose cost of 5 lakhs only. I'm putting you on notice. They will demolish and also I'll impose a cost of 5 lakhs. I will initiate. I will initiate. I don't need anybody's permission.
At the instigation of the government, they are stopping the building. First application goes through the.
coming with new story, my lord.
Uh, 2017 was rejected, alva?
Yes, sir. It is rejected. On the ground that, my lord, the petitioner is not having any house, my lord, to regularize.
Which is that document? Anjana?
Lord, along with memo, my lord, I produced the application. Along with memo, my lord, last date, my lord, was filed. Document number 1 is the application, my lord.
Document number 2.
Document number 1 is the application. Document number 2 is the report, my lord. May I read, my ಯಾವುದೇ ಮನೆಯನ್ನು ನಿರ್ಮಾಣ ಮಾಡಿರುವುದಿಲ್ಲ, ಖಾಲಿ ನಿವೇಶನವಾಗಿದ್ದು ಅಕ್ರಮ ಸಕ್ರಮದ ಅಡಿಯಲ್ಲಿ ಶಿಫಾರಸನ್ನು ಮಾಡಲು ರಹ ಇರುವುದಿಲ್ಲ. ಮುಕ್ತ
When was the kata changed?
My lord, the kata was changed, my lord. Next, my lord, further documents. After photograph, my lord.
Date is
And date ಇಲ್ಲ. ಅದು ರೌಂಡ್ ಮಾಡ್ಬಿಟ್ಟು ರಾಮಕೃಷ್ಣ ಸನ್ ಆಫ್ ನಾಗಮ್ಮ ಅಂತ ಬಂದಿದೆ. After photograph, my lord.
date ಇಲ್ಲ.
Date ಇಲ್ಲ.
Yes. I had given you a choice. I told you if you demolish the house and withdraw the petition, I'll keep quiet. I will not allow you to withdraw. You will demolish the house, then withdraw the petition, or else I will direct demolition. I'll impose 5 lakhs cost and initiate criminal proceedings against you. You cannot take the court for granted. Anything else? The prayer in this writ petition is for washing of annexure M, which is an order directing the petitioners to remove the structure that has been put up by them illegally. It is a case of the petitioner that he had given a application seeking for regularization of the unauthorized construction that he had put up as per annexure.
Document number 1, my lord, filed along with memo 3/12/2015, my lord, dated.
He'll produce ಮಾಡಿಲ್ಲ, ಅವ್ರು produce ಮಾಡಿಲ್ಲ.
ಅವ್ರು ಮಾಡಿಲ್ಲ. ಅವ್ರು endorsement produce ಮಾಡಿದ್ರು. Therefore, this court directed to produce the application.
On 3/1/2015. A copy of this application is produced as document number 1 along with the memo filed by the government advocate. This application indicates that the petitioner was seeking for regularization of an unauthorized construction that he claimed to have put up in property bearing number 158, measuring about 1,600 square feet on a plot measuring 40 by 40. The petitioner also contends in his petition that he had obtained a license to put up a construction on 21/9/2023 from the Panchayat Development Officer. And on the basis of this license, he had put up the structure. And he also places on record. And he also placed reliance on a no objection certificate
Issued by the president of
from
Gram
the
Panchayat. President,
the president to the effect that there was no arrears of revenue. Petitioner also seeks to place reliance on an electric bill to indicate that he is in possession of the property. And he said property has also been given an electricity connection. Then a DG on the other end submits that this is a case where the petitioner is abusing the process of this court. He points out that in the year 1992, the petitioner's brother applied for a site under the Ashaya scheme, and he was also granted a site under the said scheme. Thereafter, in the year 2015, both the petitioner as well as his mother made an application seeking for grant of a site under the Ashaya scheme, and the claim of the petitioner under the aforementioned application dated 3/2/2015 was actually rejected by
endorsement dated 57/2017, document number 3.
Tahsildar with a clear observation that there was no house constructed for entertaining the application filed by the petitioner. Then AG also points out that this application was not, this rejection was not challenged by the petitioner. Practical annexed to document number 2 and 30. Then AG also points out that thereafter on 21/2/2024, the petitioner's mother in fact gifted the house, the site that she was allotted under the Ashaya scheme under registered gift deed, and the Kata was also changed the name of the petitioner, and he was also paying taxes in respect of the said property which was given to him as a gift by his mother. Then a DGA points out that this material fact has been suppressed, and an argument is sought to be advanced that the petitioner is a sightless person and he had put up a dwelling house which is entitled to be regularized under the provisions of the KLR Act. As far as the contention of the petitioner that a license had been granted by the Panchayat Development Officer, then a DGA places on record the affidavit filed by B.R. Narayan Swamy, who was working as a Panchayat Development Officer, who has stated that the building license which is produced by the petitioner as Annexure G is a fabricated document, and the signature found thereon is not his signature. He has also produced the copy of his PAN card to indicate
And also
that the
specimen,
signature found does differs substantially, and this was a clear case of forgery. He also states that the procedure for issuance of a building construction license by an applicant was that a request is required to be made through the online portal, and thereafter documents are verified, and the same would be presented in a meeting before the panchayat. But in the incident case, no such application was filed by the petitioner, and this also indicates that the grant of the license was a rank forgery. Then a DG has also placed on record an affidavit of Srimati Rajeshwari, the president of the Chennai Gram Panchayat, and she has also stated that The NOC that is produced by the petitioner's annexure J is a forged document, and the signature found therein is not her signature. She has also produced a copy of the PAN card to indicate that her signature and the signature found on annexure J vastly differ. She also states in the affidavit that her office would issue an NOC only in respect of private properties and not for government lands, and that too after verification of records maintained in the office. She has stated that to her knowledge, the petitioner has not made any application seeking for grant of an NOC. From the above assertions, it is clear that the petitioner has come to the court by suppressing material facts. Firstly, the petitioner has not even whispered the fact that the property granted to his mother under the Ashraya scheme was in fact gifted to him under registered gift deed dated 15/7/2024. He has also suppressed the fact that the Kata was also changed from the name of his mother to his name, and he has been paying taxes. If the petitioner has admittedly been a recipient of a gift, and that too of a property allotted to his mother under an Ashraya scheme, it is obvious that he would not be entitled for regularization of any dwelling, much less an unauthorized dwelling. The petitioner, by suppressing this material fact, is fundamentally trying to abuse the process of the court and snatch an order so as to protect his illegality. As far as the assertion that he demolished the earlier existing structure after obtaining an approval and built a structure is concerned, in the light of the affidavits that are now filed by the PDO and the president, it is also obvious that the petitioner has gone to the extent of forging licenses and the signatures of licenses and NOCs to establish before this court that he has put up a building lawfully. It is stated here that if the petitioner had built a structure lawfully, the question of regularization of such a construction would not arise. It is inconceivable that the petitioner would seek for approval of a building plan to construct a house on government land. The application that is filed by the petitioner is also not forthcoming before this court. These facts by themselves clearly establish that the petitioner has come to this court only to secure an order from this court just to protect his illegality, that is the construction of a structure which has been done on the basis of forged documents. And therefore of the view that the petitioner would be disentitled to claim any relief whatsoever, and it would be in the interest of justice that the respondents take immediate action to demolish the structure put up by the petitioner. The petitioner shall also be liable to pay costs of rupees 2.5 lakhs to the Idva Institute of Oncology within a period of 2 months from the date of receipt of a copy of this order. Petition. They should have thought about it twice. They should have thought about it twice before they did all this. I give you thrice, 3 opportunities.
Number 24.
I have said forthwith. You want me to report, directly to report complaints?
Forthwith we will take action. In this matter, my lord, I seek for 1 week accommodation. They are seeking for to conduct Podi and Durust.
Notice only that.
Notice. Notice.
24th. Number 25.
Yes, my lord. If 3 months time is granted, my lord, the process will be completed, my lord. My instructions.
3 months ಅಲ್ಲಿ ಮಾಡ್ತಾರಂತೆ. 3 months ಅಂತ ಹೇಳ್ತಾರೆ. The clear in this petitions to direct the third respondent. Consider and pass appropriate orders in the representation dated 4/7/2023 by which the petitioner is seeking for effecting Podi and Durasti in respect of his land bearings number 16, measuring 1 acre 20 guntas, situated Ajapnalli village, Kasba, East Obli, Tumkur Taluk and district. Learned AGA, on instructions, submits that if 3 months time is granted, the request of the petitioner for conducting a Podi and Durasti will be considered, and the Podi and Durasti would also be completed within a period of 3 months. According to said subsection, the petition is disposed of.
Seal number 26.
In this matter, my lord, within 3 months, my lord, the petitioner's application will be placed before committee, my lord, along with other applications. 3 months.
The prayer in this petition for issuance of a minimus, direct the respondent to place the matter of the claim of the petitioner before the second respondent committee for enabling the committee to take steps to confirm his unauthorized occupation. DG on instruction submits that the claim of the petitioner will be placed before the committee constituted for regularizing unauthorized occupation within a period of 3 months, and the committee will consider and pass appropriate orders within a period of
3 months.
3 months thereafter. According to said submission, the petition is disposed of.
Seal number 27.
I will take notice. First time.
Access notice for respondents. Released in committee.
Next week, my lord.
Seal number 28.
Manjunath,
Take notice. Earlier, 2 occasions, my lord, the dishonorable court directed. My lord, now again, my lord, the petitioner has sought for conclusion of the my lord proceedings.
then what is the problem?
I think, my lord, it is already completed, my lord. Page number, your lordship may kindly see 42, my lord. If not concluded, my lord. We'll take notice, my lord.
AJ accepts notice for respondents. Relist. R6 here. So, Swati Ashok, to take notice for R6.
Seal number 29. BS Nagaraj.
Take
notice.
AJ accepts notice for respondents.
Seal number 30. Shri Anish Acharya. Line.
Your father's name was not in the records? When? And from 74, his name was not entered in the record. Why?
Subsequently, they
Children of the.
No, until your father's name is entered in the revenue records, your names can't come on record. And if your father did not seek for change of entries for 50 years, you can come and seek for change of entry. I'm not blaming you. If your father did not get these entries changed, how can you get the entries changed in your favor? Inheritance ಬರೋದು ನಿಮ್ ತಂದೆ ಇದ್ರೆ ನಿಮ್ಗೆ ಬರ್ಬೇಕಿರೋದು.
Subsequently, they have the petitioner is not paid civil to the children of the petitioner as paid civil to before the order of the judgment court. 2024 they are taking the declaration, but the petitioner has not paid any civil. Mainly see the page number 54 yours. 52 yours. Children of the petitioner as paid the civil to yours. There is no dispute regarding the sale deed executed by the petitioner.
Where is the sale deed?
It is not produced by the petitioner.
You have a copy of sale deed with you? ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ? Realist.
No, you are not. They have no right. Already they have executed. We are in possession.
I'm inclined to set aside this order only on the ground that for the past 50 years, your name was not entered in the revenue records. For the first time, the name is coming in your records. The name of Hangappa continues in the revenue records. Correct country, but 50 ವರ್ಷ ನೀವು. What is the order now of the deputy commissioner? AC records. ACL. DC dismiss the revision. Who's Ashwatappa?
Subsequent purchaser.
No, you filed an appeal against Tahsildar and Ashwatappa. Who's this Ashwatappa? From?
Father of the Ashwatappa purchased 20 guntas.
From whom?
From the Angappa.
And his name is entered in the revenue records.
Subsequently, Ashwatappa and his brothers have entered the partition deed. By way of partition deed, they have paid to obtain the revenue entries for that. That only they are Ashwatappa and including the application.
What is the sale deed of Ashwatappa's date?
Father of the.
So earlier to yours. So he got his name entered for 20 guntas.
He entered the revenue entries, but subsequently, Ashwatappa and his brothers have divided the shares for 10 guntas.
How are you related? Are you related to each other? But you had sold how much to him? All right. What is the sale deed that you claim to have executed? What does that say? 1 acre 37 guntas or?
The same petitioner executed the sale deed in favor of the father of respondent number 5 and 6.
Pursuant to the partition.
No. I executed sale.
No, you said Angappa and his brothers had entered a partition.
No, I don't have any knowledge regarding the Angappa and his brothers. But as per the government's of the petition, the Angappa and his brothers have divided their shares.
Yavaga. But what is the effect of the sale deed that the suit that your children have filed? What will be the effect of that suit? Now, what is the prayer in the suit? So until that prayer is granted. No. Until that prayer is granted, in whom does the title vest? Possession, you get a degree of injunction there. You are not the plaintiff there. Your children accept that title is with him. until that suit is decreed, that sale deed will stand. They admit the sale deed now. If you're seeking for cancellation of the sale deed or for declaration, that means the sale deed does exist. And you don't challenge that, your children challenge it. On the ground that you had executed because you were wayward behavior, etc., etc.
But Ashik kindly appreciate it. If the petitioner has not executed any deed, the petitioner has filed the civil suit. But the children of the petitioner has filed a civil suit. Kindly, that is page number 52. The same petitioner has produced the plain copy. Children of the petitioner has filed a civil suit. For declaration. Mailar of Anmokar, Chandra, with the petitioner here. No dispute regarding the sale deed executed by the petitioner. That is not filed in the
I have produced the before these we have united by that is the petitioner. I also got the
also another thing that's filed by the same petitioner coming in with the before the the proof for partition which is not produced by the plain copy from the petitioner.
Is there an entry order in the suit?
Eventually they have filed civil suit.
No.
And also another partition suit filed by the petitioner family. The plain copy has not produced the
connection team. I have I asked the AC correct the
No, I am only concerned with the prayer in the suit at page 58. Until this second prayer is granted to you, to declare the sale deed as null and void. Title is with him. I am not talking anything about possession. I am only talking about the revenue entry now. If you are in possession, continue in possession. Nobody is going to stop you. How can I grant you an interim order which your children have not got in the suit? Then you file a separate suit for inaction against them if you are in possession. You set up your children to file the suit. Now you are litigating on the revenue side. How could the revenue entries be in your name after the sale deed? The only point in your favor is it is for 50 years is standing in your name. Apart from that, that is what you will do. You have not challenged the sale deed. You are not the plaintiff. But your children admit the sale deed and say that declared as null and void. In this suit, are you placed ex parte? No, the revenue will be subject to the result of the suit, isn't it? Ultimately, suppose your children succeed, then the revenue entries will be taken away. How did this happen? I was revenue to change. Yes, ಬರುತ್ತಲ್ಲ ಅವರೇನು furnish ಮಾಡೋದು. ಸಂಬಂಧಿಕರಲ್ವಾ ನೀವು? You are not related. You are not related, both of you.
They are in possession. The intention-
What is there to show that you are in possession? ನಿಮ್ಮಲ್ಲೂ ವೀಕ್ನೆಸ್ ಇದೆ ಸುಮ್ಮನೆ. Can you find out as to why it was not done for 50 years? PG accepts notice. Respondents. ನೀವು ಕೇವಟ್ ಹಾಕಿದ್ದೀರಾ?
Yes, yes.
ಶ್ರೀ ಪ್ರಸನ್ನ ಕುಮಾರ್ TN standard 2 weeks time. File his objections. Granted you 2 weeks to file objections. But the petitioners on interim prayer. In my view, I am limited to the fact that the revenue entries are sort of mediated in favor of respondents 5 to 6 for the first time, nearly 50 years after the sale deed was executed in favor of their father. We appropriate to examine the matter. And until then, status quo regarding interest to be maintained. Released on. ಇದು ಒಂದೇ ಅಲ್ವೇನ್ರಿ ಹೇಳಿದ್ ನೀವು, ಇನ್ನೊಂದು ಅವ ಇದೆಯಾ?
Another partition by the petitioner. Not disclosed by the petitioner. They suppress the facts you are.
ಕೊಡಿ, ಯಾವ್ದಿದೆ ಕೊಡಿ ಅದು.
I will produce the date of hearing.
Next week ಅಂತ ಕೊಡಿ. Granted a week's time to file objections. Released on a date. He is the plaintiff for the defendant there.
Children of the petitioners by partition.
Apart from this, it was one more suit.
Yes, yes. Yes, you are.
Now, then I will hold that the entries will be made subject to the result of the suit. Until then, seal it. No, I am sure you will be placed ex parte. All this is a way of getting over that sale deed. Next week, you have relief for 1 week, that's all. R5 and R6 ಅಲ್ಲಿ. ನೀವು ಯಾರಿಗೆ ಅಪೀಲ್ ಆಗ್ತೀರಾ? ಶ್ರೀ President Kumar TN also accept notice for R7. I need to find out as to why.
Seal number 31, Sri Bunigangappa.
What are you challenging here?
Rajiv Gandhi Housing Corporation. On the farmer, bulldozers are going there. Kindly see these photographs.
What is the next reg? Utsala ಕೊಟ್ರು next reg. Utsala ಕೊಟ್ರು next reg.
3 kilometer ಒಳಗೆ ಇದೆ.
As on which date?
In the similar subject matter, this lordship shows the similar subject matter is considered for its court. Granted, same similar subject matter, the same server number, this lordship has granted directed to regularization committee to consider the case of the petition.
The committee has already taken a decision, my lord, rejected his claim, my lord, in the year 1996 itself.
This court has held, court and bench has held against. ಏನ್ ಮಾಡ್ತೀರಿ ನೀವು?
ಈ ಸುತ್ತು
Another judgments before this lordship.
Where is this 28/4/2011? 28/4/2011 order. I can't grant you relief because of this order. But our
Here, farmer, after lapse of 60 years, they are implemented the government scheme.
when did you make the application?
In 1998.
1991 itself, it is 11.5 kilometers.
Regularization.
C, B and C. My father was born in the year of 1996. And my petitioner is born in 1998. Next, C.
In Madakakala. This court has already taken a view. I can't take a different view.
Yes.
ಇಲ್ಲ ನೀವು ಅಪೀಲ್ ಹಾಕೊಂಡು ಈ ಆರ್ಡರ್ ಸ್ಯಾಟಿಸ್ಫೈಡ್ ಮಾಡಿಸ್ಕೊಡಿ ಅಷ್ಟೇ ಇನ್ನೇನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ. ಏನು the prayer in this petition is for issuance of a direction to direct respondents 2 and 3 to consider the application filed with the petition form number 50 dated 29/7/1991 and also form number 53 dated 2/12/1998 and issuing with the Sagole Chet. Today an application for amendment is filed seeking for quashing of the order passed with Tahsildar dated 28/4/2011. A copy of which is already produced in Annexure H. A perusal of Annexure H, which is sought to be challenged by way of an amendment, indicates that the applications in respect of 11 claimants was situated within 18 kilometers from the limits of the corporation, and therefore the claim of the petitioner for regulation cannot be considered. This order is sought to be challenged after nearly a period of 14 years. Be that as it may, and counsel for the respondent points out that this court bench of this court in WP 6578/2023 had considered similar matters and had in fact issued an interim direction on 26/9/2023 directing the Chief Commissioner BBMP to ascertain the distance of the land in regard to the limits of Bangalore Mahanagara Palike as on 29/7/1991. And on securing the report from the Chief Commissioner to the effect that the boundary of Mahanagara Palike as on 29/7/1991 was within 11.5 kilometers. This court dismissed the writ petitions. In my view, the case of the petitioner would also fall within the purview of a decision already rendered by the coordinate bench in as much as the application of the petitioner for regulation was made in 1991 and as already recorded in the aforementioned order. The distance from the boundary of BBMP was 11.15 kilometers, and therefore it is obvious that the claim of the petitioner for regularization cannot be considered, and it was rightly refused way back in the year 2011. That was the matter. I find no reason to entertain the petition. The petition is therefore dismissed. ನಾನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ, ನಿಮ್ಗೆ ಏನ್ ಮಾಡ್ಬೇಕು ಗೊತ್ತಿಲ್ಲ ನಾನು. ಅದು 23 ಆರ್ಡರ್ ಕಂಡ್ರೆ.
Seal number 32, Ajay Prabhu.
Why was it deleted? Same ಅದೇ.
This is Milad, I got the instructions from the department. Tahsildar also present before the court, Milad. Till Milad 2025 February, Milad, no point of time, Milad, there is no agriculture activities at all. Milad, including that, Milad, it was not granted at all. No, Milad, in the year, in the month of February, all of a sudden, Milad, the petitioner has started, my lord, cultivating activities, my lord, in the field.
Now, what is the procedure for declaring the land to be forfeited in your favor? Which section?
Allah, it is not forfeited. The
Then,
grant itself is not made.
then how was the name entered in the revenue
Lord,
record?
in the grant certificate, Lord, in the register of grant certificate, there is no, Lord, his name is not entered at all. Lord,
The RTC's name was not found?
not found. In the RTC, my lord, in the month of February, he filed an application for
What
a
is
certified
annexed-
copy of RTC.
Annexure C,
He
page
removed-
86.
Allah, he removed some of the RTCs, inserted, my lord, that is the, my lord, finding the instructions received from the Tassidar is also present. before the
86,
court.
87, he has produced an RTC.
Yes, my
Are you saying that this is a forged RTC?
yes, my lord. Yes, my lord. That's what I am saying. I received, my lord, the yes, my lord, in the month of, my lord, of January 2025, he filed an application for a certified copy of the RTCs. Lord, then only, my lord, he come to the, my lord, before this court.
You have the original register with you?
Not original, my lord. Where, my lord, is removed, that is also, my lord, finds, my lord, in the RTCs.
ನಿಮ್ಮ ಹೆಸರೇನು? You claim to be granted this land. And who was your name entered? What is the MR on the basis of which your name was entered? MR ಬರ್ದಿಲ್ವಲ್ಲ ಅದು ಯಾವ MR ಕೇಳಿ ಅಂತ? If there was a grant and if there was a durasti done. MR? Now this is. What is survey number? 3. ಅಲ್ಲ ಇದು annexure C is for the larger extent of 19 acres, correct? Correct. Now, if after the grant to several persons, how was the RTC reduced only to 4 acres in annexure D, annexure C1? How? Then it should have been at least 3 paiki, or there must have been a sub number. How can the extent change in survey number 3 from 19 acres to 4 acres? ಈ MR 1/8687 ಇದೆಯಾ?
Is fabricated. The original one is also available. Fabricated was inserted. MR is also available.
MR 1/8687 ಇದೆಯಾ?
ಇದೆ ಸ್ವಾಮಿ. This, in the month of September onwards, my lord, it was inserted. Earlier to the month of.
ಅವ್ರು ಎಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
Please.
MR ರಿಜಿಸ್ಟರ್ ಅಲ್ಲಿ MR 1/8687 ಅಂತ ಇದೆಯಾ?
ಅದು ಯಾವತ್ತೂ ಹಾಗೇ ಇಲ್ಲ ಅಂತಾರೆ. ಸೆಪ್ಟೆಂಬರ್ ಅಲ್ಲಿ ಮಾತ್ರ ಇನ್ಸರ್ಟ್ ಮಾಡಿದ್ದಾರೆ. Earlier to that, my lord, MR, it was one of 86 is not inserted. It is not introduced at all. There is no.
Then produce the mutation list extract of their 8687 and also the original RTC.
Please, I will produce.
I have my doubts regarding annexure C1. It cannot become 4 acres when the earlier RTC is for 19 acres. If they were to give you an RTC for 4 acres, they should have mentioned 3 paiki, 3/P or something like that. They cannot maintain 3. I have 2 extents in the RTC register. If that order is wrong, then everything else is. Get that
The
grant
agriculture
registration.
activities itself, my lord, in the month of. my lord.
Grant registral grant ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ನೀವು?
ಇಲ್ಲ ಮಾಡಿಲ್ಲ.
Produce a grant
ಅಲ್ಲ
registral
earlier
document.
earlier Tarikere taluk, my lord, in the
He is referring to,
subsequently, my lord.
he is referring to LND 210/85/86.
I will
Produce that file also.
Please.
If there's a grant register for this particular village, produce it so that we will know.
Yes, please.
List.
24th. 24th, sir, please. Seal number 33, Shri Muniappa.
Part of the Karnataka, the assessment commissioner has been separate. And cost and the operation operation will not. Mysore to Karnataka, the government is also local and they are 175 of the ವಿಕೀಕರಣ ಮಾಡುವುದು ರಾಷ್ಟ್ರೀಯ ಮೈಸೂರು ತಾಲೂಕಾ ಆ 1275 22 ಇವಾಗ 17 ವರ್ಷ 21 ವರ್ಷ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಅದನ್ನು ಅನುಸರಿಸಿ ಪ್ರಾಧಿಕಾರವು ಎಲ್ಲಿಯಾಗಲಿ ಪರಿಹಾರ ಕಾರ್ಯ ನಿರ್ಣಯಿಸುವ ಮುಂದಾಗಿ ಈ ರಿವಿಷನ್ ಸಮಕ್ಷಮ ಪ್ರಾಧಿಕಾರ ಸಂಬಂಧಿಸಿ ಅವರಿಗೆ ಅಗತ್ಯವಿರುವ ನಿರ್ದಿಷ್ಟ ಪರಿಹಾರವನ್ನು ಕೊಡಿಸಿಕೊಳ್ಳುತ್ತದೆ. Directing the owner to discuss the amount of the immediate.
What was the original order with Tahsildar? Where is the order with Tahsildar?
Tahsildar order. That he has directed.
No.
The AC was 2012, there was a petition made that has been directed by the AC to examine the documents and pass an
No,
order.
what was the order that you challenged before the AC? Which was the mutation restriction that you challenged in the, before the AC?
AC, for the AC, I made an application that immediate, it can be not considered as.
Now, please come to page 41. First paragraph. ನಿಮ್ದೇ ಅಲ್ವಾ ಅದು? ನಿಮ್ದೇ ತಾನೆ 120, 128. Keshamurthy. Your respondent number? First respondent. Please read the first paragraph. Mysore Taluk Kasaba.
ನಾಲ್ಕು ಎಕರೆ ಮೇಲ್ಮನವಿದಾರರಾದ ಕರಿಯಾಗಿ ಕೃಷ್ಣಯ್ಯ ಕೆಂಪನಕರಿಗೆ ಅವರಿಗೆ ಸೇರಿದ ಗೊತ್ತಾಗಿರುತ್ತದೆ. ಮೇಲ್ಮನವಿದಾರರ ತಾತ ಕೆಂಪಾವಿ ಕರಿಯ ಅವರು ಮುದ್ದರಾದ ನಂತರ ಮೇಲ್ಮನವಿದಾರರ ಕಾಪಿ ಆಗಿರುತ್ತದೆ. ಮೈಸೂರು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರವು 9/6/92 ತಮ್ಮ ಕಚೇರಿಯ ಜ್ಞಾಪಕಕ್ಕೆ 755ರಲ್ಲಿ 4 ಎಕರೆ 36 ಎಕರೆ ಪೈಕಿ 2 ಎಕರೆ 18 ಎಕರೆ ಜಮೀನಿಗೆ ಪರಸ್ಪರ ಒಪ್ಪಂದ ಮೂಲಕ ಶಿವಚಿಕ್ಕಯ್ಯ ಅವರಿಗೆ ಅಂತಿಮ ಮಾಪನಕ್ಕೆ ಕೆಲಸಕ್ಕೆ ಹಣವನ್ನು ನೀಡಿರುತ್ತಾನೆ ಹಾಗೂ 2 ನಿವೇಶನಗಳನ್ನು ಮಂಜೂರಾತಿ ಮಾಡಿರುತ್ತಾನೆ. ಉಳಿದ 2 ಎಕರೆ 18 ಮಾಡಿದ್ದಾರೆ. ತಂದೆ ಶಿವಚಿಕ್ಕಯ್ಯ ಈ ರೀತಿ ಇರುವಾಗ 1ನೇ ಅಧಿಕಾರ ತಂದೆ ಪಟ್ಟಯ್ಯನವರು 150 ಸ್ವಾಧೀನದಲ್ಲಿರುವುದಾಗಿ ಇದಕ್ಕೆ 3ನೇ ಅಧಿಕಾರ ರಾಘಯ್ಯ ಅವರ ಕುಟುಂಬದ ತೊಂದರೆ ನೀಡುತ್ತಿರುತ್ತಾರೆಂದು ಅವರ ವಿರುದ್ಧ 1ನೇ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ 1928 ಪ್ರತಿವಾದಿಗಳ ವಿರುದ್ಧ ತಡೆಯಾಜ್ಞೆ ಕೋರಿ ದಾವೆ ಸಲ್ಲಿಸುತ್ತಾರೆ. ಆದರೆ ಸರ್ವೆ ನಂಬರ್ 157ರಲ್ಲಿ ಮೂಲ ಮಾಲೀಕರಾದ ಯುವತಿಯ ಮತ್ತು ಸ್ವಾಧೀನಪಡಿಸಿಕೊಂಡ ಪಕ್ಷಗಾರರನ್ನು ಮಾಡದೇ ಇರುವುದರಿಂದ ಸದರಿ ಶಾಸನ ತಡೆಯಾಜ್ಞೆ ದಾವೆಯನ್ನು ಘೋಷಣಾತ್ಮಕ ದಾವೆಯಾಗಿರುವುದು ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿ ಪ್ರಕರಣವನ್ನು ಹಿಂಪಡೆದಿರುತ್ತಾರೆ. ತಾರೀಖು ದಿನಾಂಕ 15/6/2007 ಮಾನ್ಯ ಕರೆ ನ್ಯಾಯಾಲಯ 500 ರುಗಳ ದಂಡವನ್ನು ವಿಧಿಸಿ ಕೋದಂಡಯ್ಯನವರ ಹೊಸ ದಾವೆಯನ್ನು ದಂಡ ಪಾವತಿಸಿದ 15 ದಿನಗಳವರೆಗೆ ನಂತರ ದಾವೆಯನ್ನು ಹೊರಗುವುದೆಂದು ಆದೇಶಿಸುತ್ತಾರೆ. ಕೋದಂಡಯ್ಯ 1ನೇ ತಂದೆ ಅವರ ಮಕ್ಕಳು ಮೇಲ್ಮನವಿ ತಂದೆ ಶಿವಚಿಕ್ಕಯ್ಯ ಮತ್ತು ಅವರ ತಂದೆ ಕೆಂಪಯ್ಯ ಅವರನ್ನು ಮಾನ್ಯ 1ನೇ ನ್ಯಾಯಾಧೀಶರ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಅಸಲು ದಾವೆ ಸಂಖ್ಯೆ 899/2005ರಂತೆ ಪ್ರತಿವಾದಿಗಳ ವಿರುದ್ಧ ಸರ್ವೆ ನಂಬರ್ 155ರಲ್ಲಿ 4 ಎಕರೆ 36 ಗುಂಟೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ತಾವೇ ಮಾಲೀಕರೆಂದು ಸದರಿ ಘೋಷಣೆ ಮಾಡುವಂತೆ ನಕ್ಸಲರಿಗೆ ಎದುರಾದ ತೊಂದರೆ ನೀಡಿದಂತೆ ಶಾಸನದ ತಡೆಯಾಜ್ಞೆ ಕೋರಿ ಅಸಲು ದಾವೆ ಸಲ್ಲಿಸುತ್ತಾರೆ. ವಿಚಾರಣೆ ನಡೆಸಿದ ಘನ ನ್ಯಾಯಾಲಯ ದಿನಾಂಕ 29/2/2020 ಬಾಲಿ ಸಲ್ಲಿಸಲಾದ ಮೌಲ್ಯೀಕರಣ ಪಟ್ಟಿಯ ಸದರಿ ಸ್ವತ್ತಿನ ನಿಜವಾದ ಮೌಲ್ಯೀಕರಣ ಮಾಡಿರುವುದಿಲ್ಲ ಹಾಗೂ ಸದರಿ ಸ್ವತ್ತಿನ ಮೌಲ್ಯವು 30 ಲಕ್ಷಕ್ಕಿಂತ ಹೆಚ್ಚಿರುವ ಕಾರಣ ಘನ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಮೌಲ್ಯ ಅಧಿಕಾರ.
So your father filed a suit for a declaration that was not granted.
That is the sixth response.
Same land, isn't it? So the Kata was in the name of Shiv Chikkaya.
My grandfather was the Kata that I have produced.
No. The
In the year 2021.
This is for 136. The name of the appellant's father, Shiv Chikkaya, was in the revenue records. You filed a civil suit for a declaration that you have not got a decree.
No, they not because the.
For over that land, you have not got a decree.
No.
Admittedly, the Kata stands in the name of the Shiv Chikkaya. Then what is your right over this land?
The grandfather is, they claim that they have purchased the land in the year 1935. Till today, they have not produced any sale.
There are two mutation registers in their favor. One is of the year 82-83. 82-83 and 84-85. That you have not challenged.
That has been, before the case, that has been,
No. 82-83, 84-85, you have not challenged.
that is where the Mahindra that must an order to enter the name of this,
On what basis?
on the basis of the Karta by the grandfather.
Oh.
And moreover.
No, is it your case that MR 7/82-83 and 7?
They say that they have purchased the land in the year 1935.
No, I'm not on that.
1935. They are producing the reputation before this court.
No.
And please, Raina, they are not producing revenue before, what is their right? What is their right, Raina? Nothing.
No, my doubt is, for the first time in IHR 7/82-83 and 7/84-85, the Kata was changed the name of the Shiv Chikkaya. That entry was never challenged by you.
That is.
So, if you have not challenged that entry at all, now to come and say, and especially after the suit is dismissed, to say that your name should be entered, on what basis do you do that?
They have filed, they say before this court, that they have purchased the suit property from one Channa Bovi, who is the grandfather. It is an impersonation. My grandfather name is Channa Bovi. They have purchased from Channa Bovi. That has been not produced anywhere before the authority. Now they are produced before the honorable court, before the honorable court first time. And that way the annexation 3 has been passed by the Buddha in favor of that has been challenged and that has been taken. Now they are produced the thing, I mean, in the disposition number by lot, where my the annexure D has been paid, which has been passed by the board of inquiry.
What is annexure D?
Annexure D by lot paid. Annexure G, page 35.
I still don't seem to understand as to what is your right. You don't claim under title deed. You admit that when you file the appeal before the AC, the Kata was standing in the name of his grandfather. After his grandfather died, to stand in the name of his father and continue from 80 to 83. Your suit is dismissed under this land. How can you have any claim over this land?
No, by lot. What is their right by lot? That-
The Nevo-
Their right that, both the Kata, they are not in their supply.
But you have not challenged that order.
That is
it-
what the invitation has been changed.
No, no.
Tasita.
No. You will not challenge that order at all. That has become final. 80 to 83 has become final.
82, 83 order that now, in 2000, the Tasita has passed an order to enter the name of the grandfather of this.
That is why the DC was right in saying that if you have not challenged these entries, how can you for the first time come and say my name should be entered? ಅವ್ರ ತಾತನ ಹೆಸಲಿತ್ತು, ಅವ್ರ ಅಪ್ಪನ ಹೆಸಲಿತ್ತು. ಈಗ ಸಡನ್ ನಿಮ್ಮ ಹೆಸರು ಸೇರಿಸಬೇಕು ಅಂತಂದ್ರೆ ಯಾವ ಆಧಾರದ ಮೇಲೆ ಮಾಡಬೇಕು? ಸರಿ, ಬಟ್ ನಾನು RT 136 ಅಷ್ಟೇ, ನಾನು ಮೂಡಾಗ ಹೋಗ್ತಾ ಇಲ್ಲ. 136 ಕೇಳಿ ನಾನು ವಾಟ್ ಇಸ್ ಐ ಕ್ಯಾನ್ ಡು. I am not inclined to accept your. You have failed with the civil court.
So that is only, it has not passed on merit.
Ultimately, suit is dismissed
So it is-
by the fact that
It not comes with the jurisdiction of the,
you first filed a suit for injunction. Then withdrew. You withdrew the suit with liberty to file a fresh suit, suit for declaration. You file a suit before an incompetent court. That court rejects your plaint on the ground it has no jurisdiction. Appeal filed by you is dismissed. Therefore, your claim for a declaration is not granted by any court. How can the entry be in your name? DC is right.
the- what is their right by law? They
ಅವ್ರದ್ದು
say
ಬೇಡಿ,
that-
ನೀವ್ ತಾನೇ ಕ್ಲೈಮ್ ಮಾಡ್ತಿರೋದು.
No, they are,
ಅವ್ರ ಹೆಸರು ಕಿತ್ತಾಕ್ಬಿಟ್ಟು ನಿಮ್ಮ ಹೆಸರು ಹಾಕು ಅಂತ ಹೇಳ್ತಿದ್ದೀರಾ.
they say that they are purchased in the year 1955. The sale is not yet, they are produced the restitution by law, first time. They are not produced before the, it is a draft of document, all that it is not, executed by grandfather, we Channa, Bangle, Channa Bori, it is a Channa Bori as executed. But as first time they are produced in the year 2024 before the report.
I am not inclined.
Let them be, not before. Let, these two should be tied together because the involvement of money, the involvement of the right, which is annexure 3 by law, where I have produced the income rest by law from 99 years income rest. No transaction has taken.
Your name was not in the revenue records from 1955.
This
Then how can your name be entered now? On what basis do you enter your name? Either registered instrument or a declaratory decree.
No,
You have neither of them.
Income rest by law.
On what basis do I accept your claim that your name should be there? On the basis that you are the Karta and the civil suit? ಹೆಂಗಾಗತ್ ಮುನಿಯಪ್ಪನವ್ರೆ, ಆಗಲ್ಲ.
Because the other two, the other requisition is also pending. Annexure.
No,
annexure H by law.
other writ petition is not in relation to 136.
No, that is not annexure, out of annexure H. Of the same. And they have directed to Mula.
ಅವ್ರದೇನ್
Disperse the amount.
ನಿಮ್ಮ ಅಮೌಂಟ್ ನಿಮ್ಮ ಹೆಸರು ಹೇಳಿ ಸಾಕು, ಖಾತಾ ಮಾತ್ರ ಹೇಳಿ, ಮಿಕ್ಕಿದೆಲ್ಲ ತಲೆ ಕೆಡಿಸ್ಕೊಬಿಡಿ. ನಿಮ್ಮ ಹೆಸರು ಖಾತೆಲಿ ಹಿಂಗೆ on what basis?
Whether the second respondent has got such a duty, without authority of law, he directly would have to disperse the amount. Is it an order by sustainable order by?
If you had a right, then I could say that that order is bad. If you have no right, how are you concerned about this land at all?
My grandfather was doing that.
The civil court should say that. I don't think.
Annexure B, my lord.
Yes.
A. 23, 24, 25.
Read from page 20, no, DCN ಹೇಳ್ತಾರೆ. From page 20. Paragraph 15.
ವಿಶ್ಲೇಷಣೆ ಉಭಯ ಪಕ್ಷಕಾರರು ಮಂಡಿಸಿದ ವಾದವನ್ನು ಹಾಜರುಪಡಿಸಿದ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿದೆ. ಪ್ರಕರಣದ ತಪ್ಪಿನಲ್ಲಿ ಒಟ್ಟು 4.36 ಎಕರೆ ವಿಸ್ತೀರ್ಣ ಜಮೀನಿದ್ದು ಒಟ್ಟಿನಲ್ಲಿ ಪ್ರಾಧಿಕಾರವು 2 ಎಕರೆ 2.18 ಎಕರೆ ಸ್ವತ್ತನ್ನು ಪರಸ್ಪರ ಒಪ್ಪಂದದ ಮೇರೆಗೆ ಭೂ ಸ್ವಾಧೀನಪಡಿಸಿಕೊಂಡು ಶಿವಚಕ್ರಯ್ಯ ಅವರಿಗೆ ಪರಿಹಾರವನ್ನು ಮತ್ತು ಪ್ರೋತ್ಸಾಹಿಕ ನಿವೇಶನವನ್ನು ನೀಡಿರುವುದನ್ನು ಉಭಯ ಪಕ್ಷಕಾರರು ಒಪ್ಪಿಕೊಂಡಿರುತ್ತಾರೆ. ಈ ನಂತರ ಉಳಿಕೆ 2 ಎಕರೆ 2.18 ಎಕರೆ ಮತ್ತು ಶಿವಚಕ್ರಯ್ಯ ಕರಿಯ ಕೆಂಪಾರವರ ಹೆಸರಿನಲ್ಲಿ ಆರ್ಟಿಸಿ ಮುಂದುವರಿಯುತ್ತದೆ. ಮೈಸೂರು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರವು 2.18 ಎಕರೆ ಸ್ವತ್ತಿಗೆ ಪೈಕಿ 1 ಎಕರೆ 37 ಗುಂಟೆ ಸ್ವತ್ತನ್ನು ಸ್ವಾಧೀನಪಡಿಸಿಕೊಳ್ಳದೆ ಉಪಯೋಗಿಸಿಕೊಂಡಿರುವುದನ್ನು ಸಹ ಉಭಯ ಪಕ್ಷಕಾರರು ಒಪ್ಪಿಕೊಂಡಿರುತ್ತಾರೆ. ಪ್ರಸ್ತುತ ಪ್ರಕರಣದಲ್ಲಿ ಮೈಸೂರು ತಾಲೂಕು ತಹಸೀಲ್ದಾರ್ ಸಂಖ್ಯೆ RTI 12/75/22/23 ದಿನಾಂಕ 17/10/23 ಹೊರಡಿಸಿರುವ ಆದೇಶವು ಪ್ರಕರಣದ ವಿವಾದಕ್ಕೆ ಬಿಂದುವಾಗಿದ್ದು ತಹಸೀಲ್ದಾರರ ಮೂಲಕ ಆದೇಶ ಪರಿಶೀಲಿಸಿದೆ. ಕೋದಂಡಯ್ಯರವರು 19/1/23 ತಹಸೀಲ್ದಾರರಿಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿ ಉಪವಿಭಾಗಾಧಿಕಾರಿ ಮೈಸೂರು ಅವರ ನ್ಯಾಯಾಲಯ ಸಂಖ್ಯೆ RTC 2020 ಆದೇಶ ಹೊರಡಿಸಲು ಕೋರಿದ ಮೇರೆಗೆ ತಹಸೀಲ್ದಾರರು ಪ್ರಕರಣವನ್ನು ವಿಚಾರಣೆಗೆ ತೆಗೆದುಕೊಂಡಿದ್ದಾರೆ. ಉಪವಿಭಾಗಾಧಿಕಾರಿ ಮೈಸೂರವರು RTC 75/2010 ದಿನಾಂಕ 27/8/2002 ಆದೇಶದ ಪ್ರಕಾರವಾಗಿ ಈಗಾಗಲೇ ಮೈಸೂರು ತಾಲೂಕು ತಹಸೀಲ್ದಾರರು ಸಂಖ್ಯೆ RTC 86/2010 ದಿನಾಂಕ 31/7/2017 ಆದೇಶ ಹೊರಡಿಸಿದ್ದು ಅದರಲ್ಲಿ ರಿವಿಷನ್ ತಪ್ಪಿದ್ದಾರ ಹೆಸರು RTCಯಲ್ಲಿ ಮುಂದುವರಿಸುವ ಅಭಿಪ್ರಾಯ. ಈಗಾಗಲೇ ಪ್ರಾಧಿಕಾರವು ಸ್ವಾಧೀನಪಡಿಸಿಕೊಂಡಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಪ್ರಾಧಿಕಾರದಿಂದ ಸ್ಪಷ್ಟ ಅಭಿಪ್ರಾಯ ಪಡೆದು ಪ್ರಾಧಿಕಾರದ ಹೆಸರಿಗೆ ಖಾತೆ ದಾಖಲಿಸಲು ಆದೇಶಿಸಿರುತ್ತಾರೆ. ತಹಸೀಲ್ದಾರರು ದಿನಾಂಕ 31/7/2015 ಉಪವಿಭಾಗಾಧಿಕಾರಿ ಮೈಸೂರವರ ದಿನಾಂಕ 27/7/2012 ಆದೇಶವನ್ನು ಪುನರ್ ಪರಿಶೀಲಿಸಿ ಆದೇಶ ಮಾಡಿದ್ದರೂ ಮತ್ತೆ ತಹಸೀಲ್ದಾರರವರು ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳ ದಿನಾಂಕ 27/8/2012 ಆದೇಶವನ್ನು ವಿಚಾರಣೆ ನಡೆಸಿ ಸಂಖ್ಯೆ RTC 17/25/82/23 ದಿನಾಂಕ 17/10/73 ಆದೇಶಿರುತ್ತಾರೆ. ಒಮ್ಮೆ ಆದೇಶವಾದ ಮತ್ತೆ ಅದೇ ಪ್ರಾಧಿಕಾರವು ಆದೇಶ ಹೊರಡಿಸಲು ಕಾನೂನಿನಲ್ಲಿ ಅವಕಾಶವಿಲ್ಲದಿದ್ದರೂ ತಹಸೀಲ್ದಾರರ ವ್ಯಾಪ್ತಿ ಮೀರಿ ಆದೇಶಿರುವುದನ್ನು ಅದಲ್ಲದೆ ದಿನಾಂಕ 17/10/2023 ಈ ಆದೇಶದಲ್ಲಿ 1ನೇ ತಹಸೀಲ್ದಾರರು ಶಿವಚಿಕ್ಕಯ್ಯ ದಿನಾಂಕ 8/8/2016 ಮೃತರಾಗಿದ್ದರು ಅವರ ಪ್ರಕರಣದಲ್ಲಿ ಪಕ್ಷಗಾರರನ್ನಾಗಿ ತೆಗೆದು ಆದೇಶಿರುವುದು ನೇಮ ಮಾಡಿರಲಾಗಿದೆ. ತಹಸೀಲ್ದಾರರವರಿಗೆ ಅಧಿಕಾರ ಅಗತ್ಯವಿಲ್ಲದಿದ್ದರೂ ಅವರ ವ್ಯಾಪ್ತಿ ಮೀರಿ ಆದೇಶಿರುವುದರಿಂದ ಪ್ರಾಥಮಿಕವಾಗಿ ತಹಸೀಲ್ದಾರ್ ಅವರ ದಿನಾಂಕ 17/10/23 ಆದೇಶ ವಜಾವಾಗಿದೆ. ತಹಸೀಲ್ದಾರ್ ಅವರ ಆದೇಶದ ಮೇರೆಗೆ ಮೈಸೂರು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರವು ಭೂಸ್ವಾಧೀನ ಮಾಡಿಕೊಳ್ಳದೆ ಉಪಯೋಗಿಸಿರುವ 1 ಎಕರೆ 37 ಗುಂಟೆ 37 ಸೊತ್ತಿಗೆ ದಿನಾಂಕ 21/10/23 ಭೂ ಮಾಲೀಕರ ಪಕ್ಕ ಕೌಟಿ ವಾಸುದಾರರೆಂದು ನೀಡಿರುವ ಪ್ರಮಾಣ ಪತ್ರದ ಆಧಾರದ ಮೇಲೆ ಕೆ. ಚಂದ್ರಯ್ಯನವರಿಗೆ ಪರಿಹಾರ ನಿವೇಶನವನ್ನು ನೀಡಲು ಆದೇಶಿಸುತ್ತಾರೆ. ಪ್ರಾಧಿಕಾರವು ನಿವೇಶನಗಳು ನೀಡಿದ್ದನ್ನು ಡಿವಿಷನ್ ಅರ್ಜಿದಾರರು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸಂಖ್ಯೆ 23/24 ಮಾನ್ಯ ನ್ಯಾಯಾಲಯವು ದಿನಾಂಕ 25/8/2024 ಹೊರಡಿಸಿರುವ ಮಧ್ಯಂತರ ಆದೇಶದಲ್ಲಿ 3ನೇ ವ್ಯಕ್ತಿ ಹಕ್ಕುಸ್ವಾಮ್ಯವಾಗಿ ಆದೇಶ ನೀಡಿರುವುದನ್ನು ಗಮನಿಸಿದೆ. ಪಟ್ಟಣದಲ್ಲಿ ತಹಸೀಲ್ದಾರ್ ಅವರು RRT 86/2019 ದಿನಾಂಕ 31/7/2015 ಉಪವಿಭಾಗಾಧಿಕಾರಿ ವೈದ್ಯರವರ ಸಂಖ್ಯೆ RRT 75/2011 ದಿನಾಂಕ 27/8/2012 ಆದೇಶ ಮಾಡಿದ್ದರು. ಮತ್ತೆ ತಹಸೀಲ್ದಾರ್ ಅವರು ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳ ದಿನಾಂಕ 27/8/2012 ಆದೇಶವನ್ನು ಉಲ್ಲೇಖಿಸಿ ವಿಚಾರಣೆ ನಡೆಸಿ ಸಂಖ್ಯೆ RRT 12/75/22/23 ದಿನಾಂಕ 7/10/23 ನಿಯಮಬಾಹಿರವಾಗಿ ಉತ್ತರ ವಿರುದ್ಧವಾಗಿ ಆದೇಶಿಸಿರುವುದು ಕಾನೂನಿಗೆ ವಿರುದ್ಧವಾಗಿರುವ ಆದೇಶವು ವಜಾವಾಗಿದೆ. ಪಟ್ಟಣದ ಒಟ್ಟು ಪೈಕಿ 2 ಎಕರೆ 15 ಒಪ್ಪಂದದ ಮೂಲಕ ಪ್ರಾಧಿಕಾರವು ಉಪಯೋಗಿಸಿಕೊಂಡಿರುವ ಬಾಬತ್ತು ಅದನ್ನು RTCಯಲ್ಲಿ ಉಲ್ಲೇಖಿಸಲು ಮತ್ತು ಬಳಕೆ 2.18 ಎಕರೆ ಸ್ವತ್ತಿನ ಪೈಕಿ 1.37 ಎಕರೆ ಸ್ವತ್ತನ್ನು ಮೈಸೂರು ಪ್ರಾಧಿಕಾರವು ಉಪಯೋಗಿಸಿಕೊಂಡಿರುವುದರಿಂದ ಉಪವಿಭಾಗಾಧಿಕಾರಿ ಮೈಸೂರವರು ಅಭಿಪ್ರಾಯಿಸಿದ ರೀತಿಯ ಭೂ ದಾಖಲೆಗಳಲ್ಲಿ ಮೈಸೂರು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ ನಮೂದಿಸಲು ಹಾಗೂ ಉಳಿಕೆ 21 ಗುಂಟೆ ಸ್ವತ್ತಿನಲ್ಲಿ ರೆವಿನ್ಯೂ ಬಡಾವಣೆಯನ್ನು ನಮೂದಿಸಲು ತಹಸೀಲ್ದಾರ್ ಮೈಸೂರವರಿಗೆ ನಿರ್ದೇಶಿಸಲು ಕ್ರಮಬದ್ಧವಾಗಿದ್ದು ಸದರಿ ಆದೇಶದಲ್ಲಿ ಹಸ್ತಕ್ಷೇಪ ಮಾಡಲು ಸಕಾರಣ ಇರುವುದಿಲ್ಲ. ಮೈಸೂರು ಪ್ರಾಧಿಕಾರ ಕಾನೂನಿಗೆ ವಿರುದ್ಧವಾಗಿ ಲೋಪದೋಷದಿಂದ ಮೂಡಿದ ವ್ಯಕ್ತಿ RRT 12/75/23 ದಿನಾಂಕ 17/10/23 ಹೊರಡಿಸಿರುವ ಆದೇಶವನ್ನು ರದ್ದುಗೊಳಿಸಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಅದನ್ನು ಅನುಸರಿಸಿ ಸರ್ಕಾರವು ಈಗಾಗಲೇ ಪರಿಹಾರ ನಿರ್ಣಯಿಸುವುದರ ತ್ವರಿತವಾಗಿ ಡಿವಿಷನ್ ಅರ್ಜಿದಾರರು ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರ ಸಂಪರ್ಕಿಸಿ ಅದಕ್ಕೆ ಅಗತ್ಯವಿರುವ ನಿರ್ದಿಷ್ಟ ಪರಿಹಾರವನ್ನು ಪಡೆದುಕೊಳ್ಳಬಹುದಾಗಿದೆ. ಈ ಅಂಶವನ್ನು ಅವಲೋಕಿಸಿ ಈ ಕೆಳಗೆ ಆದೇಶಿಸಿದೆ.
You got your name entered on the basis of an affidavit in respect of this 1 acre 37 guntas which have been utilized by Muda without acquiring it. Was your father's name in the RTC?
So my grandfather's name was in that.
Who has to establish that he was your grandfather and your can that be decided by the Tahsildar? And how can he pass an order on 17/10/2023? How can he pass an order on 17/10/2023 without you challenging the original order? 82-83 order you have not challenged, 84-85 order you have not challenged. You wake up in the year 2023, silently go get an order from the Tahsildar to enter your name as the legal heir. ಅವ್ರದ್ದು ಬಿಟ್ಬಿಡಿ, ಅವ್ರ ಹೆಸರು ರೈಟ್ or wrong ಅವ್ರ ಹೆಸರು ಖಾತಲ್ಲಿ ಇತ್ತು. ನಿಮ್ಮ ಹೆಸರು ನಿಮ್ಮ ತಂದೆ ಹೆಸರು ಯಾವತ್ತೂ ಖಾತಲ್ಲಿ ಇರ್ಲಿಲ್ಲ. ನಿಮ್ದು ಇರ್ಲಿಲ್ವಲ್ಲ, ನಿಮ್ದು ಹೇಳಿ. How can you get this order entered in your favor? On the basis of an affidavit, your name is entered in an inheritance proceedings. For you to get an order under inheritance proceedings, the khata should have been the name of your father or your. ನೀವು ಕರ್ದಲ್ಲಿ ಇರೋದಲ್ಲ, we are only concerned with RTC. In the RTC ಇಲ್ಲ Where is the order of the Tahsildar dated 17/10/23? Where is the order of the Tahsildar dated 17/10/23? Please come to page 33. Adesha. ಓದಿ.
ದಾಖಲೆಗಳನ್ನು ನವೀಕರಿಸುವ ಹಾಗೂ ಮಾನ್ಯ ಉಪವಿಭಾಗಾಧಿಕಾರಿ ಅವರ ನ್ಯಾಯಾಲಯದ ಪ್ರಕರಣಕ್ಕೆ ಹಾಗಾಗಿ 75/2019 ದಿನಾಂಕ 27/8/2012 ಕ್ರಮ ವಹಿಸಲು ಪರಿಶೀಲಿಸಿದೆ. ಮೇಲಿನ ವಿಶ್ಲೇಷಣೆ ಅಂಶಗಳನ್ನು ಅನುಸರಿಸಿ ವ್ಯಾಪಾರದಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 155 ಆರ್ಥಿಕ ಕಾಲಂನಲ್ಲಿ 9ರಲ್ಲಿ 2 ಎಕರೆ ಅಧಿವೇಶನೆಗೆ ಮೈಸೂರು ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಭೂಸ್ವಾಧೀನ ಕಾಲಂ 10ರಲ್ಲಿ ಭೂಸ್ವಾಧೀನ ದಾಖಲಿಸಲು ಹಾಗೂ ಉಳಿಕೆ 2 ಎಕರೆ 18 ಕಾಲಂ 9ರಲ್ಲಿ ಹಿರಿಯ ಗೋವಿ ಪಿ ಮಹಿಳ ಕನ್ನಾ ಗೋವಿ ಎಂದು ಹಾಗೂ ಕಾಲಂ 10ರಲ್ಲಿ ದಾಖಲಿಸಲು ಆದೇಶಿಸಿದೆ.
On what basis does he include Giri above his name? After how many years? Civil court going in. Reserved. Reserved.
They have not produced that. Now they are producing before the report. But it is not produced before any authority. Can they have
For orders,
Madam,
seal number 34. Shri Manmohan PN.
I thought I had got rid of this problem. Why is this again coming back?
What is the final opinion? Also what is the other?
What is the error?
Here it's a one-man committee for report, or the director that would be provided whatever procurement there are to the one-man. You can be brought, accepting a one-man committee report, but as related to the amount of violation.
This was an order more or less by consent,
Consent.
and you're seeking for review of this.
Before the first court, the submission was made that he was not instructed. Lawyer was not instructed.
You make a submission, I accept the submissions. You want it to be an order of the court, I make it an order of the court. Now you're saying that, no, I'm aware, I'm aware. Heard, no grounds, review rejected.
Seal number 35. Seal number 36. Shri Narayan Swami.
I'll tell you, the exact submissions were that let it be an order of the court. We are in agreement with that committee report and we will accept that committee report. we want a judicial order. And I pass an order because of the statement by senior counsel. Now that if you say,
This condition
I-
is accepted, entire selection of my lord are required to be set aside.
But I have nothing to say except that my lord, it
no,
will,
I'm also at a loss because I accept the words of senior counsel, and if I'll review there afterwards.
the institution feels not, but government of India also, my lord, has said that not, I have to follow the statute. Very well, I'll leave it.
Seal number 36.
Other applications. Petitioner is 1 week time, 36. Week's time is going to the process, pay the process. If the same is not paid, the petition shall stand dismissed. Much.
Seal number 37. Timothy Jivia came.
Await service, I guess. R7 is yet to be served.
R7,
Proposed R7 is yet to be served, await service of notice and
how many LRs are there?
the other LRs are already on record. There was a memo filed and that was allowed. And in respect of one other LR, this application is filed. Notice was ordered, it's not yet.
No, if
served.
R7, some of the LRs are already on record.
7A
Hold
is
that.
the daughter, my lord, she's not been made party, so I've made a separate application in her.
Who is R7?
The notice, R7 my lord, is
What is the matter about? You're in landlord or tenant? Where is the order of? Which is the order that you're challenging?
please.
Page 97.
Please, page 95.
R7 is the daughter of Panchakshaya.
Please. R7 is the wife. R7A is the daughter.
Already there, isn't it?
Allah, the sons are on record, my lord. The daughter is not yet made party.
No, so long as the estate of Panchakshaya is adequately represented, not all the LRs are required to
No,
come on
it's,
record.
I believe there's some dispute between the family members, my lord.
No,
There was,
if
it's a
ultimately
matter-
the orders will pass in favor of Panchakshaya,
please,
that can you to everybody's benefit.
please,
So then what difference does it make?
please. The notice was already ordered, which is why, my lord, the service of notice is not yet complete.
This 2000 weeks time is granted for. Comply with the laws. What is IA 1/24?
The same application, my lord, for bringing LRs on record.
Notice of-
R7A. It is on that IA, the notice was ordered.
The office objection. What is the office objection there?
Believe it is on delay, my lord, but since the parties are already on record, there is no abatement and therefore there's no delay. That office objection may be overruled.
If the LRs are already there, then where is the question of filing an application?
No, the other LRs are there, my lord. One LR has been left out. To avoid any other further litigation, my lord, later on, if the daughter comes and files, my lord, it might be an issue. Therefore, she's also been made
Yes.
party.
No, the objection was that you should file an application to set aside the abatement and also to,
No, there was also a separate memo filed, my lord, to treat them as. There is no abatement, lord, in respect of the other LRs on record.
post after service of notice. Mr.
Lord, date may be fixed, my lord. It's going, my lord, from now. The
Please,
date
my
may
lord,
be
the date may be fixed.
You
Yes.
get them served.
I saw, I'll, Lord, help, Lord, in serving, Lord.
Petitioner is permitted to take out notice on R7A personally. And if possible through courier.
Oblige.
Seal number 38.
Grateful.
Ramesh KR.
My lord, kindly pass over.
Serve a copy on them.
Yes.
Copy ಕೊಟ್ಟಿಲ್ಲ ಮೇಡಮ್ Learned AG submits that she has received the copies for the reputation. Hence filing of encroachment would be unnecessary. In matter. Ready na yan?
Password, my lord.
We list. Great, good. We group that, great.
39, is Satish Babu M.
Lord, I appear for the respondent number 5. Also, can you look into the previous order? The remaining action. After was adjourned on the condition, don't appear.
Today also there is no appearance on behalf of the petitioner. Having regard to the order that was passed on 7/8/2025, this court has no other option but to dismiss the petition from non-prosecution.
Seal number 40, Lord Shri Ravindra K.
Your Lordship has directed government to verify whether some document which has been. Not here, only the questions is that, my lord, the name of the, my lord, the fourth respondent father, grandfather was also, my lord, Lingaya, not son of Siddhaya. The husband of the, my lord, the name is also, my lord, that advantage, same village. My lord, taken that, my lord, even see, my lord, in all the records of the, my lord, fourth respondent family, my lord, shows Matakada, my lord, Lingaya. Lord, only in the first time, my lord, in this, my lord, property, they have entered into, my lord, the Lingaya, son of Siddhaya.
What was the order before the AC?
Lord, AC also, Lord, because Tashildar, kindly see the Tashildar order first, my lord.
Where?
Lord, sorry. Lord, kindly come to, Lord, page number 66, my lord. Because since there is a dispute, my lord, when they came to know that this property which has been entered in the name of the, my lord, name of the grandfather of the fourth respondent, my lord, we filed a, my lord, approach RRT dispute which has been taken place. There, my lord, in between, my lord, suit has been filed.
This was filed by Nagaraju against Lingaya.
Lord, this is not,
You're not a party here.
no, my lord.
The claim of Nagaraju was rejected.
Rejected because because we appeared when we have filed a, my lord, application saying that there is already injunction which has been granted in the OS number. So 36 it has been rejected because since the matter is pending before the civil court, so he cannot entertain. This order, my lord, he has taken into the AC. Lord, AC says, my lord, where, my lord?
You were not a party before the Tahsildar.
Please, my lord, I am the party.
Only Ibrahim.
Lingaya. That time, my lord, husband is a petitioner husband.
So the claim of Nagaraju was rejected.
Rejected.
Then
He has taken to the AC, my lord, chair, my lord. AC, what did, my lord, AC done? Lord, he says that since there is a decree, separate suit which has been earlier to my suit. So when the decree which has already been passed, so on that basis is entertained the appeal, my lord, and order to restore the, my lord, name in the RTC. Page number 33. Page number 30.
page number
33.
by Lingaya.
This is by Lingaya, my lord.
Why did Lingaya prefer an appeal?
No, not Lingaya, Lord, not that. Sorry. Lord, kindly come to annexure B, my lord. Page number 13. Lord.
I think annexure D was the order that.
No, earlier proceedings, my lord, that is. Serial number 13, page number 13. Lord, he says he has mentioned, my lord, OS number 5210 of 2019, which is, my lord, prior to the my suit.
Now please read page 35. Vadimatu.
35.
Third paragraph.
Lord, this is ವಾದಿ 1, 2 ಮತ್ತು 6 ಪ್ರತಿವಾದಿ 17ನೇ ಪ್ರತಿವಾದಿಯ ಪರ ಕೃಷ್ಣಪ್ಪ ಹಾಗೂ 20ರಿಂದ ಪ್ರತಿವಾದಿಯು ಪರ ಜಯರಾಮಯ್ಯರು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರಾಗಿದ್ದು ರಾಮನಗರ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಹರಿಶ್ಚಂದ್ರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 388/3 ಎಕರೆ 38 ಗುಂಟೆ ಜಮೀನು ಸಿದ್ದಯ್ಯ ಬಿನ್ ಲಿಂಗಯ್ಯರವರಿಗೆ ಸೇರಿದ್ದು ಸೊತ್ತಾಗಿದ್ದು ಇವರು ಮೃತರಾಗಿರ್ತಾರೆ. ಸದರಿ ಜಮೀನು ವಾದಿಗೆ ಪಿತ್ರಾರ್ಜಿತವಾಗಿ ಬಂದ ಸೊತ್ತಾಗಿದೆ. ದಟ್ ಈಸ್ ಅವರ್ ಕ್ಲೈಮ್. ಸದರಿ ಜಮೀನಿನಲ್ಲಿ ಅನುಭವದಲ್ಲಿದ್ದು ಪ್ರತಿವಾದಿಗಳಿಗೆ MR 12/84/82 ಪೌತಿ ಖಾತೆ ಮೂಲಕ ಬಂಬದಾಗಿ ಅನಧಿಕೃತವಾಗಿ ಖಾತೆ ಬದಲಾವಣೆ ಆಗಿರುತ್ತದೆ. ಇದನ್ನು ರದ್ದುಪಡಿಸಿ ವಾದಿ ಹೆಸರಿಗೆ ಖಾತೆ ಮಾಡಿಸಿಕೊಳ್ಳಬೇಕೆಂದು ಕೋರಿ ಮಾನ್ಯ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ರಾಮನಗರ ಉಪವಿಭಾಗ ರಾಮನಗರ ಇವರಲ್ಲಿ ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಲು ಸದರಿ ಇವರು ನ್ಯಾಯಾಲಯದಲ್ಲಿ 20ನೇ ಪ್ರತಿವಾದಿ ಜಯರಾಮ ಎಂಬುದಾಗಿ ಲಿಖಿತ ರಾಜಿ ಮೆಮೊವನ್ನು ಸಲ್ಲಿಸುತ್ತಾ ಪ್ರಶ್ನಿತ ಜಮೀನು ವಾದಿಯ ತಂದೆ ಸಿದ್ದಯ್ಯರ್ ಅವರಿಗೆ ಸೇರಿದ ಸ್ವತ್ತಾಗಿರುತ್ತದೆ. ಪ್ರತಿವಾದಿಗಳಿಗೆ ತಪ್ಪಾಗಿ ಖಾತೆಯಾಗಿರುತ್ತದೆ. ಪ್ರತಿವಾದಿಗಳು ಈ ಜಮೀನಿನಲ್ಲಿ ಅನುಭವದಲ್ಲಿರುವುದು ಆದ್ದರಿಂದ MR 12/84/85 ರದ್ದುಪಡಿಸಿ ವಾದಿ ಹೆಸರಿಗೆ ಖಾತೆ ಮಾಡಲು ಪರಸ್ಪರ ಲಿಖಿತ ಸಮ್ಮತಿ ವ್ಯಕ್ತಪಡಿಸಲೆಂದು ಸೂಚಿಸಿದ್ದು ಸದರಿ ಜಮೀನಿನ ಬಗ್ಗೆ ಅಧಿನಿಯಮ 64 ಕಲಂ 126 ಅಡಿಯಲ್ಲಿ ಪುನರ್ ಪರಿಶೀಲಿಸಲು ಆದೇಶಿಸುತ್ತದೆ. ಕಸಬಾ ಹೋಬಳಿ ಹರಿಶ್ಚಂದ್ರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 380 ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ವಾದಿಯು ಹಳೆ ಕೈಬರಹ ಪಹಣಿ IL ಮತ್ತು ವಂಶರಕ್ಷಣೆ ಸಲ್ಲಿಸಿದ್ದು ಸರ್ವೇಯರ್ ಅವರು ಅನುಭವ ಕಂಡಂತೆ ತಯಾರಿಸಿದ ನಕ್ಷೆಯನ್ನು ಲಗತ್ತಿಸಿ ಸಲ್ಲಿಸಿಕೊಂಡು ಮುಂದುವರೆದು ಪ್ರತಿವಾದಿ 1, 2 ಮತ್ತು 6ರವರು ESC ತಮ್ಮದೆಂದು ಹೇಳುತ್ತಿರುವ ಬಗ್ಗೆ ಸದರಿ ಅವರು ಮೂಲ ವಾರಸದ ಲಿಂಗಯ್ಯ ಬಿನ್ ಮಡಗದ ಸಿದ್ದಯ್ಯ ಎಂದಿದ್ದು ಎಲ್ಲಾ ದಾಖಲೆಗಳಲ್ಲೂ ಲಿಂಗಯ್ಯ ಬಿನ್ ಮಡಗದ ಸಿದ್ದಯ್ಯ ಎಂದು ತಿಳಿಸಿ ಈ ಕುರಿತಂತೆ ಸರ್ವೆ ನಂಬರ್ 352/1, 352/7, 352/4, 352/2 ಮತ್ತು 352/8 ಹಿಸ್ಸಾ ಸರ್ವೆ ಟಿಪ್ಪಣಿ ಪುಸ್ತಕದಲ್ಲಿ ಲಿಂಗಯ್ಯ ಬಿನ್ ಮಡಕದ ಸಿದ್ದಯ್ಯ ಎಂದೇ ಇರುತ್ತದೆ. ಮತದಾರ ಪಟ್ಟಿಯ ಕ್ರಮ ಸಂಖ್ಯೆ 264ರಲ್ಲಿ ವಾದಿಯು ಹಾಗೂ 326ರಲ್ಲಿ ಪ್ರತಿವಾದಿಯು 1ರಿಂದ 6 ತಾತನ ಹೆಸರನ್ನು ಮಟಕದ ಸಿದ್ದಯ್ಯ ಒಂದೇ ತರ ಹೆಸರಲ್ಲಿ ದುರುಪಯೋಗಪಡಿಸಿಕೊಂಡು ತಮ್ಮದೇ ನಡೆಸುತ್ತಿರುವ ತಿಳಿಸಿದ್ದಾರೆ. ಸರ್ವೆ ನಂಬರ್ 388ರಲ್ಲಿ ಮಟಕದ ಸಿದ್ದಯ್ಯ ಎಂದಿರುವ ಬಗ್ಗೆ ದಾಖಲೆ ತೋರಿಸಿದ್ದಲ್ಲಿ ಆಸ್ತಿ ಬಿಡುವುದಾಗಿ ಸಲ್ಲಿಸಿಕೊಂಡಿದ್ದಾರೆ, ಖಾತೆಗೆ ಕೋರಿದ್ದಾರೆ. ಅಂತೆಯೇ 6ನೇ ಪ್ರತಿವಾದಿಯವರು ಸಲ್ಲಿಸಿರುವ ತಕರಾರಿನಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 386 ಎಂದು ನಮೂದಿಸಿರುತ್ತಾರೆ. ಈ ಸರ್ವೆ ನಂಬರ್ 388 ಇಲ್ಲವೆಂದಿದ್ದರೆ 6ನೇ ಪ್ರತಿವಾದಿಯವರು ಈ ಜಮೀನು ಲಿಂಗಯ್ಯರವರಿಗೆ ಸೇರಿದ್ದು ಸಿದ್ದಯ್ಯನದಲ್ಲ ಎಂದಿದ್ದಾರೆ. ಆದರೆ ತಾವು ಈ ಜಮೀನು ಸಿದ್ದಯ್ಯನಿಗೆ ಸೇರಿದ್ದೆಂದು ತಿಳಿಸಿದ್ದಾರೆ. ವಾದಿಯವರು ಈ ಊರಿನ ಮೂಲದವರಲ್ಲ, ವಲಸಿಗರು ಎಂದಿದ್ದಾರೆ. ಅದಕ್ಕೆ ವಾದಿಯವರು ಪ್ರಸ್ತುತ 6ನೇ ಪ್ರತಿವಾದಿಯವರು ಈ ಗ್ರಾಮದಲ್ಲಿ ವಾಸವಾಗಿರುವುದರಿಂದ ಸರ್ವೆ ನಂಬರ್ 388ರಲ್ಲಿ ಮಠದ ಸಿದ್ದಯ್ಯ ಹೆಸರು ನಮೂದು ಇರುವ ದಾಖಲೆ ಲಭ್ಯವಾಗಿರುವುದರಿಂದ ಉಭಯತರು ಸಲ್ಲಿಸಿಕೊಂಡು ಕೋರಿದ್ದಾರೆ. ಆದ್ದರಿಂದ ತಂದೆಯ ಹೆಸರು ಸಿದ್ದಯ್ಯ ಎಂದು ಒಂದೇ ಇರುವುದರ ಲಾಭ ಪಡೆದು ಲಿಖಿತ ಸರ್ವೆ ನಂಬರ್ 386ರಲ್ಲಿ ಮಠದ ಸಿದ್ದಯ್ಯನಿಗೆ ಯಾವುದೇ ಹಕ್ಕು ಇಲ್ಲದಿದ್ದರೂ ಸಹ ಮಠದ ಸಿದ್ದಯ್ಯ ವಾರಸುದಾರರು ಖಾತೆ ಮಾಡಿಸಿಕೊಂಡಿರುವುದು ಸ್ಪಷ್ಟವಾಗಿ ಕಂಡುಬಂದಿದ್ದು ಮಾನ್ಯ ಉಪವಿಭಾಗಾಧಿಕಾರಿಯವರು ಆದೇಶಾನುಸಾರ ಸಾಕಷ್ಟು ಕಾಲಾವಕಾಶವಿದ್ದರೂ ಸಹ 386ರಲ್ಲಿ ಹಕ್ಕು ಇಲ್ಲ ಪ್ರಾಪ್ತವಿದ್ದ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲೆ ಲಭಿಸಿದ್ದರಿಂದ ಪ್ರತಿವಾದ ಪುರಸ್ಕರಿಸಲಾಗುವುದಿಲ್ಲ. ಖಾತೆ ಮಾಡುವುದರಿಂದ ಅಭಿಪ್ರಾಯಿಸಿ ಕೆಲಸ ಇದು ಇಟ್ ಇಸ್ ಡನ್ ಇನ್ ಮೈ ಫೇವರ್. ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ not yes change it.
You challenge the order.
It is in my favor.
12/84/85.
No, it is my favor.
MR 12 is in your favor?
Yes, my lord. He is a Lingaya, my lord, not Siddhaya. It is in my favor.
Yes.
Notice is not.
My lord, I'll produce the document also, my lord. Even in because they have not only this property, my lord, they have other property also where, my lord, I have read out now. That name, my lord, only the Mataka Siddhaya name will coming because it is the only.
He accepts notice for respondents 1, 2, 3. Issue notice 2 or 4. Interim stay or status quo, interim order status quo.
Oblige, my lord. Lord, that office objection in respect of that, my lord, that may be overruled because the partition suit which has been filed only in the name of fourth respondent is, my lord, is acquired property. There are not required property, my lord. They are not necessary part. That is the only office objection. Other office objections have been come.
Alakki the objections.
Other office objections have only one office objection, that, my lord, submission which has been made in by senior citizen, my lord, because court fee is already been paid. I am not my lord, claiming any
Objections kept open.
oblige.
Lord, if the lordships kindly, my lord, serial number 38, I'm sorry. Really short.
Last time I had passed an order, isn't it? That if you don't come, I will consider the application. If you don't come, what should I do?
ಅಲ್ಲ ಇದ್ರಲ್ಲ ಸರ್ ಅದಲ್ಲ
Adರಲ್ಲಿ vacating
ಅದಲ್ಲ
stay.
ಅದಲ್ಲ ಅದಲ್ಲ
Earlier.
ಅದು ನಾಳೆ ಆಗಿದೆ ಸರ್
Satish Babu,
38
date ಕೊಟ್ಟಿದ್ದಾನೆ. 24.
ಪ್ಲೀಸ್.
41. Already.
This matter, my lord, as per the direction of the Sanabad court, my lord, in the presence of the parties, my lord, survey has been conducted. Report has been prepared, my lord, I'm filing. Copies also.
But we'll have a look at it. But
Order dated Monday, 3/2020.
Impleading. As ordered on 3/3/2025. Survey has been conducted and a report is also filed. Copies of minutes to be petitioners council.
Master and survey.
List of. Survey copy and make the application.
Copy of the report has been furnished to the petitioner also.
Eight. Number 42.
Interior matter. Interior matter. Same both the.
Sir, ಮಾಡಿದಿರಾ?
Seal number 42 ಮೇಲೆ ತಾವು RSA ಒಳಗೆ ಸರ್ವಿಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಹೇಳಿದ್ರೆ ಒಬ್ರು ಅಡ್ವೊಕೇಟ್ ಹೇಳ್ತಾರೆ ರಿಟೈರ್ ಆಗ್ಬಿಟ್ಟೆ ಅಂತ, ಇನ್ನೊಬ್ರು ಕೇವೆಟ್ ಹಾಕ್ದವ್ರು ಹೇಳ್ತಾರೆ ನಾನು ನೋಡಿ ಹೇಳ್ತೀನಿ ಅಂತ. ಯು ಲಾಸ್ಟ್ ಮೈ ಕೈಂಡ್ಲಿ ಡೈರೆಕ್ಟ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಅಡ್ವೊಕೇಟ್ ಸಂಗಮೇಶ್ವರ್ ಅಂಡ್ ಗೋವಿಂದರಾಜ್. Because considering urgency matter, we lordship proceed today, my lord. Our Sangameshwar and Govindraju, who are the caveators in that.
Respondents 4 to 6 are the appellants.
Are the appellant? No, are the respondents in the RSA 767/23?
Respondents.
It is the petitioner's appeal.
ಅವ್ರು 3 ಜನ ಕೇವಟ್ ಹಾಕಿದ್ರಲ್ವಾ?
ಹೌದು.
ದ್ರಾಕ್ಷಾಯಣಿ, ಪ್ರಸ್ನಾಥ್
ಹೌದು.
and for
Puneet. Caveat petition had been filed by one Sangameshwar and Govindraju advocates. ಅವ್ರಿಗೆ ಸರ್ವಿಸ್ ಮಾಡೋಕೆ ಇನ್ನೊಬ್ರು ಮೇಲೆ ಹೇಳ್ತಾರೆ, ಅವ್ರಿಗೆ ಹೇಳ್ತಾರೆ ಇನ್ನೊಬ್ರು. ಅದಕ್ಕೆ ಕೇವೆಟ್ ಆರ್ ಅಡ್ವೊಕೇಟ್ಸ್ಗೆ
ಇವಾಗ ಯಾರು ಆನ್ ರೆಕಾರ್ಡ್?
ಸಂಗಮೇಶ್ವರ್ ಅಂಡ್ ಗೋವಿಂದರಾಜ್.
ಇವಾಗ ಆನ್ ರೆಕಾರ್ಡ್ ಯಾರಿದ್ದಾರೆ?
ಆನ್ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಈಗ ಗಚ್ಚಿನ್ಮಠ್ ಅಂತ ಇದ್ರು, ಅವ್ರು ನಾನು ರಿಟೈರ್ ಆಗ್ಬಿಟ್ಟಿದೀನಿ ಅಂತ. ಗುರುದೇವ್ ಗಚ್ಚಿನ್ಮಠ್ ಅಂತ.
ಅಲ್ಲ, ಕೇವೆಟ್ ಹಾಕಿದ್ ಯಾರು?
ಕೇವೆಟ್ ಸಂಗಮೇಶ್ವರ್ ಅಂಡ್ ಗೋವಿಂದರಾಜ್.
ಅವ್ರು NOC ಕೊಟ್ಟಿದ್ರ?
ಅಲ್ಲ, ಅವ್ರಿಗೆ ಹೇಳ್ತಾರೆ ಇವ್ರಿಗೆ. ಅದಕ್ಕೆ ಗೋವಿಂದರಾಜ್ ಸಂಗಮೇಶ್ವರಿಗೆ ಹೇಳ್ಬಿಡಿ. Permitted take notice to Govind.
Only said permitted to take out notice on the council who represents the response 4 to 6 in RFA 767. Or is the council survey copy on them?
Out. Kindly specific advocate's name may be mentioned. Otherwise, they don't receive.
I have said councils who are representing R4 to R6. Or is the council you?
ಅವ್ರ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಒಬ್ರು ಇದಾರೆ, ನಾನು ತಗೊಳ್ಳಲ್ಲ, ಆಲ್ರೆಡಿ ಐ ರಿಟೈರ್ಡ್ ಅಂತ ಹೇಳಿ
affidavit ಹಾಕಿ ಅಂತ.
both the councils ಅಂತ record, advocate on record and caveators ಅಂತ.
Will not get into this dial. You should serve a copy. ನಾನು ಯಾರು?
I will take notice to them. Specific ಆಗಿ ಅವ್ರ ಇದು ಮಾಡ್ಕೊಂಡು
waiting service of notice ಅಂತ ಹೇಳಿ. Weeks time is granted to serve the response 4 to 6 through their council.
caveators.
Representing 767/20.
caveators ಅಂತಾನೆ ಬರ್ಲಿ.
I don't know if you have said NOC has been
No,
given.
caveators 26th will have to be kindly have 26th of this month. In the meantime, I will serve the notice on them. Lordship may kindly post the matter of specific date 26th.
First serve on them.
There is urgency in
My
the
lord, with
matter.
permission.
26th.
Lords, you are kindly.
My lord, with kind permission, my lord.
Please wait for a minute.
60, my lords. Further consideration, I have informed the petitioner council also, my lords. Maybe posted next week, any date, my lords, I'll file the,
ಏನಾಯ್ತು?
I'll secure it. I have sought for instruction, my lords. It may post next week, any date, my lords, I'll list.
My lords.
Serial number 2, my lords. The lordships have granted interim order.
And don't make a mention in the
No,
minutes. It's
list-
not the proper.
Apologies.
List to item 50, my lords. The council has some difficulty before this bench, my lords.
Serial number?
50, my lords, 50.
2 weeks.
Yes,
Should be 26th, Lordship may kindly, because I will serve the notice on them 26th.
My lord, with permission.
Madam, ಯಾವ date, madam? Madam, ಯಾವ date? What the second?
Aye, sir.
26th.
42 stop ಐತೆ ಸರ್. List to item 50, 24, list to. Not before me, not first of ಸರ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಯಾವ್ದಾದ್ರು ಪಾಸ್ ಓವರ್ ಆಗಿರೋ ಸರ್?
ನಮ್ಮ ಬೇಡ.
ಸರ್ ಲಿಸ್ಟ್
ಮೆನ್ಷನ್ ಮಾಡಿ ಅಂದ್ರೆ ಅವಾಗೆ ಮೆನ್ಷನ್ ಮಾಡಿ.
ಅದಕ್ಕೆ ಯಾವ್ದು ಮೂರ್ amendment pass.
2 weeks, 2 weeks ಆಗಿ.
What officer sir?
Sir, after.
ಇಷ್ಟು ಅಲ್ಲಿ ಯಾವ್ದು
ಯಾವ್ದಾದ್ರು ಕೊಟ್ಟಿದ್ದೀನಿ. ಎಲ್ಲ 2 weeks ಆಗಿ.
That's serial number 45.
petition. To their counsel appearing before previous order. Hey, man, yeah. ಇದರಲ್ಲಿ ಆಯ್ತು. Also applied. Sorry, ಆದ್ಮೇಲೆ by the given time after ಅಂದ್ರೆ ಅವ್ರು ಬ್ರಾಂಚ್ ಅವ್ರು ಕೊಡಲ್ಲ. ಕೇಸ್ ನಂಬರ್ ಕಳಿಸ್ತೀನಿ. ಫಸ್ಟ್ಲಿ ಇಷ್ಟ ಕಾಲ್ ಔಟ್ ಮಾಡಿರಿ.
Serial number 2 ಕರೀತಾರೆ.
ಸರ್ ಲಿಸ್ಟ್
List.
ಲಿಸ್ಟ್ ಇಸ್ಕೊಂಡು
Subject correction ಕೇಳಿ ಯಾರ ಮಾತಾಡ್ತಾರೆ.
2 weeks ಕೊಟ್ಟಿದ್ದಾರೆ.
ಸರ್ 5 ಇದು 8 to 5 ಸರ್ ಇದು ಕೆಳಗಡೆ ಇರೋದು ಸರ್ 35 ಇದು ಅದು ಇದು
Serial number 2 and delivery.
ಆಮೇಲೆ ಲಿಸ್ಟ್ ಇಸ್ಕೊಂಡು ಡೇಟ್ ಬರುತ್ತೆ ಫೈನಲ್
41, 40. ರಿಸರ್ವ್ಡ್ ಫೈಲ್ ಅಲ್ಲೇ ಕಳಿಸಿರ್ತೀರಾ? ಅಲ್ಲೇ ಕಳಿಸಿ. ರಿಸರ್ವ್ ಫಾರ್ ಆರ್ಡರ್ ಇಲ್ಲೇ ಕಳಿಸಿ. ಇಲ್ಲ ಇಲ್ಲೇ ಇದೆ. ಇದೆಲ್ಲ ಟೈಪಿಂಗ್ ಅಲ್ಲ. ಬರೀ ಹೆಂಗಿದ್ರೆ ಅವಾಗ ಬಿಡ್ತಾರೆ. ಅಲ್ಲ ಬರೀ ಅಷ್ಟೇ ರಿಸರ್ವ್ ಫಾರ್ ಆರ್ಡರ್. ಇದು ನಮ್ ಚೇಂಬರ್ ಕಳ್ಸಿರ್ತೀನಿ ಫೈಲ್ ರಿಸರ್ವ್ಡ್. ಆರ್ಡರ್ ಶೀಟ್ ಕಳಿಸಿ. ಇದೇ ಇದೆ. ಶ್ರೀಮತಿ ಗೊತ್ತಿಲ್ಲ ಶ್ರೀಮತಿ Passed over matter, serial number 1.
Hello. The petitioner is challenging the order passed by the Assistant Commissioner as well as the Deputy Commissioner. The Assistant Commissioner has been allowed and Deputy Commissioner has been rejected. My petition, my lord. The case of the contesting respondent is that, my lord, in page number 35, in page number 35. My lord, the case of the contending respondent is that, my lord, the father of the petitioner and petitioner number 4 executed a registered sale deed in favor of the one Nanjappa. One Nanjappa.
Petitioner.
Petitioner and petitioner number 4 herein. Sir, petitioner number 1 herein. Petitioner number 1 and father of the petitioners have executed the sale deed in favor of the one Nanjappa, who is the father-in-law and father of the contesting respondent herein. My lord, a moment in page number 35, my lord. That is the sale deed.
Date of the sale deed?
But 2012-1985. 1985. But a moment in page number 35, my lord. 35.
Yes.
But kindly see the sale deed, which has clearly indicates, we'll seeing that it is a fabricated for purpose of the case, one aspect. But the second aspect is, my lord, there are 3 items in the sale deed. Two survey numbers, 1 Karnataka number. Survey number, my lord, in page number 40, 41. Survey number 56 and survey number 35/1 and 1 Karnataka number. My lord, what happened? That legal aids of the Nanjappa has filed a suit for declaration with respect to one of the item 35/1 in page number the plaint in page number 27. They filed a suit for declaration on the strength of the registered sale deed in page number 27. And madam, they sought for the declare that they are the absolute owner of the sole property, and they left and pick and choose. They only entered for one item of the property. They sought for declaration, and also they sought for not binding of the registered sale deed executed by the defendant, the petitioner, in favor of the one developer, which has been, they not been challenged that. And my lord, after that, they sought for an appeal, they filed appeal before the Assistant Commissioner. Well, after lapse of the 35 years, they filed an appeal without condonation of delay in page number 17, my lord, a moment, my lord, in page number of 17.
The base of the sale deed, the kata was changed.
Subsequently, 2020, they filed appeal, not 1985. Subsequently, they filed appeal before the
Kata changed on the base of the sale deed.
sale deed. Kata had to change. The order has been passed by the Assistant Commissioner. Kata.
From 85 it has not been changed.
No, it's not changed. Kata is in my name. We are in position still. There are 3 items in the scheduled property, and they pick and choose only one item before the Assistant Commissioner. And without condonation of delay, without appealing of any application, they filed appeal before the Assistant Commissioner in page number 17, my lord. And also, there is no any reference of the condonation of delay in the entire order of the Assistant Commissioner. And the Assistant Commissioner has to come to conclusion that there is a sale deed in favor of this so and so, and appeal has been allowed. I mean, which again is the subsequently we prepared a petition before the Deputy Commissioner. And my lord, Deputy Commissioner is saying, my lord, this is quite strange, my lord, because we submitted in all the documents filed, the suit has been pending, they sought for a declaration, and the Deputy Commissioner is saying that, my lord, Sadri Daviju.
You have not challenged the sale deed.
No, we are not challenged. They challenged it. They filed a suit for declaration.
You have not challenged the sale deed. What is the effect of it?
But they already filed a suit for declaration based on the sale deed, which is the pending for consideration.
You don't file a suit challenging that sale deed. Is it not amounting to accepting the sale deed?
No, they themselves have filed suit for declaration against me with respect to one item.
Even if the declaration suit is dismissed, will the sale deed go?
Well, they have filed out of the 3 items, they only choose one item.
Their choice. They have gone to the court. So long as the sale deed is there, it binds you. Your father executed the sale deed.
No, that is, we are not at all, the contention of the,
Your father never challenged the sale deed.
but we are not at all aware of we never executed such sale deed during 1985.
Then you should, until you get a declaration that the sale deed is a fabricated document, or it is forged, or it was signed by jurors or whatever. How can that effect of the sale deed be
But
nullified?
they themselves filed a suit for declaration. The declaration suit is pending.
You have been asked to go to the civil court now, isn't it?
No, they have to file suit. No, they themselves filed suit for declaration. Again, they filed a appeal before the Assistant Commissioner and the Deputy Commissioner. The Deputy Commissioner saying that, my lord, we have challenged only for JD, not the sale deed. A movement in page number 26, my lord. A movement in page number 26. Sadri Daviyu JD ಅನ್ನು ವಜಾಕೋಳಿ ಸಂಬಂಧ ಆಗಿದ್ದು ಅಕ್ಕಿನ ಬಗ್ಗೆ ಸಂಬಂಧಪಟ್ಟಿರುವುದಿಲ್ಲ. The Deputy Commissioner has to come to such conclusion that, my lord, they already sought for the declaration in page number 26 tapali. Adre Sadri Daviyu JD ಅನ್ನು ವಜಾಕೋಳಿ ಸಂಬಂಧಪಟ್ಟಂತೆ
That sale deed is there. I can't do anything in this.
my lord, only question is they already filed a suit for declaration which is pending.
Was the mutation not made despite the sale deed of the 84-85?
And my lord,
They have not done, in fact, section 128, proviso number 2.
No, is it a fact that from 84, 85, despite the sale, it has not
It
changed?
has not been changed.
Why is it not done, madam? It's like 40 years. Then what is the reason? ಬೆಳೆ ಕೇಸಲ್ಲಿ 50 ವರ್ಷ, ಈ ಕೇಸಲ್ಲಿ 40 ವರ್ಷ.
Proviso to section 128 specifically.
All right, all that is there. For 40 years, if the name is not changed. What is the,
Of course, it has not been changed. It is the duty of the revenue officer to change the entries in the revenue records because the title has been transferred.
No, if they fail in their duty.
Registered sale deed.
if they fail in their duty, after
That's the
40,
reason why I went to the Assistant Commissioner, made an application stating that, look here, I have got the sale deed executed by the petitioner before the Honorable Court and his father. And despite the sale deed, my name has not been entered in the revenue records. So the Assistant Commissioner passed an order directing the Tahsildar to effect necessary entries in the revenue
now
records.
for almost half a century, their name has stood, and now to change it,
That is true. That is the fact that our name was not entered in the revenue records. Therefore, only we went to the Assistant Commissioner making.
I need the instructions to why AG accepts notice for.
the
And
notice
the
already
Deputy
issued.
Deputy Commissioner has said that your remedy is by filing a civil suit, you establish your title to the property, then necessary changes will be made in the revenue records.
But I am finding it difficult to accept that 40-year. The
It should
entries
have
stand in
been-
one person's name for 40 years. It is more than one generation.
Correct.
Now, if you suddenly say that my sale deed was not given effect to, either way, you're before the civil court.
That is how the revenue authorities function.
No,
Despite
what
all-
about you? You should have done something.
I should have, that's right, I should have, but notwithstanding that I did not go to the revenue authorities.
Then at AGA to state,
And yes,
to get secure instructions to why the revenue entries were not mutated pursuant to the sale deed of year 84, 85. Relist on sounds. Till then, status quo regarding entries to continue.
It was absolute. Great.
You have no case. The only thing is 40 years.
My lord,
So-
only question is that, my lord, the sale deed itself is clearly indicates. Yes, my lord.
second April. Seal number 10.
Second, but third account.
Bill number 10, Shri S.V. Prakash.
There two petitions, my lord. I request my lord to take second petition,
You 136, huh?
second petition,
136.
136, mutation proceedings. Second petition, 30,335. Lord, I invite my lordship kind attention to annexure A, page 33, typed copy 33. My lord, 12 of 1988-89, it is the mutation entry made in favor of my lord, the petitioner's father and uncle. On the right hand side, madam. Form 21 was issued, nobody has objected.
In consent, Kathan.
Uh,
Consent.
Yes, ma'am. This is not, my lord, on the death inheritance, my lord, this was accepted. It's the ancestral property.
Bautina.
There, inheritance, Bauti Sabu. My lord, this is of the year 1988,
ಅಣ್ಣನ್
89.
ಮಕ್ಳಿರ್ಲಿಲ್ವಾ? ಅಣ್ಣನ್ ಮಕ್ಳಿರ್ಲಿಲ್ವಾ?
No,
Ramappa had no children?
Ramappa died issueless. Ma'am. Ramappa died without any issues. Survivorship. My lord, page 35, my lord, the genealogical tree of the petitioners and.
What happened after this?
But thereafter, my lord, there was a subsequent death and my lord, the mutation was accepted in 2016 and 17, annexure E, my lord. Annexure E, this is of the year 2016-17
Yellappa also, Barsappa.
and not
Barsappa.
Ellas, not their Ellas.
No. Ramappa died.
Ramappa
The
died,
Gata came in the name of Barsappa.
yes. ma'am.
Barsappa also died.
ಹೌದು Ramappa bin Yellappa. It was made in the name of Gangamma Kom Hanumantappa
ಇಲ್ಲ
and
ರಾಮಪ್ಪ
ಇತರ.
ರಾಮಪ್ಪ ಬಿನ್ ಯಲ್ಲಪ್ಪನ ಹೆಸರು ಇತ್ತು.
ಅವ್ರು ತೀರ್ಕೊಂಡು
ಅವ್ರು ತೀರೋದಾದ್ಮೇಲೆ ಪರ್ಸಪ್ಪ ಬಂತ. ಪರ್ಸಪ್ಪ ಬಿನ್ ಯಲ್ಲಪ್ಪ.
ಪರ್ಸಪ್ಪ ಆಮೇಲೆ ಗಂಗಮ್ಮ ಅದಕ್ಕಾಗಿ ಅನೆಕ್ಷರ್ ಬಿ ಲಾರ್ಡ್ಶಿಪ್ ಖಂಡಿಸಿ ದಿಸ್ genealogical tree, page 35.
Not common propositors is Yellappa Gajera, he's a common propositors, Kari Yellappa and Milord Parsappa. Not the Ramappa, Milord, who died and mutation entry was made is Ramappa. So Ramappa represent Kari Yellappa's branch. And Milord Parsappa, that is Gangamma, Milord Annexure E. This is Milord Parsappa's family. So the petitioners in the writ petition represent Milord this Hanumantappa's branch, that is branch of Parsappa. Your Lordship got it, Milord. The Ramappa is here, Milord, Kari Yellappa's son, Ramappa. He died as a bachelor and entry was in 1988-89 in the name of Parsappa. His brother, survivorship, no children, therefore the brothers got it and how, Milord, entries were made. But this entry 1988-89, Milord, sought to be challenged in 2017, Milord, by, Milord, the sixth respondent, who is son of Parsappa. His father name was there in the mutation, page 66, Milord. It is 17, Milord, he files an appeal, 136, without an application for condonation of delay. He challenges, Milord, 2017 mutation, page 68, MRH 19. Milord, this is annexure E, F. This annexure F mutation was challenged. Then, Milord, the Assistant Commissioner, annexure H, page 69.
Challenge annexure E na.
How?
What the
Annexure,
challenge?
annexure E, Milord.
That is annexure E.
Annexure F, Milord. He challenged annexure F. The bottom on left side date is given 27/2/2017 in page 65. Date is last, Milord. Mutation Adesha Dinanka 27/2.
It was from Ramappa in favor of Ramappa, Iramma, Baswantappa, Chandrappa. And from Parsappa to Ramappa.
Ramappa is his father, Milord. Ramappa is his uncle.
Annexure F he challenged. Annexure F he challenged.
Challenges, Milord, in by way of an appeal before there is no delay. There is no delay. Page 66.
Why was it allowed?
Milord, it was dismissed. Page 69. Page 69. Page 75, ink page 75, order portion. ಪ್ರಸ್ತಾವನೆ ವಿಧಿಸಿದ ಕಾರಣಗಳಿಗೆ ಮೇಲ್ಮನವಿ ತಿರಸ್ಕರಿಸಿದೆ.
Then DC.
Then, Milord, he challenges, Milord, that this order was challenged before Deputy Commissioner. Milord, we were not made party, we were not issued notice by the Deputy Commissioner, Milord, annexure J. Milord, the Deputy Commissioner allows the revision petition and he remands it to the Assistant Commissioner.
He interfere in order of remand.
No, I am not challenging remand order, no. Milord, there was a remand order by Deputy Commissioner. Why then, Milord, what happened is, there was another, Milord, an appeal pending. Milord, that is a connected matter, but I will argue a little later. And therefore, he said, you consider this appeal along with other pending appeal is.
That appeal was against which MR? That appeal was against which MR?
No.
Connected appeal.
Yes, Milord.
Against which MR was that appeal filed?
No, that is, Milord. There was, according to the Milord, the private respondent in the other writ petition, he says, there are three persons, they say that their fathers purchased 5 acres of land in this survey number in 1954. And they first time sought for kata of the land, Milord, after 73 years. And the Tahsildar said, no, you are not entitled. You go and establish your title by way of suit. And he relegated them to civil court. That order was challenged. And Milord, this revision is said you consider. And in the meantime, he challenges, Milord, in annexure F is challenged before the Assistant Commissioner. That was dismissed and revision we filed. And thereafter, Milord, he files the appeal, 2 more appeals, Milord, against the annexure E and annexure A mutation. Milord, I should find it. Appeal memo. Page 83.
This 88-89 order was challenged.
ಅದು ಮುಂಚೆ ಮಾಡಲಿಲ್ಲ, ಈಗ ಮಾಡ್ತಾರೆ. Page 83, Milord. Page 83. This is appeal memo. ಆಮೇಲೆ
Is
page
the ultimate-
86, page 86, ಮೇಲ್ಕಂಡ ಎಲ್ಲ ಕಾರಣ ಸಂವಿಧಾನ 1ನೇ ಎದುರಿ 17-12-88. But this mutation he challenges. 88. And another appeal, he challenges annexure E. Another appeal, annexure E. My lord, the Assistant Commissioner allows these two appeals. Page 91. There is no application filed. My lord, 88 mutation.
What ground did he allow the appeal?
My lord, he says that, my lord, he made a, I don't understand, my lord, the reasons. It is not difficult to understand what is the, my lord, reason he says, my lord.
Page?
No, my lord, firstly, my lord, Deputy Commissioner, before Deputy Commissioner, my lord, what I say is, my lord, there is a limitation, my lord, under 136(3). But 88 mutation, my lord, challenges in 2017, and that is allowed. No, that is
Then,
Deputy Commissioner order. That is Deputy Commissioner. I filed
be-
revision. My lord, I filed revision is dismissed. But he says I should approach civil court.
Next, then is the AC's order.
AC color, GC.
N is AC order,
AC order is, my lord, page 104,
3/8/2023.
96 ಇಂದ ಶುರುವಾಗುತ್ತೆ. AC.
Connected matter ನಾನು ಹೇಳ್ತಿರೋದು. 30335. Area number? DC order. Read from page 11.
Well, may I submit before that?
ನಿಮಿಷ.
ಅಥವಾ ಕ್ರಯ ಕಾನೂನು ತತ್ವ ಸಿದ್ಧಾಂತಕ್ಕೆ ವಿರುದ್ಧವಾಗಿರುವುದಿಲ್ಲವೆಂದು ಕಂಡುಬರುತ್ತದೆ. ಈ ಮೇಲ್ಕಂಡ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ಸಾಗರರವರು ಆರ್ಯ ನಂಬರ್ 37 ಮತ್ತು 38/2020 ದಿನಾಂಕ 36/22 ಮತ್ತು
All these MRs are inter family. But 58 sale deed is being implemented now.
yes, madam. Now it has been implemented, madam. On his-
Same ಅದೇ ತರ 60 ವರ್ಷ
70 ವರ್ಷ ಆಗಿದೆ.
ಬಟ್ ಅದರಲ್ಲಿ
54.
ಆರ್ಡರ್ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ ಆ ಸೇಲ್ ಡೀಡ್ ನ ಇವ್ರು ಯಾರು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿ
ಇಲ್ಲ ಸೆಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು ನಿಮ್ಮ ಲಿಮಿಟೇಷನ್ ಇರೋದು.
limitation.
Accepts notice for.
No, matter is now before Tahsildar.
1 to 5. Issue notice to R6. Status quo regarding entries to be maintained. Federal same respondents, huh?
ಹೌದು. ಅಲ್ಲ, same response, my lord, matter is now before Tahsildar.
They said status quo regarding entries. Notice ಆಗಿದೆ.
Connected matter 1 to 5. madam.
Respondent 7 to 12. Respondent 6, both the parties, legal status quo regarding entries.
For hearing IA. Seal number 43.
Read in this case.
Appearing for petitioner.
Challenge is, Lord, insofar as review petition has been filed by the deputy commissioner. By the petition.
Sir, what is the stay granted?
When the state now. Insofar as the order of review which has been rejected.
Vacating stay ಹಾಕಿದ್ದಾರೆ 2017.
Lord, that they will give tax. Further in the year.
You are ready?
One small submission, my lord. Reason inconvenience, my lord. Please have it done any day next week. my lord.
Who will issue?
The issue is very simple.
Like, if he is not ready, what is the point? Who will issue? The list. Get it in next time, merits. After so many years, if I have to.
24th. Number 44th.
Whom do you want to implead? Yarna.
Respondent number 10 has declared the property to his wife name. Wife.
Respond number? ಯಾರು ಮಾಡಿದಾರೆ?
Respondent number 10, my lord.
He sold it to gifter.
This was a religious Shivama. He did ಮಾಡಿದ್ದಾರೆ.
Who appears for the husband? Issue notice in I1/2020.
Seal number 45.
This matter, my lord, is there are two applications filed by impleading applicants to come on record. Lord, these applicants, my lord, one applicant is a purchaser, another applicant is a grantee, saying that I am the grantee of the very similar person, Shivlingama, who is the petitioner herein. This honorable court, my lord, has directed the jurisdictional police to make an inquiry who is the original grantee, because two persons, petitioners, writ petitioner ಏನಾಗಿತ್ತು ಅಂದ್ರೆ one of the person claiming that I am the petitioner, I am the original grantee ಅಂತ they one person come and filed an application.
What is the impugned order in the?
Impugned order 136 subclass 3 proceedings before the deputy commissioner, my lord, regarding the genuineness of grantee is concerned. Deputy commissioner, my lord, has been allowed, and these records genuineness of grant is concerned, my lord, has passed an order. The impleading application, my lord, when we filed this writ petition is pending consideration. Your lordship has before your lordship in the WP, one more writ petition filed by impleading applicant that was allowed. May I kindly look at, my lord, this one WP, your lordship has passed the order. Very same impugned order has been set aside because no opportunity was given to the applicant. Therefore, matter remanded to the deputy commissioner to give opportunity and set aside the order. My lord, this during pendency of that proceedings, my lord, after remand,
What is this order? Detailed order in it?
the detailed order itself, my lord, was set aside by your lordship.
Lala. What is the interim orders passed by this court?
This court, my lord, has passed an interim order, direct the jurisdictional police to make an inquiry who is the original person, whether Shivlingama, petitioner also claiming as a Shivlingama, impleading applicant also saying that I am the Shivlingama. Based on that, a report has been before this court. 3 police stations, my lord, matter was referred to 3 jurisdictional police conducted inquiry. One report, my lord, clearly indicates impleading applicant is an impersonated person. This petitioner is the correct Shivlingama.
136(3) ಇದನ್ನೆಲ್ಲ decide ಮಾಡೋದು.
But my lord, what happened, my lord? There are 2 claims, 2 persons claim. Rightly or wrongly, your lordship has decided. Now the matter, my lord, has been set aside by your lordship in this matter and remanded to the DC to make an inquiry with regarding the genuineness of grant is concerned. Now the deputy commissioner, my lord, has after that inquiry, he has directed the Tahsildar to get the report from the concerned authority and put up the records. Now at this stage, my lord, this incident happened. This impleading. Now, my lord, my request before your lordship is that once your lordship has set aside the order, this matter also remain. Let them conduct the fresh inquiry, because that impersonation person is now out of court. Earlier, at their instance, my lord, matter was remanded, and now the DC has to conduct detailed inquiry whether who are the grantees or not. Genuineness of grant is concerned now. Now, out of that, my lord, one is claim has been now decided by the court. ಅದಕ್ಕೆ ತಹಸೀಲ್ದಾರ್ಗೆ ಅವರು ಡೈರೆಕ್ಷನ್ ಮಾಡಿ
custodian of the records, let him verify the records, then it will happen. Not the DC.
he has to give a report to the DC. DC has to decide the delegated powers under 136 3 million.
Report ಏನಂತ ಆಯ್ತು ಮೇಡಮ್ ಕೊನೆಯಲ್ಲಿ?
Police report, my lord, is there, my lord.
Pertaining to, my lord, the impleading applicant and petitioner, that is the report, my lord, it is filed by the
Police.
police. And regarding.
Not the
grant-
genuineness. Only the persons is concerned, my lord, report indicates impleading applicant is an impersonated person.
FIR ಹಾಕಿದ್ದಾರೆ.
ಹೌದೌದು ಆಗಿದೆ. ಅವ್ರ ಮೇಲೆ FIR ಆಗಿದೆ impleading applicant ಮೇಲೆ.
Who appears with impleading applicant?
Now they are After this happened, my lord, nothing. They have given NOC and some other advocates, now all NOCs. They order mele they sold to another person. That person also come and filed an impleading application before this honorable court. And my lord, in view of the order, my lord, annexure J,
Then covered.
Tahsildar has to pass, my lord.
Covered ಆಯ್ತಾ? No. Have you seen this order that I have passed? I have set aside this order dated 79/2019. And
Remanded to DC, my lord, to make an inquiry. Fresh in accordance with law by giving opportunity. Allow the police report that also placed by the police, my lord, after that.
ಯಾವಾಗ್ಲೇ order ಮಾಡಿಸ್ಕೊಂಡು ಇದನ್ನೆಲ್ಲ ಯಾಕೆ ಮಾಡಿಸ್ಕೊಂಡ್ರಿ?
See, I am the original grantee. Third person filed, impleading applicant filed this unchallenged. Now, my lord, the court has already, through the court, my lord, inquiry was conducted, police come to the conclusion, and those person is an impersonated. We are the original Shivlingam and grantee of the subject land. Therefore, the proceedings has to, my lord, technically, my lord, the order was already set aside. Let them decide it by the DC in accordance with the record submitted by the parties. Make an inquiry whether the grant may genuineness of grant.
The order impugned in this writ petition was also the subject matter of WP 1275/2021. And this court by an order dated 1st of July 2022 disposed of the writ petition in following terms. Purti copy. In the light of the above, having regard to the fact that the impugned order has already been set aside in WP 1275/2021. The order impugned in this petition, insofar as the petitioner is concerned, is also set aside. And the matter is remanded to the Deputy Commissioner to conduct an inquiry as ordered, WP 1275/2021 afresh.
But thereafter, my lord, one incident happened, my lord. After that order, my lord, Deputy Commissioner make an inquiry. One order was passed to delegate the power to Tahsildar. Tahsildar has to submit a report. This is the order, my lord. After this, your lordship remand order.
No, I remanded to DC. What
Yes,
happened
my
to
lord.
DC?
DC has, my lord, has again, my lord, has very same similar issue come before the DC. Who is the Shivlingama is the original genuine person. He delegated powers to Tahsildar.
ಶಿವಲಿಂಗಂ ಯಾರು ಅಂತ ಆಮೇಲೆ.
And now the petitioner is the Shivlingama. Impersonated person also called as a Shivlingama.
ಇದು ಶಿವಲಿಂಗಮ್ಮನೆ.
Adu Shivlingama is the impersonated person. Now,
ಈ ಶಿವಲಿಂಗಂ
that is impersonated person.
ನೀವು ಒರಿಜಿನಲ್.
Now original is declared by the, as per the police report. That was misguided and misleaded to the court, and the court also, my lord, without Deputy Commissioner also after that, my lord, had inquiry and passed this order. Thereafter, my lord, that impersonated person sold to one Shivshankar. He claimed before this court and filed an application again in pleading. This is the entire fraud made by the impersonated person.
One ಶಿವಲಿಂಗಮ್ಮ filed WP 1275/2021. Challenging the order impugned in this writ petition, that is the order dated 79/2019, passed with the special deputy commissioner. This court, by an order dated 1st of July 2022, disposed of the writ petition in the following terms. And counsel for the petitioner submits that WP 1275/2021, which was filed by Shivlingamma, was in fact filed by the person who was impersonating Shivlingamma, and she was not the original grantee. That person petition contains that the Shivlingamma, who is the petitioner in this writ petition, is in fact the original grantee. And therefore, the claim made by Shivlingamma, the petitioner WP 1275/2021, would be a fraudulent claim. The council over submits that since the impugned order has already been set aside, the matter has been remanded to the Deputy Commissioner. The Deputy Commissioner will be directed to consider the claim of the present petitioner, Shivlingamma, that is the petitioner in WP 3025/2020, present writ petition, and thereafter decide the matter fresh on merits. The council points out that in pendency of this writ petition, the police were directed to conduct an investigation. And the police, after an investigation, have concluded that the petitioner WP 1275/2021, that is the alleged sibling Amma, was an imposter. And therefore, she will have no right to participate in the proceedings. Learned Counsel also submits that pursuant to the order passed WP 1275/2021, the Deputy Commissioner himself had delegated had directed the Tahsildar to conduct an inquiry regarding the genuineness of the claim of Shivling Amma.
Yes,
And-
yes,
Shivling
not
Amma-
grant, he's only alleged,
And the
Jinay
Tahsildar had submitted a report,
yet to submit report now at this stage.
has yet to submit a report. In the light of the above, the Deputy Commissioner is directed to consider the claim of the present petitioner Shivling Amma's, present Shivling Amma through her LRs.
As well as other petitioners, other land is there, my lord, that also to be remanded, my lord, now. The other two petitioners, another survey number, my lord.
Decide the matter afresh. The Deputy Commissioner also consider the claim of other petitioners in this regard and pass approved orders. The question as to whether the petitioner in WP 1275/2021 has a genuine claim or not can be considered by the Deputy Commissioner in the light of the police report that has now been filed and also the report of the Tahsildar that may be filed in this regard.
Yes,
WP is according to this.
my lord, my humble request, my lord. Based on that remand order, my lord, that impositor lady sold the property. Again, that impleading applicant before the court now.
What can be done here?
My lord, here is only, my lord, all subsequent transactions in the 226 exercise power and declared
What
as
is the,
null and void.
what is
my
the
lord.
order of the special DC?
Yes, DC has to decide whether who is the grantee and genuineness of grant.
If she has sold
Yes.
without title,
My lord, one, any transaction pursuant to order, my lord,
you're asking me to give a finding.
not finding,
First of all, that she's an imposter.
correct, my lord.
And secondly, that the sale done by her is illegal.
That he come on also before the court claiming I am the purchaser of property.
Allow ಮಾಡ್ಕೊಡಿ.
Yes. Not one thing, my lord, one observation. Liberty to challenge that sale deed before the appropriate court. Otherwise, my lord, my right, my lord, again, that person also claiming based on impersonated lady, that I have a liberty to
Agreed.
challenge.
Any of the action said to have been taken by the petitioner in WP 1275/2021, that is the alleged imposter Shivling Amma, it will be open for the petitioner's hearing to initiate appropriate proceeding against the same.
Great.
Number 46, should be able to go.
I'm appearing for the petitioner, my lord.
It's
They
appear
have
for the,
filed objections on this one short
For
account.
what?
For,
for the respondent.
they have filed a vacating of interim.
For the respondent number 4 and 5, my lord.
One short
Not the
account, they
petitioner.
should-
Petitioner father has purchased 2 acres of land, my lord, in 7 number 90 bar.
2020 interim order, ah? In 2020 interim order.
Yes.
More time ಕೊಡ್ತೀನಿ. List.
Interim order may be extended.
Note continue to.
Before 24.
Eಲ್ಲಿದೆ ಮಸ್ಟಿಂಗ್ ಅಮ್ಮ? ಎಲ್ಲಿ interim order?
Number 47, Shri S.V. Prakash.
My lord, I appear for petitioner. But
For
this
the
can be disposed of. This can be disposed of. The application is for early hearing. This can be disposed of. Lord, I have,
ಇವಾಗ ರೆಡಿ ಇದ್ರ ಇಲ್ವಾ?
I'm ready. Lord, I have challenged, my lord, the order of the assistant commissioner. My lord, at next year.
ರಿವಿಷನ್ ಹಾಕ್ಲಿಲ್ವಾ?
My lord, what happened is, my lord, the respondents 4 to 15. They have nothing to do with the my land. That is my case. 61/2. The petitioners are the owner.
ರಿವಿಷನ್ ಇರ್ತಾನೆ ಇದ್ರ ಮೇಲೆ.
My lord, appeal me.
ಆರ್ಯ ಆರ್ಡರ್ ಮೇಲೆ
ಹೌದು
ರಿವಿಷನ್.
ಹೌದು ಅದು ಯಾಕೆ ಅಂತ ಅದರ್ವೈಸ್ ಮಿಲಾಡ್ ಐ ಹ್ಯಾವ್ ದ ರೆಮಿಡಿ ಆಫ್ ರಿವಿಷನ್ 136(3). ಬಟ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಕೈಂಡ್ಲಿ ಸಿ ಐ ಆಮ್ ಎಂಟೈಟಲ್ ಟು ಮಿಲಾಡ್ ಚಾಲೆಂಜ್ bypassing remedy of revision. Milord, I bring to your lordship now what happened is, Milord, 1962-63 mutation was challenged by Milord the respondents 4 to 15 in the writ petition before assistant commissioner, Milord, with an application to condone delay. Milord, I have produced that application. Your lordship kindly see
delay.
page 6.
Yes, condone the delay.
No, he condoned delay in one line order. Then, my lord, what happened is I have challenged that order before Deputy Commissioner. My lord, dismissed my revision petition on the ground that there is a mistake in mentioning, my lord, the provision. My lord, your lordship kindly see page 98, page 98. Earlier, my lord, after exhausting all the remedies, that is Deputy Commissioner, I have approached this court, annexure P, page 98. Your lordship kindly see the order, my lord, para 2, my lord, para 2, my lord. That this court has come down heavily on the revenue authorities in, my lord, entertaining appeal, which are, my lord, barred by time.
Which is the order that you're challenging?
No, yes, my lord, I can. Then, my lord, this after remand, my lord, what happens? Your lordship kindly see what happened after remand.
What is the impugned order?
My lord, impugned order is again, my lord, third time, my lord, the similar order is passed by the Assistant Commissioner in a one-line order.
Yes, condone the delay.
Yes, my lord.
What is the reason? What is the reason given for condoning the delay?
No, my lord, therefore, my lord, your lordship kindly see the application first. But what is the reasons assigned? My lord, page 89, annexure K. Page 90, my lord. If there are reasons, my lord, offered in the affidavit, whether it is for the Assistant Commissioner to decide whether those, my lord, reasons offered by the applicant constitute valid grounds within the meaning of section 5. There are no reasons. Page 90, your lordship kindly see. Page 90. 90.
No, he has found some deficiencies in the order of mutation. Therefore, he has found it.
1960 to 63 mutation, my lord.
Based on?
My lord, based on, my lord, our, it is ancestor property, my lord, based on our right, my lord, mutation. Mutation was accepted. Mutation, my lord, let us see that
We'll go step by
mutation.
step.
Yes, my lord.
You made a claim for changing the name in your.
Yes, my lord.
On what basis did you make the change?
My lord, annexure, my lord, because of, my lord, page, my lord, annexure D, my lord.
The Vedi sir Prakash, on what basis did you make the claim for getting your name mutated?
My lord, page annexure
Sale
A.
deed, partition, what?
No, there is, my lord, I will read the page 20, my lord.
Taylor sir, you don't have to read. Page 20.
My lord, page 32, my lord, page 32. That is the mutation. No,
Better.
you wait for your turn, please. My lord, let us take that, my lord.
ಏನಂದ್ರೆ ಬಗ್ಗೆ ಖಾತೆಗೆ ಒತ್ತಾಯಿಸಿ ಅರ್ಜಿ ಮಾಡಿಕೊಂಡು
It's difficult to read. Page 19.
ವೆಬ್ ಕಾಪಿ
My lord, page 19, my lord. Page 19. It's difficult to, my lord, read.
I am reading your taped copy.
Yes, my lord, ಮೇಲ್ಕಂಡ ಅರ್ಜಿದಾರ ಸ್ವಾತಂತ್ರ್ಯ ಮಾರ್ಜಿನಲ್ ಇರುವ ಖಾತೆಯಲ್ಲಿ ಅರ್ಜಿ ದಾಖಲೆಯಂತೆ ಬಸಪ್ಪ ಮೀನ್ ಖಾತೆ ದಾಖಲು ಸ್ವೀಕರಿಸಿದೆ. This is, my lord, 62-63 accepted in.
ಇದ್ರಲ್ಲಿ ಕೊಟ್ಟಿರೋದು ಅರ್ಜಿದಾರನು ಮಳ್ಳೆಬೆನ್ನೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 61 ಸೊಪ್ಪಿನ ಬಸಪ್ಪ ಬಿ ನೀರಪ್ಪ ಎಂಬುವರಿಗೆ 4 ಎಕರೆ ಜಮೀನಿದ್ದು ಸದರಿ ಉತ್ತರ ದಿಕ್ಕಿನ 2 ಎಕರೆ 32 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣದ ಬಗ್ಗೆ ಖಾತೆಗೆ ಒತ್ತಾಯಿಸಿ ಅರ್ಜಿ ಮಾಡಿಕೊಂಡಿರೋ ಬಗ್ಗೆ. What basis? Are you related to him? Was there a transfer?
My lord, let us take that, my lord, this is a wrong mutation. Wrong mutation. Whether, my lord, a aggrieved party can approach the appellate authority at his sweet will. My lord, what should be, my lord, the reasons, my lord, page 90. Now come to page 90. My lord. See, 62-63 appeal is filed, my lord, after lapse of.
You
Try
tell
to
me
take page 90.
You tell me the basis for this claim as to on what basis you are asking for 2 acres. ಒತ್ತಾಯಿಸ್ಬಿಟ್ಟಿದ ತಕ್ಷಣ ನೀವು ಖಾತೆ ಚೇಂಜ್ ಮಾಡ್ಬಿಟ್ರೆ.
Let us take that, my lord, it is correct. The mutation could not have been accepted. Let us proceed on that premises.
I will hold
Then,
that. I will hold in the given facts in some of this case, it is an appropriate case, condone the delay.
my lord, kindly see, my lord, page.
Argument that being
No,
my
no,
reply.
no. Not only that, page 90, your lordship, first, kindly for few minutes, my lord, page 90. This is the reasons assigned. Whether it is sufficient to condone delay is one, page 90. Page 90, this is this application.
ನೀವು
This is
ಅಷ್ಟು
applied.
ನೀವು
No, I followed.
ನಿಮ್ಮ
my lord.
ಅಪ್ಲಿಕೇಶನ್ ಯಾರು ಓದ್ತೀವ ನಾವಿಲ್ಲಿ.
My lord,
ಇಲ್ಲ ಅಫಿಡವಿಟ್ಸ್ ಅಷ್ಟು ಹಾಕ್ತಿರ ಸೆಕ್ಷನ್ 5 ಅಪ್ಲಿಕೇಶನ್ ಯಾರು ಓದ್ತೀವ ನಾವು?
No, that is a different aspect, but to condone, my lord, if there is, my lord, small delay, I understand this court would, my lord,
Want an
condone.
order, you want an order confirming this AC order, or will you go file a revision? I am prepared to confirm this order,
Your lordship
or
kindly,
you want to go and file a revision?
kindly see the orders passed by this court afterwards, my lord. It is not first time I challenge. My lord, the direction issued by this court.
You want to argue, I'll consider on merits and say that this reason given is correct. Avoid ಮಾಡಬಹುದು, ಸುಮ್ಮನೆ revision ಹಾಕೊಡಿ. Maybe you'll have a better chance there than before me.
No, no, that I followed. My lord, the order passed by this court, my lord, page 121. My lord, what happens, my lord, my submission, your lordship kindly appreciate. I understood, my lord, what is passing on your lordship mind. If I withdraw this writ petition, there will be liberty for me, and I approach the deputy commissioner, and I may get a favorable order. If I don't get a favorable order, I may again come before this honorable court, and if it may appear before some other judge, he may accept the case. I understood. But, my lord, there is
But
a
if you
direction
argue-
issued by this honorable court,
if
even
you-
that is flouted.
But if you argue, I will confirm this order.
Then, my lord,
ಏನ್ ಮಾಡಿ?
my lord, ಮಾಡ್ಲೇಬೇಕು ನಾನು.
ಇಲ್ಲ ನೀವ್ ಹೇಳಿ ಏನ್ ಮಾಡಬೇಕು? ವಿಡ್ರಾ
My lord,
ಮಾಡ್ತೀರಾ?
my lord, I seek liberty to go before deputy commissioner. I don't want to file writ appeal.
Pass with the assistant commissioner.
My party is very small.
Delay has been condoned, the petitioner has the remedy of filing a revision. Hence, I decline to entertain this writ petition and reserve liberty to the petitioner to approach the deputy commissioner by way of a revision. Public is accordingly dismissed subject to the appeal.
Argument ಮಾಡ್ಬೇಕು.
CMAರಿಗೆ they changed the author. Only on the application.
Take notice for response.
Number 48.
For the petition.
Sunil Kumar S.
That's for the extension of interim order. The last occasion, my lords had sought for the status of the RTC. On the last occasion, my lords had directed the government to secure the revenue records. I've got the records. In the RTC, there is a reflection of Sarkari Gomala.
ಏನ್ ಮೇಡಮ್? What is the matter about?
That's proceedings relates to 136 up plus 3, my lords.
136(3).
Please, my lords.
Next year.
That's the deputy commissioner by an impugned order had directed the Tahsildar to keep the records in the name of government.
Where is the order of the DC?
My lords, typed copies at 83, my lords.
80. ಎಷ್ಟು?
83. $55 is the original order. Type copy is at 83 minutes.
ಏನ್ ಮೇಡಮ್ ಇದು ಕಾರಣ? He gives a finding that Sagodi sheet is issued and yet he says 136(3) ಅಲ್ಲಿ he can sit in judgment over. It does not record a finding as to that.
I had sought for an extension of interim order by filing an application.
Shall continue to the next state of. Entry ಆಗೋಗಿದೆಯೋ ಅಲ್ಲಿ?
ಆಗೋಗಿದೆ.
ಆಗೋಗಿದೆಯಾ?
ಆಗೋಗಿ.
Status quo as it exists today. To be
Grateful.
Number 49. CPN Harish.
Lord, land has been granted, extent of 1 acre 20 gunters. First petitioner applied in the year 1999 for grant of land for his unauthorized occupation, my lord.
What is
the
annexure G?
Annexure G is the order passed by the deputy commissioner, my lord, in my opinion.
Second appeal.
Second appeal.
Challenging grant.
Challenging the order of the assistant commissioner, my lord. The Tahsildar granted in 1 acre 20 gunters of land in favor of the petitioner. That was questioned by the fifth respondent before the assistant commissioner
Grant of
by
regular-
filing an appeal.
Regularization.
Howdu. By filing an appeal, he has questioned that order. Assistant commissioner allowed the appeal and cancelled the grant. Against I preferred an appeal before the.
Why was it cancelled on what ground?
Mainly on the two grounds that I have fenced it and I am disturbing the other cultivators.
On the ground?
Fencing it, I have fenced my land and disturbing the free movement of cattle and other things. Second is I'm holding more extent of land. My family holds about 10 acres of land. That is why I'm not entitled for grant. These are the major two
Was
grounds.
a grant made?
Grant made in the 2013, Miller. I
2013.
applied for in the year 1998,
2013 grant made.
please.
When was it cancelled?
Cancelled in the year 2019,
6 years.
So the appeal is filed after 7 years.
On the ground that you're a sufficient holder.
Yes, because
Basically, the ground
that
that
is
is
not correct, Millard, because for the simple reason, my family owns 6 acres of land that was owned by my father. My father is no more. Now there are 7 legal heirs. I will hardly get only 30 gunters of land. I have produced the genealogical tree
What is
also,
the reasoning of the AC?
please. Millard, it is all the operative portion starts, Millard, from page number 31. The third para from the bottom, ಮೇಲ್ಕಂಡ ವಿಷಯ, ಲಾಸ್ಟ್ got it. ಮೇಲ್ಕಂಡ ಉಪಯುಕ್ತ ವಾದ ವಿವಾದಗಳನ್ನು ಹಾಜರುಪಡಿಸಿದ ದಾಖಲಾತಿಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಹಲವಾರು ವಿಷಯಗಳನ್ನು ತುಲನಾತ್ಮಕ ನೋಡಿದಾಗ ಈ ಕೆಳಗಂಡ ಅಂಶಗಳು ಪರಿಗಣಿಸಬೇಕಾಗಿರುತ್ತದೆ. ಎದುರುದಾರ ಅರ್ಜಿಯನ್ನು 2013-14 ಸಕ್ರಮಗೊಳಿಸಲು ದಿನಾಂಕ 24/11/2001 ತಕರಾರು ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಸದ್ಯ ಅರ್ಜಿಯಲ್ಲಿ ಅರ್ಜಿದಾರನ ಸ್ವಾಧೀನದಲ್ಲಿ ಇಲ್ಲದೆ ಇರುವ ಬಗ್ಗೆ ತಿಳಿಸಿರುತ್ತಾರೆ ಹಾಗೂ ದಿನಾಂಕ 18/7/2019 ಊರಿನ ಗ್ರಾಮಸ್ಥರ ತಕರಾರು ಸಲ್ಲಿಸಿದ್ದು ಸಾರ್ವಜನಿಕ ಓಡಾಡಲು ತೊಂದರೆಯಾಗುವ ರೀತಿಯಲ್ಲಿ ಬೇಲಿ ನಿರ್ಮಿಸುತ್ತಾರೆಂದು ತಮ್ಮ ಪಕ್ಕದ ಜಮೀನನ್ನು ಒತ್ತುವರಿ ಮಾಡಿರುತ್ತಾರೆಂದು ಈಗ ಸಸಿ ಅಡಿಕೆ ನಡೆಯುತ್ತಿರುವ ಬಗ್ಗೆ ತಿಳಿಸಿದ್ದು ಅಂದಿನ ದಿನಗಳು ಫೋಟೋಗಳನ್ನು ಹಾಜರುಪಡಿಸುವುದು ಕಂಡು ಬರುತ್ತದೆ. ಸದ್ಯ ಸಕ್ರಮಾತಿಯ ಖಾತೆ ದಾಖಲು ಮಾಡುವಾಗ ರಾಜೇಶ್ ತಮ್ಮ ವರದಿಯ ದಿನಾಂಕ 30/6/2014 ಮಂಜೂದಾರರು ಅಗತ್ಯಕ್ಕಿಂತ ಹೆಚ್ಚಿನ ಭೂಮಿ ಹೊಂದಿರುವುದು ತಹಶೀಲ್ದಾರ್ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸೂಕ್ತ ಆದೇಶ ಪಡೆಯಬಹುದೆಂದು ವರದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ನಂತರ ತಹಶೀಲ್ದಾರರು ದಿನಾಂಕ 37/2014 108 ಅಡಿಯಲ್ಲಿ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಿ ರದ್ದುಪಡಿಸುವ ಬಗ್ಗೆ ಸೂಕ್ತ ಕ್ರಮಗಳು ವಿಪರಾಧಿಗಳಿಗೆ ಸಲ್ಲಿಸಿರುವುದು ಕಂಡುಬಂದಿರುತ್ತದೆ. ಆದರೆ ಮಂಜೂರಾತಿಯಾಗಿ RTC ನಮೂದು ಮಾಡುವ ಮುನ್ನವೇ ಈ ಪ್ರಕ್ರಿಯೆ ಹಾಗೂ ಮಂಜೂರಾತಿಗೆ ತಕರಾರು ಸಹ 2012 ಇರುವುದು ಕಂಡುಬಂದಿರುತ್ತದೆ. ಆದರೆ ದಿನಾಂಕ 30/7/2014 ರದ್ದತಿಗೆ ಕಳಿಸಿದ ನಂತರ ತಹಶೀಲ್ದಾರ್ LND ಸೋಯನ್ಸೋ ದಿನಾಂಕ MR ಸೋಯನ್ಸೋ ಖಾತೆ ಬದಲಾವಣೆ ಮಾಡಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ದಿನಾಂಕ 30/7/2014 ಅಡಿಯಲ್ಲಿ ರದ್ದತಿಗೆ ಸಲ್ಲಿಸಿದ ನಂತರ LND ನಂಬರ್ ಸೋಯನ್ಸೋ ಅಂತ ಆದೇಶ ಮಾಡಿರುವುದು.
Who's this Sujata?
Is my wife. What has happened? I applied for 1 acre 20 gunters of land.
No, she's got 4 acres.
She has got for it through gift from there.
She got 4 acres, isn't it?
That is in the year 2007, Millard. What has happened is, at the time of applying for,
When your wife gets that 4 acres, you're descendant.
Millard, that
I will
is,
ignore the holding of your family. But this 4 acres you can't get over.
that is Millard. That is what I'm trying to explain. I applied for the grant in the year 1999. At that time, I was not married at all. Subsequently, after marriage,
2013, the grant was made.
please.
Your wife was already holding 4 acres.
Yes, Millard. That is
Then you
through
can't
gift,
grant it.
through gift, Millard. That is what I'm.
Either gift or whatever, you can't.
Yes, that is true, Millard. What I'm submitting is, the application was filed by me for grant for the first petitioner for regularization of his unauthorized occupation. At the time of granting is, my wife's name is included. That is also one of my contentions.
That is the rule. If it is to be granted for
Yes.
regularization, the establishment should in your name and your wife's
Your
name.
wife's name, Millard.
That is the rule.
That is true.
Then how can this be sustained?
Millard, my electrical submission is 2007 is a subsequent acquisition because 1999 is a point for
Prior-
consideration.
Prior to the grant, I don't know.
Millard, in that regard, Millard, the currently see the section 94, Millard. What as it says,
As may be prescribed, Tane. As may be
As
prescribed.
may be prescribed, the
The rules
provided
prescribe-
further that no land shall be granted in the area lying within the limit of cities and city municipality respect in call number, that is provided that the land so granted together with the land already held by such persons shall not exceed 2 hectares of B class land. That is almost 4 acres banbadate. Even if that is considered millat, I will be entitled for that. And so far as the family is concerned, there are so many other legal heirs that has been ancestral property. This millat may recognize the whether as on the date of application for regularization of grant, whether such land was available.
2
for
hectares
grant.
ಅಂದ್ರೆ 4 acres ಚಿಲ್ಲರೆ ಆಗುತ್ತೆ.
ಹೌದು.
Less than 4 acres, 3 guntas?
2 acres.
But even there is no order to condone the delay, milord. After 7 years, the appeal is filed. No delay application, there is no order to condone the delay at all. In the order of the Assistant Commissioner, it is silent. And that is one of the grounds made out by me in the before the Deputy Commissioner. No finding on that. Lord, I am relying upon a decision of the Sambal Court, my lord. If I am entitled for grant, that should be the consideration.
Now, you proceedings initiated because of his attitude.
Yes. I rely upon a decision of,
So, my lord, this appeal, first appeal bill 49A. Second
ನೀವು
appeal.
ವಿಲೇಜರ್ಸ್ ತಾನೆ?
Land granted.
Land which was granted by of regularizing the occupation of the unauthorized official petitioner was called in question by filing an appeal. In the appeal, the Assistant Commissioner has set aside the grant on the ground that the petitioner was causing inconvenience to the residents, and also on the ground that the wife of the petitioner was gifted 4 acres, 3 guntas in the year 2007. And the family of the petitioner also owned 6 acres, and consequently the petitioner would be dissented. In the order of the Assistant Commissioner, it has been stated as follows. Thirty-three alva?
33.
ವರದಿ ಬಂದಿರುವುದಿಲ್ಲ ಅಂತ. As could be seen from the above, though the Assistant Commissioner had called for a report from the Tahsildar, even before the report could be furnished, he has proceeded to allow the appeal and has set aside the order of regularization passed in favor of the petitioner. This order has been confirmed by the Deputy Commissioner. In my view, in the light of the fact that the Assistant Commissioner had passed the order even before he received report from the Tahsildar, would vitiate the order passed by him. Consequently, I had to set aside. It is to be also noticed here that the family of the petitioner consisted of 7 sons, 6
Hello.
sons.
Father, mother and 6 daughters, 6 children, 7 total sons.
The petitioner consisted of his mother and 6 siblings, and they together owned 6 acres.
ಹೌದು, 6 acres.
And the petitioner would therefore not have the entitlement to claim the entire 6 acres, and at best he could claim 1/7 share in the said property. It is also to be noticed here that the petitioner's wife has also been gifted only 4 acres, 3 guntas. And if both these factors are taken into consideration, if the Tahsildar finds that the holding of the petitioner's wife and the petitioner pursuant to partition is less than 2 hectares, it is obvious that the order of grant cannot be cancelled. If however, the extent held by the petitioner as far as his share and that of his wife on receipt of a report of the Tahsildar is found to be inadequate, the grant should not be cancelled. Subject to the above observation, the writ petition is allowed and the matter is remanded to trial court.
Re-inquiry remand the matter if it is the complete. set aside the order, my lord.
Remanding it,
And this reason mentioned by the assistant commissioner and deputy commissioner, and also first of all, my lord, this petition is not maintainable. The first appeal filed at 649, second appeal filed at 50. Division. Instead of maintaining the tribunal division, they are filed in petition. And my lord, they are, because of this order, having sufficient land. As per the 94A, that is also mentioned, they were able to access my lord.
yes.
The inquiry has been conducted, the inquiry before, but at the time of filing the application as well as before the.
ಬಿಡಿ ಒಂದ್ ಎಕರೆನೂ ಬರಲ್ಲ, ಅದು ಯಾಕೆ ನೀವು ಸುಮ್ನೆ ಈ ಒಂದ್ ಎಕರೆನೂ ಬರಲ್ಲ ಭಾಗ ಆದ್ರೆ ಅವ್ನಿಗೆ.
ಇಲ್ಲ, 10 ಎಕರೆ ಮೇಲಿದೆ ಅಂತ ಫೈಂಡ್.
ಅದೇ ಅವ್ರ ಸಂಸಾರಕ್ಕೆ 6 ಎಕರೆ, ಅವ್ರ ಹೆಂಡತಿಗೆ 4 ಎಕರೆ.
ಮುಂದೆ ಹೋಗಿ ಡೀಟೇಲ್ಸ್ ಪ್ರೊವೈಡ್ ಮಾಡಬೇಕಾಗಿದೆ.
ಅವ್ರ ರಿಪೋರ್ಟಿಗೆ ವೇಟ್ ಮಾಡ್ಲಿಲ್ವಲ್ಲ ತಹಸೀಲ್ದಾರ.
ಇಲ್ಲ, ಅವರೇ ಕೊಟ್ಟಿಲ್ಲ, ಖಂಡಿತ ಅದನ್ನೇ ಫೈಂಡಿಂಗ್ ಆಫ್ ದ.
ಅದಕ್ಕೆ ನಾನು ರಿಪೋರ್ಟ್ ತರ್ಸ್ಕೊಂಡು ಆರ್ಡರ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರೆ ಐ ಮೇಡ್ ಅನ್ ಅಬ್ಸರ್ವೇಷನ್.
That is clarified and inquiry means that is similar. If they have.
That's what I've said.
Or not.
I've said he will
And also similar, the land grant ತಗೊಂಡಿದ್ದಾರೆ, okay, ಆದ್ರೆ they are troubling to the public or villagers.
He
They
will,
are not providing to the.
that can't be. Show me which rule provides for cancelling the grant if they are troubling the villagers.
In the absence of the villagers, it is inquiry can be conducted.
ರೂಲ್ ತೋರಿಸಿ ನೀವು ಒಂದ್ ಗಲಾಟೆ ಮಾಡ್ತಾರೆ, ಗ್ರಾಂಟ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಕ್ಕಾಗುತ್ತಾ?
Villagers ಗೆ trouble easy matter rights ಅಲ್ಲಿ ಹೋಗ್ಬೇಕಾಯ್ತು, ಅವ್ರ they made it sufficient.
ಆಯ್ತು, ಇವಾಗ
Interest of villagers.
ಅಲ್ಲ, ಇವಾಗ ಬೇಲಿ ತೆಗ್ಸಾಕ್ಬಿಟ್ರೆ ನೀವು ವಿಡ್ರಾ ಮಾಡ್ತೀರಾ ಅಪೀಲ್ನ?
ಈ ಎನ್ಕ್ವೈರಿ ಮಾಡಿ
ನೋಡ್ರಿ,
jurisdiction of the estate commissioner will act. It is Tahsildar sufficiently obtained.
you are forcing me to give a finding that the pinpricks that is given to the villagers cannot be a ground to set aside the grant.
That is the case of, if they are not allowing, they are not troubling to the villagers. There is no any objection to the villagers also. The intention, they are not allowing any villagers to reach the river ಮೇಲೆ. ಹಸುಗಳಿಂದ ತಗೊಂಡೋಗ್ತಾ ಇಲ್ಲ, ಪ್ರಾಣಿಗಳಿಂದ ತಗೊಂಡು ನೀರು ಹೋಗ್ತಾ ಇಲ್ಲ, ಎಂಟೆ ಡೈಲಿ ಹಾಕೊಂಡು ಒಬ್ಬನು ಬಿಡ್ತಾ ಇಲ್ಲ ಅವರು. That is the problem to the villagers.
ನಿಮ್ಗೆ ಏನ್ ಬೇಕು ಇವಾಗ?
ನಮಗೆ free access into the river.
Free access to.
ನಾವು ಒಳಗೆ ಎತ್ತುಗಳನ್ನ ಗಾಡಿಗಳನ್ನ ಹೋಗಿ ತಗೊಳಕ್ ಬಿಡ್ತಾ ಇಲ್ಲ ಯಾರು villagers ನ. Because of enemy of the grant of this land.
Not that there is a main road, my lord, next.
File an affidavit that you will not cause an impediment
Please,
for
please,
them
I will-
to have access.
File it, I will file it,
I'll keep this order pending,
please,
file the affidavit.
file affidavit, grant affidavit,
Indicating a sketch. I'll keep that on record and take note of the fact
please,
that he has no objection now in view of the affidavit.
please,
Serena,
I will file affidavit,
after tomorrow, file the affidavit.
please,
You should indicate a sketch, the way of access to the villagers.
Please.
Then I will record his submission that he has no objection.
please. And 3 days time, ಯಾಕಂದ್ರೆ ತೀರ್ಥಹಳ್ಳಿಯಿಂದ ಬರ್ಬೇಕು, communicate ಮಾಡ್ತಾರೆ,
Order type ಮಾಡಿ, order type.
please, will file affidavit.
Bill number 50.
Let I pay for the petitioner's note.
Now they have served this copy on me, just not even a minute. However, on the facts of the case, I'll make my submission.
Fake grant.
Allegation is that, my lords. Lord, since they wanted to repeat the same again, I seek the leave of this honorable court to place another set of recently obtained certified copy from the office of the Tahsildar concerned.
What is the
from
prayer in
where-
this writ petition? Now, what is the prayer in the writ petition?
Their allegation is that my grant records itself is fake.
No, no, what is the challenge in the writ petition?
Not the writ petition, I have challenged annexed M, where an order came to be passed by the deputy commissioner, granting a lease in favor of the respondent number
Page
4.
number?
My lord, annexed M, page 163, my lords, please. Page 163. An extent of 7 acres of land is leased in favor of respondent number 4, an association. My lord, that they wanted to claim the portion of the land which is granted in our favor, as if allotted to them, they are making a claim. So I had no other option except to.
Please write annexed M.
My lord, annexed M, my lords, please. May I read from the beginning, my lords, please?
ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ
Adesha ಅಂತಿದೆ, some page number 164, if I am permitted, the particular portion of the order. Operating. They have referred survey number. They did not say which is the extent of the land.
ರಾಷ್ಟ್ರೀಯ ದರ್ಜೆಯ ಟೆನ್ನಿಸ್ ಕ್ರೀಡಾಂಗಣ ನೀವು. This was granted to the market committee.
First APMC market ಮಾಡಿದ್ರು sir.
The total extent is around
62 acres, 32 guntas.
Out of which, 22 acres, 24 guntas, 13 grants have been made. And for Asha scheme, 3 acres. What is remaining is around 17 acres, out of which 7 acres have been given to the respondent number 4.
No, in this page number 163, 27 ಎಕರೆ 23 ಗುಂಟೆ ಜಮೀನಿನ ಪೈಕಿ 7 ಎಕರೆ ಜಮೀನು ಕೃಷಿ ಉತ್ಪನ್ನ ಮಾರುಕಟ್ಟೆ ಸಮಿತಿ ವರೆಗೆ ಮಂಜೂರು ಮಾಡಲಾಗಿದ್ದು, ಆದರೆ ಸದರಿ ಸಮಿತಿಯ ಇದುವರೆಗೂ ಯಾವುದೇ ಮೊತ್ತವನ್ನು ಪಾವತಿಸಲಿಲ್ಲ ಕಾರಣ ಸದರಿ ಮಂಜೂರಾತಿಯನ್ನು ರದ್ದುಪಡಿಸಿ
136 class 2 proceedings are there against them.
in favor of the market committee.
No, this was proposed, my lord. I opposed and it is stopped. Then this order is passed. There was a proposal, my lord. I filed my objections.
ಯಾವ ವರ್ಷದಲ್ಲಿ?
Swami,
ಯಾವ
may I
ವರ್ಷದಲ್ಲಿ?
kindly peruse my objections.
ನನಗೆ ವರ್ಷ ಹೇಳಿ ಸಾಕು. Which year was it proposed?
It was in the last year, before last year, my lord. I submitted objection statements in 2020, just prior
2020.
house. And on stopping that on the objection submitted by me, they proposed this and order came to be passed. But they wanted to make an allegation as if grant is not made to me, my lord.
Your basic argument is that this land is already granted to you.
But this is already granted to me. And my lord, even sketch is also, my lord, I
Number
produced.
19.
Please.
So number 19.
Yes, ma'am.
What is the total extent Britishers are claiming?
My lord, the land is granted 14 acres of land in favor of 4 persons.
Seven people.
Please, ma'am.
6.
May I take my lord's kind attention?
4 people.
4 people.
3 acres, 20 to 2 people and another extent of
4 acres and 3 acres.
Together 14 acres.
14 acres.
When was it granted to you?
My lord, may I kindly peruse the proceedings, my lords, please. Applications are submitted as per Annexure B, my lords.
Page?
4 persons, my lord. Page number, it commences in page number 26, my lords. Please. Annexure B series, my lord. My lord, these applications as unauthorized cultivators, my lord. Then, my lord, these applications, my lord, a sketch came to be prepared, my lord. Kindly peruse at page number 34, my lord.
ಇಲ್ಲ ಯಾವತ್ತು ಅಪ್ಲಿಕೇಶನ್ ಯಾವಾಗ ಹಾಕಿದ್ರೆ ನೀವು ಡೇಟ್ ಇದೆಯಾ?
Some date ಇಲ್ಲ ಇದರಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ ರೆಫರೆನ್ಸಸ್ ಎಲ್ಲ ಏನು ಆರ್ಡರ್ಸ್ ನಲ್ಲಿ ಇವೆ ಸ್ವಾಮಿ ಆರ್ಡರ್ಸ್ ನಲ್ಲಿ ಇವೆ ಆರ್ಡರ್ಸ್ ನಲ್ಲಿ some this sketch came to be prepared as at page number 34 annexure C, my lords, please. On the base thereafter, my lord, the Tahsildar has recommended and submitted the applications concerned to the, my lord, page 38 kindly annexure C, page 1, page 38. My lord, Tahsildar has
Where
recommended.
is the OM? Where is the official memorandum?
Please, I'll come, my lord. I'll take my lords. My lord, page 38, my lord, annexure C. On 10/1/1978, he recommended to,
Please read the order.
Swami, page number 38, Swami.
Please read the order.
Please, my lord, order is, I'll come to my lord. Annexure D, assistant commissioner, who recommended to the deputy commissioner. Then, my lord, deputy commissioner has recommended as per annexure E to the divisional commissioner for detaching this 14 acres of land from Gomal. On, in presence of this order, my lord, as per annexure F, my lord, page 42, an order came to be passed by the deputy commissioner granting the land. Then, my lord, as per page number 44, F1, the Tahsildar has called upon us to pay the upset price amount, my lord. So we have paid the amount. Thereafterwards, the grant certificates are issued in our favor.
Where have you paid the amount?
My lord, at page number, one minute, my lord. It commences in page number 48.
48.
48, my lord. That is in pursuance of the letters at page number 44 in the 4 demand notices are there, on the basis of which I paid the amount. We all 4 paid the amount.
Pursuant to this order of the year 70.
Thereafterwards, my lord, grant certificates were issued as per page 54, annexure F9, my lords, please. F9 to 12, my lord. 4, in all 4 they have issued. My lord, in pursuance of these things, my lord, an application was submitted for transfer of Kata. A report is also called for from the concerned revenue inspector by the Tahsildar.
MR ಆಯ್ತಾ?
ಸ್ವಾಮಿ, MR ಆಗ್ಲಿಲ್ಲ ನಮ್ಗೆ. ಅದಕ್ಕೆ we made an application in 2012.
79
Proceedings.
79 grand for 11 years you didn't do anything.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಮಾಡಿರ್ಲಿಲ್ಲ. Then those proceed, my lord, please, kindly permit me. Sir, senior, sir, please. In pursuance of that, since they have not considered my application, I have also filed writ petition before this honorable court. That writ petition came to be disposed of with a direction to me file a fresh application also. Those proceedings are also pending. A report was called upon, kindly peruse at page number 92, my lord, please. Page number 92.
This grant was made by regularizing your unauthorized occupation.
Regularizing unauthorized occupation.
Under which section they are?
My lord, in 1971, regularization unauthorized act is there, my lord. Those things are referred to in the order passed by the deputy commissioner and also passed. Yes, sir.
Yeah.
There was a provision by,
ಯಾವ section ತೋರಿಸಿ?
my lords, please. Kindly peruse the assistant commissioner. Circulars are referred therein, my lord. Regularization of unauthorized, page number 39, annexure D. In assistant commissioner's recommendation to the deputy commissioner, my lord. Kindly peruse. Regularization of unauthorized cultivation of the government land in survey number 19 of Timsandra village, Chikjala, Hobli, Devanalli Taluk. So government order number 105 LG 77 of 1977, then circulars. My lord, there was an order for regularization and the lands are granted, my lord, in the similar manner. Not only to me, for several persons in the state, lands are regularized. It is not subsequent of 1991 only GO, my lord, under section 94A. Prior to that itself, my lord, regularization of unauthorized cultivation.
When was the first amendment made to section 94?
My lord, it was in in presence of these circulars prior to 1977 itself, these things. Prior to that. Let them clarify if any such doubts regarding this, my lord. Let the state clarify. Absolutely, I am not here, my lord, because they wanted to make these allegations against me, though the land is granted. So that only, my lord, I obtained once again the certified copies from the office of the Tahsildar and I provided a set of copy to the other side. And I have got certified copies, my lords, please, which are provided under RTA to me, my lord.
So from 78, your name is not there.
My lords, please.
From 78, your name
It
is
was
not.
not, it was not. My lord, in fact, my lord, in 1964 itself, my lord, annexure A. Then unauthorized cultivation get the names to reference is 64 ga itto. But the thing is, it is not being continued. Applications are filed, sought for grant of the land, and proceedings are also initiated, my lord. All these proceedings are by the revenue authorities in accordance with law, my lord. And even before grant of the land, my lord, and this order of divisional commissioner may kindly be perused, my lords, please. Divisional commissioner order at annexure E, page 41, my lords, please.
Reducing the Gomar land.
My lords, please.
Reducing the Gomar extent.
Please, my lord. Lord, in this, my lord, it is referred in the, under rule 97, clause 4 of the Karnataka Land Revenue Rules 1966. The special deputy commissioner, Bangalore district, is permitted to reduce the extent of 14 acres of only land out of survey number 19 of Timsandra village, Chikjala, Hobli, so and so. Thereafter, only grant order is made by.
In the entire extent of 67 acres,
At 62 acres, 32 good task.
only 4 people with unauthorized occupation.
No, these 4 peoples were in occupation and they are granted. There are several other persons, my lord. I produced at page number 166 in that. Several other persons' names are illegally entered there. Without
ಅವ್ರಿಗೆ order ಆಗ್ಲಿಲ್ಲ.
some the grant till now, you know, and they have to say, I have no connected to them, my lord.
No, normally in the village, Gomar land, everybody will occupy. But here only 4 people occupied and got the.
No, my lord, not permitted, my lord. We applied for grant, my lord. I am not saying that others are not there and others should not be granted, my lord. It is not my case, my lord. We have only applied for grant. Our the applications are considered is my humble submission. So the other persons' names are there, what the government says, and also there is a reference under section 136 clause 2 for entry of their names without there being any records or what they wanted to say. Proceedings are pending against them. Against me concerned,
What was your objection to the APMC grant?
please, my lord.
You said APMC, they had granted this very land.
Ah.
What was your objections raised?
No, my lord, my portion of land, because my kindly perish the sketch, my lords,
Year
please.
2020,
Huh.
they decided to grant it to APMC.
APMC, 7 acres.
What was your objections to that?
My lord, my objection is that kindly perish annexure C for a moment.
Next,
Let them say, if this is not the portion, my lord, I will not come in.
ಅಲ್ಲ,
Annexure C, my lord.
APMC ಅವ್ರು ಗ್ರಾಂಟ್ ಮಾಡಿದಾಗ
ನಮ್ಗೆ ಗ್ರಾಂಟ್ ಆಗಿದೆ ಅಂತ.
APMC ಅವ್ರು ಗ್ರಾಂಟ್ ಮಾಡಾದ್ಮೇಲೆ
ಹೌದು.
ನೀವು ತಕರಾರು ಬರ್ಸ್ತೀರಿ ಅಂತ ಹೇಳಿದ್ರಿ ನೀವು.
ಹೌದು ಸರ್.
What is the, where are the objections?
Yeah, I have produced, my lord.
Where?
I have produced, my lord. May kindly peruse page 138, my lord.
One,
138, a legal notice was also issued. And parties have also in person they have given. One minute, my lord, page 109, my lord. Sorry, annexure K, page 109. On this basis only, it is for the government, my lords. But my objections were there, my lord. This land is granted to me. And annexure C discloses the portion of the land granted to us, my lord. Where survey was also conducted, sketch was prepared for grant of the land, my lord, before issuing the grant certificate to us, my lord.
ಇದರಲ್ಲಿ APMC ನೀವೇನ್ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ ಇದ್ರ ಅಬ್ಜೆಕ್ಷನ್?
ಚಾಲೆಂಜ್ ಅವ್ರು ಚಾಲೆಂಜ್ ಮಾಡ್ಲಿಲ್ಲ.
ಇಲ್ಲ, ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದ್ರ ಅದಕ್ಕೆ?
ಅಷ್ಟೇ ನಾವು ತಕರಾರು ಹಾಕಿದ್ವಿ, ಅಷ್ಟಕ್ಕೆ ಸೈಲೆಂಟ್.
ಆ ತಕರಾರು ಎಲ್ಲಿದೆ? ಇದು ಬರೀ
My lord, please 1 minute. I'll come. My lord, kindly peruse at page number 109, annexure K, connecting to continuation page number 111, para 8, my lord, please. My clients further instructs
131.
some page, Allah 111, 111,
So that's
para
it.
8.
That's your only case, grant ಆಗಿದೆ ಅಂತ.
ನಮ್ಗೆ ಗ್ರಾಂಟ್ ಆಗಿದೆ ಅಂತ ಅಷ್ಟೇ ನಾನು ಬೇರೆ ಅರ್ಥ ಇಲ್ಲ. ನನ್ಗೆ ಗ್ರಾಂಟ್ ಆಗಿದೆ ಕೊಡಬೇಡಿ ಅಂದೆ. I am not saying anything else, my lord. It is not my case. And here also, my lord, please. One minute, kindly peruse annexure C for a moment, my lord. Annexure C. If they do not, they are not allotting this portion of the property, which is along with at the time of grant, which is prepared this sketch, my lord. Page number 34, my lord. So, my lord, these portions of 4, 1, 2, 3, 4 are granted as my lord. So now the fourth respondent is claiming, ಇಲ್ಲಿ ನಮ್ಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಡಿಸ್ಟರ್ಬ್ ಮಾಡಿದ್ದಕ್ಕೆ ನಾವು ಬಂದಿದ್ವಿ. ಅವ್ರು ಗ್ರಾಂಟ್ ಮಾಡೋದಕ್ಕೆ ಬೇರೆ ಲ್ಯಾಂಡ್ ನಂದೇನು I have no objection.
Only if the land is granted to you will the grant be invalid.
Excluding that, they can give it to all.
Only if the grant in your favor is valid, will that grant be invalid?
My lord, that will be, if this portion is given,
Your
it will
grant-
be overlapped, my lord.
If your grant is found to be invalid or fake, then you can't question their grant.
Definitely, my lord, if my grant is not there, my lord, definitely, my lord, if my grant is invalid, my claim itself will be not correct.
Let us see how they.
Let them make submission.
Out of the total extent of 62 acres, 39 guntas, which is Roman land,
62 acres, 39.
39 guntas. 42 acres, 24 guntas has been granted to 42 acres, 24 guntas has been granted to 13 people, Mala, on 14th March 1979 and 27th April 1979. And this is the original file, Mala, and all the grants are in a common order, that is 7 grants plus 5 grants. If your lordship sees in these
14,379, 7 grants, huh?
7 grants and 27/4/1979, balance 6 grants.
Their names are not there in this.
Their names are not there in this. What surprisingly comes now, suddenly from AC office to the Tahsildar office, new file comes now, as if 4 separate grants have been made in these people. That is how this file comes, and Right to Information Act, they apply and say that yes, the file is with you. They don't have the original at all, no grant at all.
Original ilva ನಿಮ್ಮ ಹತ್ರ?
Original, I'll have to inquire, my lord, because your dispute ಮಾಡ್ತಾ ಇದ್ದಿದ್ರಿಂದ certified copies, I'll inquire, my lord. My claim. I'll- my lord-
Common grant, when a grant is passed in 14/3/1979, for all 7, one single grant is there.
Original.
Here, separate grant order comes on the same day. And a file is built up.
My lord, it is a,
No, let me complete kindly.
please,
You can reply.
please.
Your Lordship, may kindly see the grant orders which have been made. First of all, my lord, what is given for the fourth respondent with a lease for a period of 30 years, he cannot challenge because he is not in possession, no schedule is mentioned in his grant order. So no revenue record, the receipt is there, payment is not there. So therefore, my lord, they cleverly created document, but there's no corresponding to show that they're actually in our records, man. Either payment, mutation, possession, RTC, nothing, even as on this day, except for this taxpayer receipt, nothing. And the writ petition has also been dismissed by this court now, which they earlier approached before this honorable court for change of mutation. That has been dismissed with the liberty to give representation. After that, nothing has happened.
You're saying is only 12 grants were made. Nothing.
13 were made. 13 grants for 42 acres. Plus for Asha scheme, another 3 acres, 2 guntas have been given. Now 7 acres to the respondent number 4, my lords. And what is remaining as on today is 10 acres, 16 guntas. 10 acres, 16 guntas. What the
10 acres?
16 guntas as on today, what is remaining? So therefore,
This is vacant land or?
vacant.
Show me the file.
This is the file.
Originally,
But I inquired them, they are having originals also.
produce it.
My party, I'll place,
This is the original record of the 62
my,
acres.
I just inquired with,
This is the original record of 62 acres. This is the record file which my learned friend relies upon, under which they have taken Right to Information Act.
they are in the house of the party succession. In a place that I'll produce before.
ನಿಮ್ಗೆಲ್ಲ ಇದು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ರಿ.
Certified copies, originals ಇದೆಯಂತೆ ಅದನ್ನು produce.
Usually what they do, giving to understand, they'll they'll keep in the file, one parallel, they would have created. What is important is the nature of receipt during the same period of time, application which has been filed. And also compare the two applications, which is all the 13 people whom you favor land grant has been
This
made.
is the original grant.
This is the original in respect of all 13
And
people.
this file is available.
Separate file insofar as this 4 petitioner for 14 acres is concerned.
Where was this file?
Manoj, recently it has come to the file of the Tahsildar. It is there.
This is not there in the office of DC, DVC,
No,
because he must have reduced this extent. He
no,
must have maintained a file, there isn't it?
there's no file at all, except for this file, Manoj. In the Tahsildar office, there's no coordinating file at all in AC or DC's office. And as well, Lordship, from 1978, no mutation, no revenue for RTC, taxpayer receipt, nothing. Except for a writ petition which came to be filed for a direction to change the entry in the year 2000.
Where is the order of the visual commissioner here? Reducing the extent? Oh, he produced one.
But I produced along with writ petition, so also now the RTI documents which they have issued, my lord. That my divisional commissioner order, page number 42, my lords, please annex
The
area.
original record that is not there.
No, this LND SR 238/78-79 is not available.
LND SR 638 of 78-79, my lord. It is the divisional commissioner order.
Not, such a thing is not available.
My lord. With kind leave, my lords,
Once
please.
they pass this order, they make a corresponding entry in the extent of government land available in another register.
So in that file, we have all 62 acres has been done, all bifurcation, sub-bifurcation is maintained. In the original record, this file, Manoj, that is not corresponding, forthcoming.
ultimately, well, the question is the petitioner, from the into grant order doesn't show where the land is situated except for what my learning friend says, this is the sketch which it has to come there. And your worship may kindly verify the signature between the, during the same period with the Tahsildar and the.
No, this file is also not available with the survey of department because they'll have to prepare.
Not there, except for this file in the Tahsildar, I verified, cross verified, no, the files are not available or corresponding document entered in nowhere else.
My lords, please.
ಇಲ್ಲ ಗ್ರಾಂಟ್ ಆದ್ಮೇಲೆ ದುರಸ್ತಿಗೆ ಸರ್ವೆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಫೈಲ್ ಕಳಿಸ್ತಿರ್ತಾನೆ.
So definitely, my lord, there will be a record in the office of the divisional commissioner.
If there is no record anywhere
My
except
lords,
this particular
My
file
lords, please, my
for
humble,
which you obtained the certificate. copies.
my humble submission, my lords, please. All correspondences and orders are being made by the competent authorities. My lord, how I can have such a original document and give it to the office?
Let us see the original grant certificate that you have
And I'll place it. Kindly,
tomorrow.
kindly,
I have it tomorrow.
please. If it is placed by somebody, my lord, if it is placed by somebody, my lord, spirit, the office cannot have such originals with them, my lord.
Because if they have to prepare a sketch,
How could it be?
if they have to prepare a sketch pursuant to an order of grant,
Please.
there must be a parallel file built up by them also.
Definitely, my lord. It starts from the office of the Tahsildar, it would go up to divisional commissioner, my lord. I am not disputing that aspect. It should be there, my lord.
ಏನು
And
ಮಾಡ್ತಾರೆ?
entries will be there, my lord.
ಎಲ್ಲೂ ನಿಮ್ ಫೈಲ್ ನಿಮ್ಮ ತಹಸೀಲ್ದಾರ್ ಆಫೀಸರ್ ಬಿಟ್ರೆ ಎಲ್ಲೂ ಇಲ್ಲ ಅಂತಂದ್ರೆ ಏನ್ ಅರ್ಥ?
ಒಂದು ನಾನು ಹೇಳಲ್ಲ, ಸರ್ಕಾರ ನಮ್ಮದು ಆಸ್ತಿ ಗ್ರಾಂಟ್ ಮಾಡಿಲ್ಲ ಅನ್ನೋ ನಾನು ಏನು ಮಾತಾಡ್ಲಾರ ಇಲ್ಲಿ. Whatever is there, they only producing.
They are saying that they have granted to 13 people with this very survey number. That record indicates a completely different procedure. For 4 of you, there is separate procedure and no corresponding file.
But my lord, I cannot say how they are going to maintain the files also, my lord. Whatever is the certificate copies and whatever the documents placed to me, my lords, please.
Produce the
I could able to make my humble submission.
Tomorrow, the original is
Please.
produced.
Nade. My lord, please, they have to do.
Interim order.
Kindly extend the interim order, my lord.
More continue to.
How was?
Silver 51.
Next, M.
One, my lord, they are aggrieved by the order at annexure M. One. How long will you take? About 40 minutes, I'll have to go. There, in the how long will you take? Take about 20 minutes, 25 minutes.
Not convenient, sir, I will accommodate, no problem. If not convenient, I'll.
First, I'll have to go.
This is a notice asking you to be present for a survey.
Yes, my lord.
I will not oppose, make a request.
This, my lord, is the subject matter of, my lord, several litigations. I'll point out all that. We have produced all that.
You don't want a survey to be conducted.
No, my lord. This is, my lord, the devious method of overcoming, my lord, all the earlier orders. I'll point out suits filed, writ petitions filed, other writ petitions filed, orders passed. Point out all that.
There is any in respect of this matter, my lord, this particular property as is numbered, survey number 11. If there is any litigation in respect of the property, I will not do market.
Point out all that.
Yes.
Only thing is, my lord, I'll have to leave at 4:45, my lord. My difficulty is I'll have to catch a flight.
Your choice. If you want to read today, tomorrow.
26th ಆಗ್ಬೋದಾ? 26. Sorry. All that.
Interim order may be extended.
Silver 52.
Interim order may be extended. Please.
Number 52.
Number 53, MS Vardarajan.
Here for the private respondent number. Sorry. Here for injunction on 1812. An order passed by this court based on the undertaking given by him. 1812-2024. I filed this application for injunction because he was attempting to put up construction in the land in question. Therefore, this IA may not survive anymore. Matter may have to be heard for final.
There is a remand order by your lordship in respect of the very same land, which the petitioner claims to have filed for number 7. That is now pending, my lord, and notice has also been issued, and today the matter is district court, which I am told.
So this writ petition may be posted for final
What are you challenging here?
sometime next week.
The order of the deputy commissioner whereby your lordship, with reference to your lordship's order, it has refused to entertain a petition for reconsideration. Throughout, my lord, he wants entry to be made in his favor, and he files a different suits, my lord, and suit is also dismissed. And latest suit is also pending. This is the order passed by your lordship, my lord, remanding the matter to the land tribunal for fresh consideration.
So you have no order in your favor now?
No.
But the question is this, if I am shown in the revenue entries as the tenant, cultivating tenant of the land for considerable time. Let's see, is a
Was your
regrant
name-
under the
Was your
KBOA.
name- was your name entered pursuant to the order of the land tribunal?
Pardon, Miller?
Was your name entered pursuant to the order of the land tribunal?
Regrant order.
So until
Let's the regrant order is of the year 84. Then he moves the Tahsildar in the year 2006, 2007, that is 22 years later.
no, if the
When the
order,
matter is pending before the land tribunal,
the order of regrant goes,
84.
if the order of regrant goes,
Regrant?
if the order of regrant has been set aside,
No, no,
And
no.
the matter is
That's the
still
order of regrant is not challenging. That's I am a tenant under him. That is the claim.
your claim
As a tenant.
tenancy is now not yet granted.
No.
It is still pending consideration.
No, no, I mean, the regrant under the KBOA Act is complete. He is regranted the land. Now I am claiming, I filed farm number 7, claiming to be a tenant under him.
Until that application is granted,
Yeah.
your name can't come in the records.
The question is this, Millets, if my name continuously appeared, Millets appointed date, Millets, the revenue entries on that date, Millets decides the fate.
I will not touch,
Farm number, avatu ನನ್ನ ಹೆಸರು ಇತ್ತು.
I will not touch column 12, column number 9. You cannot get your name entered there, but for an order of the land tribunal.
Anyway, a matter may be called next week, Millets. I'll get ready for final.
ಅಷ್ಟೇ ಅಲ್ವಾ, why should I give this
ಅಲ್ಲ,
pending?
ಅಷ್ಟೇ final disposal ready ಆಗ್ತೀನಿ. Next week.
ಇನ್ನೇನಿದೆ ನೀವು ಲ್ಯಾಂಡ್ ಗೆದ್ರೆ ಆಟೋಮೆಟಿಕ್ ಬರುತ್ತಲ್ಲ.
Next week ಮಾಡ್ತೀನಿ. ಆರ್ಡ್ಸ್ ಬಂದಿತ್ತು ಅಂತ ಹೇಳಿ ಕಾನ್ಸಂಟ್ರೇಟ್. ಫೈನಲ್ ಡಿಸ್ಪೋಸಲ್ ಬರ್ಲಿ, ಅದು ನಾನು ರೆಡಿ ಆಗ್ತೀನಿ.
ಇದೇ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಬರುತ್ತೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಇದೇ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಬರುತ್ತೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ವೆರಿ ವೆಲ್.
24th.
ಇಲ್ದೆ ನಾ ಇಂಟ್ರಿ ಮಾಡ್ರು ಒಂದು ಎಕ್ಸ್ಟೆಂಡ್.
ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಏನಂತಂದ್ರೆ
1812.
You will not,
they said that I would be putting up some kind of.
you will not put up for the construction ಇದೆಯಲ್ಲ.
ಅಲ್ಲ, ಇದೆ ಅದು actually.
ಅದಿದೆ. That may be extended till next week.
Undertaking given on 18/12/2024, not to do further construction, shall stand extended till the next date of.
Number 54, B.R. Vishwanath.
Survey number 40, my lord. And Gopalappa and Venkatramappa, each were allotted. ಅದು ಒರಿಜಿನಲ್ ಇದು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಮೆಮೋ ಹಾಕ್ತೀನಿ.
Original ಇಲ್ಲ, certified ಇಲ್ಲ.
ಅಲ್ಲ, ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಆಫ್ ದಿ ಆರ್ಡರ್. ಅದಿದೆ ಬೇಕು. ಐ ವಿಲ್ ಫೈಲ್ along with a memo, my lord. I thought my learned friend is ready on merits. ಇದೆರಡು ಇದೆ.
Readyನಾ?
ಇದೊಂದು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ.
Let my friend produce it, then the application for dispensation is allowed.
ನಾವು ರೆಡಿ ಅಂದ್ರಲ್ಲ, ಅದಕ್ಕೆ ನಾನು ಶುರು ಮಾಡಿದೆ, ಸಾರಿ.
Number 55, Shri Chandrasekhar HP. Second April. Shri Chandrasekhar HP.
I am appearing for the petitioner's counsel. The name of the petitioner, my lord,
Who's
the
opposing?
record of rights, my lord, was removed.
Readyನಾ ಇದು?
As per the direction of the forest department.
Document to indicate that not
What is the prayer in the writ petition?
Blood, they have removed, entered the name of forest department, my lord, by removing my name, saying that it is a forest land. But there are no notification, nothing to show that, my lord, there is a notification saying that it is declared as a forest land.
That's the document that I found, but it indicates that in the year 1937, Lord, that 12 June 37, page number 9, Lord,
How was his name entered?
that was in
2004 letter, now they want to remove.
the last round of indication made the next adjustment, Lord, wherein instead of indicating that this was in reserve forest, there seems to be an submission made that this was in deep forest. Based on this, the honorable court, bench,
His name was there in the RTC, isn't it, Banu?
no, sir.
For how long was it in his name?
I produced the RTC, my lord.
So right from 1937, the land.
Except, for how long was his name standing in the revenue records?
2004 ವರೆಗೆ.
When the RTC entries were manually made, his name was taken out.
How many years?
2002 ವರೆಗೆ. Now RTC produce ಮಾಡಿದ್ದೀನಿ. I have produced the copy of the RTC.
Because if his name has been entered pursuant to a valid mutation order, it's continued for a sufficient long period of time.
Case of contention is manually, when there was,
How many years? One दिन.
I had to verify, not said, not want.
ಇಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ ನಾನು RTC.
ಅವ್ರು ಸಮಾಧಾನ ಮಾಡ್ಕೊಂಡಿದ್ರು.
ಅಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ ಅದಕ್ಕೆ ಒಂದು ಟೈಮ್ ತಗೊಂಡ್ರು.
If there is a valid order of mutation, the only way that can be set aside is by recourse to an appeal or a revision. If it's continued for several years, how can you unilaterally cancel it?
Ultimately, the land, if it is a forest land, that modification.
Correct, but 120-29
Before this, you could have got contract.
realistic. 21st.
Number 56, Shanmanta Parvi Gowda.
My lord, formal objections filed to the IA, my lord, and then copies served on the contesting, the including applicant. Lordship will pass any order on the IA, my lord.
ಯಾರು ಇಂಪ್ಲೀಟ್ ಮಾಡಕ್ ಮೇಡಮ್? Who wants to get implemented? You are the purchaser. Since it is contended that the proposed respondent is the purchaser of the property in question, come on, in my view, the objections raised by the petitioner for impleading the proposed respondent will not be sustained. Consequently, IA 1/25 is allowed, cause stated to be amended.
Please.
In case in him.
The next week in hearing, mean.
ಮಾಡಿದ್ರಿ. First it amendment.
Please.
For further consideration. Seal number 57, Shri Arjun Rao.
Have directed by the post, fitting into Panchayat Development Officer, along with all their records. Name of that very easily, it could be understood. Even by the.
You seen it?
Yes, it's just been served on me. It's not as per what your lordship said, and not only that, the amount seems to have increased from the last date. And I'll point out from this, my lord, how this is entirely.
I think the best thing is to send you across back for you to litigate.
Very simple calculation, in fact, I made it very easy to. Two relating to the properties which were permitted to be occupied in 2008 and 2011. And the third charge is relating to.
Survey number 21, da?
Yes. Now, clearly see, from 3/3/2008 to 2/3/2011.
No, survey number 21.
Yes.
These 11 hoardings,
No,
11 plus 12, 23 hoardings,
My lord, two hoardings.
two hoardings, two hoardings.
1 and 2.
One and- Now, as per the terms and conditions of the.
This is as per the agreement, correct?
As per the agreement. Now, kindly just take the calculation that I made from 3/3/2008 to 2/3/2011, that is for 3 years. Rent is 1,78,200 rupees per acre. That's per annum. That's not put about it. Now, for 3 years, we multiply by 3, it comes to 5,34,600. Then after the expiry of 3 years, there will be a revision of this ground rent.
The agreement provides for it?
Yes.
Yes. There's no dispute on this,
There's
my
no dispute about it. 10%.
And this number is correct.
After the expiry of 3 years, 10% of the existing rate. So 10% enhancement on rupees 1,78,200 will come to 90,602. Total amount.
The ground rent, there's no dispute.
There's no dispute.
The difference is a few hundred rupees is the difference in the calculation.
Then from 3/3/2011 to 2/3/2014.
Then he's saying no dispute. Regarding 1 to 6, no dispute. Then what is the dispute regarding?
I do not know what they are disputing, but we have served the copy. There is no dispute about it.
Okay, I have the copy, my lord. I'll point out what the dispute is. Can you see, my lord, this,
Ground rent, there's no dispute.
There is no dispute.
Then what is the dispute?
my lord, license fee for 10 years, the calculation placed on record by us would show that the amount is closer to around 11 lakh rupees. Because there were some periods in which the boards were not there. They have also admitted it in previous calculations filed by them. That's one aspect. Kindly see the second part.
How does it make
Advertisement
does it
tax.
make a difference whether the board is there or not?
Yes,
If there's an agreement, whether you erect a board or not.
Boards have been removed by them in some
No,
cases. Boards have been removed by them in some cases. In some cases, the boards are completely covered by trees. We have written to them. Sir, 1 minute. I don't need subtitles. Please give me a minute. In some cases, boards are covered by trees. I write to them. They acknowledge it. For that period, they give me a benefit also.
Where do they
Yeah,
get the
but-
benefit?
I produced all of that along with my calculation. I produced that. The most important aspect in this first chart is on advertisement tax. Here, my lord, once again, what is sought to be done is to claim the amounts under the agreement, but also additionally impose what is under statute. That cannot be done. Under the statute. They are now seeking to claim, my lord, both the amounts payable under the agreement and in addition to that, amounts under the statute.
You only agreed with the last portion,
Yes.
3,56,400.
With regard to imposition, my lord, only agreed by the last portion. The second portion on license fee, the figure is wrong. The figure is wrong. But my lord, these will all, please take even the next chart, my lord. I'll just point out what my.
No, even this is a small amount, 2,49,000 regarding this. What is the real dispute?
That, my lord, on the third page, your lordships will see. Kindly see annexure 3. Yes. The dispute, my lord, is with this figure of 95,20,000. Kindly see how this figure comes about. These are hoardings on private properties for which there is no agreement, where, my lord, they would only have to impose as per the rate mentioned in Schedule 4. Now they want to impose 25 rupees per square feet, which incidentally, my lord, is the rate in the agreement, though these are not covered by agreement. And this is precisely what your lordship said cannot be done.
License fee hang barutte?
So far as license fee is concerned, they are going to pay under the enactment.
Torsi.
They are going to pay.
Torsi.
Lord, whether I pay license fee or tax, the rate is the same under Schedule 4. That demand is already made in the previous
What's the
part.
license fee?
Section 7. permission shall be granted under section 66.
Section?
70.
Yes.
A permission shall be granted under section 66. And a license under section 67, 68 and 69 shall be granted or renewed only on payment in advance of such fee as may be prescribed.
Show me the prescribed fee.
Prescribed fee is under the schedule 4.
Schedule 4 is tax.
That's how we have calculated, because they are going to take the license for having it is just like a trade license.
Is there any license fee prescribed for advertisements? For granting of a license for erecting an advertisement? If there is no fee, there is no fee. You have the right to collect tax under the 4th schedule, you collect. Nobody will come in the way. How can you collect fees which is as may be prescribed? If there is no prescription, there is no prescription. As may be prescribed. Show me the prescribed license fee.
As per the decision of the panchayat, which has been communicated to them.
As may be prescribed under it, has to be by way of a statutory rule. It can't be by way of a resolution. There must be a statutory rule which says this is the advertising fee that a Gram Panchayat can collect whenever it grants a license. Show me that fee, I'll uphold it, or else you can't claim that. Tax, you have a right, absolute right. There's nothing. Fees, as may be prescribed, you'll have to show me the prescribed fee, or else you can't claim. The first 2 agreements, I have no problem. There's an agreement you can collect. They can't go back beyond that. Regarding the private ones, that will be bad.
Now, regarding the private properties are concerned. Now, when you see Annexure 3, which are passed under the court today. Permission of each board against 80 feet into 30 feet, that comes to 3,200 square feet. Total 7 boards, it comes to 3,200 into 7, comes to 22,400 square feet. Advertisement tax as per schedule 4 at the rate of 5 per square meter per month for 2008 to 2024-25, that is for 17 years. It comes to, that is 2008.
21 lakhs, 22,000. Again, there is no difficulty about it.
What I have calculated. I have not calculated anything more than that.
95 lakhs, license fee for 17 years. That is the only grievance.
95,200, 95 lakhs to 20,000 rupees. License fee.
Then ತೆಗೆದ್ಬಿಟ್ಟು ಕೊಡಿ ಡಿಮ್ಯಾಂಡ್, I'll ask him to pay and close the matter here. ತಿರ್ಗಾ ಅಷ್ಟೆಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ತಿರ್ಗಾ ಅಲ್ಲಿಗೆ ಬರ್ತೀವಲ್ಲ ನಾವು.
No, I will exclude that.
Give a fresh demand, I'll ask him to pay that.
Lord,
ನೀವು ಪ್ರಾಬ್ಲಮ್ ಸಾಲ್ವ್ ಮಾಡಿ ಗಂಗಾಧರ್ ನೀವು ಪ್ರಾಬ್ಲಮ್
Problem solve ಮಾಡೋದಕ್ಕೋಸ್ಕರ ಇದು ಕೂತು ನಾನೇ ಕೂತು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿದ್ದೀನಿ.
ಲೈಸೆನ್ಸ್ ಫೀ ಕೇಳ್ಬಿಡಿ ಅಷ್ಟೇ.
Lord, even if they were to withdraw that, some small things would be there, my lord. There is a difference of a few lakhs, and my lord, payments of over 12 lakhs made by me are not accounted by them. I produce proof.
No,
of
no,
all.
we have accounted
Give
every
it to him. Don't fight for small things.
We have
You
accounted-
succeed on the major thing, be happy and walk
We
away.
have accounted every 5 whatever that has been paid. I think they have been left out, and I am entitled for the interest part. So far as
ನಾಳೆ ನಾಳೆ
Seal number 58, Shri Deepak.
Lords, this is regarding my lords filing of an affidavit. They have served the affidavit, my lords.
ಹಾಕಿದ್ದಾರೆ.
They have served the affidavit on Friday to me.
Filed one memo, my lord. Board of the commissioner got direction to test it.
ಇಸ್ಕೊಂಡಿದ್ದಾನೆ ನೀವು.
Already filed.
Put up ಆಗಿಲ್ಲ.
ಯಾವತ್ತು ಫೈಲ್ ಮಾಡಿ? They have not come.
Put up ಆಗಿದೆ. 14th of March ತಾನೆ?
14th of March. He served on.
Then
But I just received a copy, my lord. I have to consult parties, my lord, to see whether this, I just received a copy.
photo. Relist.
24th.
Please. Omelette.
24th. Number 59, CH Srikanth.
The petitioner. Final report. Last time preliminary report they submitted, my lord. Final report is.
Yes, Pawan. ನೋಡಿದ ರಿಪೋರ್ಟ್?
ಅಲ್ಲ last time ಬಂದಿರ್ಲಿಲ್ಲ.
But they said they will submit a final report. I am just waiting. I'll have it collected from Mr. Pawan.
Deviation 66.36%. Front setback.
Piece of setback on the front side.
The interim report ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ರು ನಮ್ಗೆ? Then was it said it is an interim report?
There was no interim report.
Pawan made a submission.
Last occasion, they filed this interim report stating that final report will filing shortly.
ತದನಂತರ Sri Pawan Kumar is unavailable. Relist on
24th.
25th.
25th. Number 60 adjourned. Number 61, Sri V. Balakrishna. Yes, my lord. Amendment.
ಸರ್ವ್ ಮಾಡಿದ್ರೆ ಮೇಡಮ್ ಅವ್ರಿಗೆ R8 and R9. Copies with engineers.
I undertake to appear on behalf of the Anjanappa.
ದೇವೇಗೌಡಗೆ
ಒಬ್ಬರಿಗೆ ಸರ್
ಸರ್ವ್ ಮಾಡಿದ್ರೆ ಅವ್ರಿಗೆ.
ಅವರೊಬ್ರು ಇಲ್ಲಿ ಬಂದಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಅವ್ರು ಅಂಡರ್ಟೇಕ್ ಫೈಲ್ ಒಕ್ಕಲತ ಅಂಜನಪ್ಪ ಒಬ್ರು ಬಂದಿದ್ದಾರೆ.
ದೇವೇಗೌಡ ಬಂದಿಲ್ವಾ? Have you informed him the case is posted today? And he does not listen to you also.
My lord, there is a small correction there. It is not Devagowda, it is Ramegowda.
He says he has served and he
No,
has-
because as per my record, it is Ramegowda who is in charge at that time.
ಏನ್ ಮೇಡಮ್ ನಿಮ್ ಇಂಜಿನಿಯರ್ ಅವ್ರಿಗೆ ಗೊತ್ತು ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ವಾ? He's saying a different name as in.
Yeah, yeah, it's Ramegowda this one, because I written letter to Chief Commissioner also.
Yes, Raju undertakes to appear on behalf of R9. The Devagowda was included as rep number 8. Is not present. The party in person states that the name of the engineer is actually Ramegowda,
Ramegowda.
not Devagowda. PVMP council to verify and make her submissions. Yes.
Interim
That's
order
all,
Madan,
in the
interim
argument.
order may be extended, my lord. Interim order may be extended, my lord.
No, what is your argument now? I hear them.
Yes, my lord.
What is your argument?
No, my lord. 323 notice have been cost to me. 3 notice were cost to me. Thereafter, they sanctioned my plan.
It is in accordance with the sanction plan,
Yes, my lord.
your construction.
That is what the corporation has sanctioned my plan, my lord.
So your plan, according to your argument, is it is in accordance with the
No,
sanction plan.
There are setbacks, my lord. There are certain structures which last time I made a submission before your lordship. If your lordship permits, we would see that those structures would be removed.
What does the KAT hold?
KAT did not apply them, my lord. KAT has not gone into the notices aspect at all, my lord.
Plan was cancelled. According to KAT, the plan was cancelled. And you have not challenged the cancelled plan,
Yes, my lord.
cancellation.
Yes, my lord. I filed, my lord.
When? After you put up the construction.
That is my claim.
Where have you challenged?
Sanction present, huh? Hmm? Sanction present, eh? Yes, my lord. On 20, on 9/3/2021, and I are not served on him. My lord, my sanction plan, obtained sanction on 24/3/2021, my lord. I take a lordship to point 9.2, my lord. Pursuant to appeal memo filed by the appellant provisional order. Page 45, my lord.
Yes.
Point to my lord. There's the findings, my lord. Pursuant to the memo filed by the appellant provisional order under section 320(11) KMC Act. Some confirmation order X20 Act passed with the respondent number to scrutinize arguments and documents. Appellant through an appeal challenge the confirmation order passed by respondent stating that you obtained a sanction plan and the license from BBMP on 24th construction of a steel ground first, second, third floor property. As per the sanction plan, he's constructing building. Respondent number 2 on a complaint of his neighbors without making any physical inquiry issues the notice on 9/3/21. Even is constructing the building as per the sanction plan without deviation. Further, respondent number 2, without giving an opportunity, inquired, issued the confirmation order mechanically on 19/3/2021. Hence, the appeal pursues. This is how, my lord, their notice was not cost. Hence, the appeal pursues the copy of provisional order and 321 KMC Act passed on 9/3/2020. In the order stated, the appellant has constructed a building against the approved plan and the copy of confirmation order dated
dated 9/3/2021, issued by respondent number 2 to the appellant. In the order stated immediately to remove the portion of the construction of building against the sanction plan and by law, peruse the sanction plan. Sanction plan shows plan sanction on 5/6/2021 for construction of stilt ground second floor. Further stilt for parking and but photo shows stilt ground first and second floors. Copy of the official memorandum of BBMP Bumnelli range dated 2011-21 produced by respondent shows that prior to sanction plan, he has started to construct the building. Hence, the sanction plan issued by the appellant was cancelled. Further, the document produced by the respondent shows that the respondent made a complaint before the BBMP against an illegal construction of the building by the appellant from September 2020. Copy of the notice under section 308 KMC Act and dated 13/10/20 and 25/2/2020 and issued by respondent number 2 to the appellant or shows that they have asked the appellant to produce documents of the property with the approved plan. Yet these notices show that the appellant started construction of building without obtaining a plan. Peruse the record submitted by the respondent. The record shows that appellant has constructed.
Yes.
My lord. In this, my lord, tribunal has not taken into consideration my concept, my lord. I was not caused the notice. An opportunity was not given, my lord. If your lordship would remand the matter, say that.
Can I make a submission?
Prayer, see, my lord, quashing the order passed by the tribunal, my lord. Issue should say the quashing the order passed by the second respondent at 2011-2021, etc., etc. My only problem, my lord, is the notices were caused subsequently. They have sanctioned my plan. All these notices goes. This particular aspect was not taken into consideration by the tribunal, my lord. Now the tribunal caused any notice to me, my lord. So with this aspect, my lord, it may be remanded a matter for a fresh disposal, my lord. Yes.
He has not challenged the cancellation of the plan. And you approved the plan after he commenced, after you should no, 321 notice kottadmele you approved the plan. Yes. No. But you grant the approval after 321 notice. One floor is extra, na? One floor is extra. What are the deviations? Complaints report here.
The average setback required is around 11% setback around the building. He has given only 1.6%. That is the difference.
One floor extra. Yes.
No. Setback required around the building is around 11%. He has given only 1.6%. That is the problem. And then his balcony projects onto the footpath. 50% of the balcony projects onto the footpath. So that is one. And another point is in the earlier repetition 13077, he has submitted saying that I started construction after 24/4/20, where he has submitted a fourth sanction plan. So in one case he submits I started the construction after 21, and in one repetition he submits I started construction after 24/4/20. His own affidavits.
Either way, there is no plan.
Both the cases the plan is not there.
ರಿಟೈರ್ ಈಗ ಬಂದಿದ್ದಾರೆ
ಇಲ್ಲ ನೀವು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಕಾಸ್ಟ್ ಎಷ್ಟಾಗುತ್ತಲ್ಲ ಅರ್ಧ ನೀವು ಕೊಡ್ತೀರಾ ಅಷ್ಟೇ. ಡಿಮಾಲಿಷ್ ಮಾಡಕ್ಕೆ ಎಷ್ಟು ಖರ್ಚಾಗುತ್ತಲ್ಲ ಅರ್ಧ ಕಾಸ್ಟ್ ನೀವು ಕೊಡ್ತೀರಾ.
ಈಸ್ ರಿಟೈರ್ ಸೂಪರ್ ನೇಷನ್ ಆಗಿ ರಿಟೈರ್ ಆಗಿ ಮನೇಲಿ ಇದ್ದಾರೆ ಅವರು ಓಲ್ಡ್ ಏಜ್.
ಯು ಅಲೋಡ್ ದಿಸ್ ಟು ಕಂಟಿನ್ಯೂ.
ಅವ್ರಿಗೆ ಜ್ಞಾಪಕನಲ್ಲಿ ಏನ್ ಮಾಡಿದೀನಿ ಅಂತಾನೆ ಗೊತ್ತಿಲ್ಲ ವಿಚಾರಗಳು.
ಇವಾಗ ಗೊತ್ತಾಗುತ್ತಲ್ಲ, ಅದಕ್ಕೆ ನಿಮ್ಗೆ ಅವಕಾಶ ಕೊಡ್ತಾ ಇದ್ದೀನಿ. ಅಬ್ಜೆಕ್ಷನ್ ಆಗಿ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿ, ಇಲ್ಲಾಂದ್ರೆ ಐ ವಿಲ್ ಪ್ರೊಸೀಡ್ ಟು ಪಾಸ್ ಆರ್ಡರ್ಸ್.
ಗೆಟಿಂಗ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಅದಕ್ಕೆ ಅವರೆಲ್ಲ ಮರ್ತೇ ಬಿಟ್ಟಿದ್ದಾರೆ, ಏನು ಅಂತಾರೆ ಗೊತ್ತಾಗ್ತದೆ.
ಏನ್ ಮಾಡ್ತೀರಿ? ಇಫ್ ಯು ವಾಂಟ್ ಟು ಆರ್ಗ್ಯೂ or else I'll reserve it and pass orders.
Getting instruction.
I propose to direct the zone commissioner to initiate action against you for punishment for 321 violation 321B and also recover the cost of demolition from you and the other engineer. Allow this to happen.
Verification ಮಾಡ್ತೀವಿ, ಅದು ಯಾರು ಆ ಟೈಮಲ್ಲಿ ಯಾರಿದ್ರು ಏನು ಅಂತ
ಅವರು BPMP ಹೇಳೋದು ನೀವಿದ್ರು ಅಂತ, ನೀವು ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಿಲ್ಲ.
ವೆರಿಫಿಕೇಶನ್ ಮಾಡ್ತಾ ಅವ್ರಿಗೆ ಮರ್ತೇ ಹೋಗಿದೆ ಯಾವಾಗಿದ್ದೆ ಏನು ಅಂತ, ಅದೆಲ್ಲ ವೆರಿಫಿಕೇಶನ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರೆ
ಅಪ್ಲಿಕೇಶನ್ ಕಾಪಿ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ ತಾನೆ ನಿಮ್ಗೆ?
ಈಗ ಕೊಟ್ಟಿದ್ದಾರೆ
ನೋಡಿ, ನೀವೇನ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತಗೊಳ್ತೀರ ಎಲ್ಲ ರಿಸರ್ವ್ ಮಾಡ್ತೀನಿ, ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿ.
ಪ್ಲೀಸ್.
ಎಷ್ಟು ಲಕ್ಷ ಆಗುತ್ತೋ ಡಿಮೋಲೇಷನ್ಗೆ ಅರ್ಧ ಕಾಸ್ಟ್ ನೀವು ಕೊಡ್ಬೇಕಾಗುತ್ತೆ. ದಟ್ ಈಸ್ ಓನ್ಲಿ ಥಿಂಗ್ ದಟ್ ಐ ಕ್ಯಾನ್ ಡೂ.
ರಿಟೈರ್ ಆಗಿದ್ದಾರೆ, ಏಜ್ ಓಲ್ಡ್, ಏಜ್ ಇಷ್ಟ ಆಗುತ್ತೆ. ಅವ್ರು ಮಾಡಿದ ತಪ್ಪಿ ಅವ್ರ ತಪ್ಪಿಂದ ಏನಾಗಿರಲ್ಲ, ಅದು
ಅವ್ರು ತಪ್ಪಿದ್ದಿದ್ದು ಅವ್ರು ಮಾನಿಟರ್ ಮಾಡಿಲ್ಲ ಅಂತ ತಾನೆ,
ಹೋಗಿರ್ತಾರೆ
ಕೆಲಸ ಮಾಡಿಲ್ಲ ಅಂತಾನೆ ಇವಾಗ ಕಾಸ್ಟ್ ಕಟ್ಟಬೇಕಾಗುತ್ತೆ. And file the amount of money that is incurred for demolishing this and verify whether it's Devegoda or Ramegoda. List.
ಒಂದು ಡೇಟ್ ಹಾಕಿದ್ರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ.
Next week ಹಾಕ್ತೀನಿ, ಅದನ್ನ ಯೋಚನೆ ಮಾಡಿ ಹೇಳಿ ನೀವು. List.
May be extended by lot.
Remote to continue till 24th.
ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಏಪ್ರಿಲ್ ಅಲ್ಲ, 24th ಸ್ಟಾರ್ಟ್ ಡೇಟ್ ಹಾಕಿ ಸ್ವಲ್ಪ 28th ರೆಕಾರ್ಡ್ ವೆರಿಫೈ ಮಾಡ್ಬೇಕಾದ್ರೆ
Consideration
28.
ನೀನೇನಮ್ಮ?
First week, my lords. From your argument is over, I'm only granting him time.
Seal number 86, Shri Raghavendra S.
Serial number 77.
ಅದಾದ್ಮೇಲೆ ತಗೊಳ್ತೀನಿ, ನೀವ್ ಯಾರು ಇದ್ರೆ ತಗೊಳ್ತೀನಿ.
The last case, I just got 5 minutes back. The affidavit which he is going to file.
You want to go through it and make your submission?
Yes, my lord. Number 2, on the last occasion, my lords were pleased to direct orally the town planning authority to file the affidavit. Till today, they are not filing. And what is happening is, my lord, just because there is no interim order, they are going on with the construction, they have completed. Even OC is given, my lord, now. I'm unable to understand at this rate tomorrow.
There is no other violation.
Even completing certificate has also been issued. Then they have to challenge that order.
You want to file an affidavit undertaking that you will maintain this place and
Yes.
not
I have already filed that affidavit.
ಇಲ್ಲಿ ಪಾರ್ಕಿಂಗ್ ಮಾಡ್ತೀರಿ ತಿರ್ಗಾ?
ಏನು? Sir, ಅದು older photo.
Last time ತಾವು ಹೇಳಿದ್ರಿ ಅಲ್ಲಿ steps ಇಲ್ಲ ಅಂತ.
Rashmi KNDC
ಹೋಗ್ ಬರೋದ್ರೊಳಗೆ ಇವತ್ತಿಗೆ
they have
steps
filed a complaints report. Rashmi KNDC, the complaints.
You had indicated that I had told you that you should file an undertaking that you will not park any cars here. If you're going to park two-wheelers and tomorrow cars, the same thing.
No, sir. My lord, this is a way as per left out as per the compromise deed.
ನೀವು ಇಲ್ಲಿ ಪಾರ್ಕಿಂಗ್ ಮಾಡಲ್ಲ ಅಂತ ನೀವ್ ಹೇಳಿ ಅಫಿಡೇವಿಟ್ ಹಾಕಿ ಕರೆಕ್ಟ್ ಆಗಿ ಇಲ್ಲಿ ಯಾವ ಗಾಡಿ
ಹಾಕಿದ್ದೇವೆ affidavit. ಹಾಕಿದ್ದೇವೆ ಅದು parking ಮಾಡಿ.
ಇಲ್ಲಿ ನೋಡಿ ಫೋಟೋಗ್ರಾಫ್ ಅವ್ರು ಹಾಕಿರೋದು ಕಮಿಷನ್ ಹಾಕಿರೋದು.
Customer, kindly this is my complaint affidavit.
You don't want me to help you. You want to unnecessarily create problems for yourself.
ಹಿಂದ್ಗಡೆ total violation.
ಮಾಡೋದಿಲ್ಲ.
ನಮ್ಮನೆ
ಮಾಡೋದು, we will
road
take an
ವರೆಗೂ
undertaking
touch
that we don't
ಮಾಡಿದ್ದಾರೆ.
park here.
Where's the affidavit that you have filed?
Complaints report 27/2/2025.
I will give a right of way ಅಂತ ಅಷ್ಟೇ ಹೇಳಿದೆ.
ಯಾವತ್ತು?
27/2/25.
ಯಾವುದೇ ರೀತಿ ಬ್ಲಾಕ್ ಮಾಡೋದಿಲ್ಲ ಹೇಳಿ ಹಾಕಿದ್ರು.
ಫೈಲ್ ಮಾಡಿದಾರ?
ಹೌದು, ಮೇಲೆ I have filed it, my lord.
Where?
Already.
Complaints affidavit ಮೇಲೆ stating that ಮೇಲೆ whatever be the
27/2/25.
earlier date, second hearing date we are filings.
ಕೋರ್ಟಿಗೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿರೋದು.
ಹೌದು, ಕೋರ್ಟಿಗೆ submission.
It's not here.
ಪ್ಯಾರ 3 ಕೊಡ್ತೀನಿ.
I don't notarize it for some time.
ಪ್ಯಾರ 3 ನಲ್ಲಿ ಲಕ್ಷ್ಮಿ ಖಂಡಿಸಿ
You don't have the affidavit.
ಹಾಕಿದ್ದೀನಿ ನಾನು. ಮುಂದೆ ಅಥವಾ
Fourth January ಹಾಕಿದ್ದೇವೆ ಸರ್. Fourth.
4th January ಮೇಲೆ. Sorry.
4th January.
Yeah, you should say that you will ensure that there's no parking anywhere in this particular area.
ಹೌದು.
File a better affidavit.
Lord, on merits also, I would like to make submissions. my lord. Town planning over the affidavit ಹಾಕ್ಲಿ ಅವ್ರು.
For what do you want from them?
There's no such direction.
What do you want from them?
I want to say, how did they give amalgamation? They have played a fraud on the court. And when I filed the writ petition, the whole area was vacant. Because there is no interim order, today they have almost completed, even OC is given. And
No.
tomorrow they
Why do
will
you say-
create third party interest.
I don't think there was any amalgamation. It was considered as one plot only.
There is a
Private
road
property.
in between.
Maybe so, but it was never considered as a two different plot.
No,
Considered as one plot and granted on a.
that can't be done. Amalgamation of two plots is different. And here they consider as one, my lord, and then grant.
So where is the bar for them? If suppose there's a road coming in between my land,
Yes,
it won't become two plots. It become one plot with a road running in between.
that road,
Roads are independent of each other.
two different plots there.
They are one plot only.
ಇಲ್ಲ ಮಧ್ಯ road ಇದೆ.
Correct. That is because of the compromise decree.
No, no, no,
The
no,
part
no,
of the
no, no, no.
It is a part of the.
Clearly
Well,
ಮಾಡ್ಬೇಕಾದ್ರೆ ನೀವು ಸುಮ್ಮನೆ ಇರ್ಬೇಕಂತ.
ಸರ್ ಏನು ಇದು ತಾವು ಹೇಳುವಾಗ ಸುಮ್ಮನೆ ಕೂತಿದ್ದೆ ನಾನು.
ಮಾಡಿ ಸರ್.
My lord, when I purchased the property way back in 1950s, the whole area was held by one single owner. When he sold different plots, when I purchased, and in the sale deed also, there is a categorical mention that 12 feet road will be left.
Correct.
And in the compromise also, the honored the 12 feet road. It is not that they have granted me that 12 feet road. It has been there from 1950s. Therefore, to say they have granted is totally wrong. Number two, absolute violation of building bylaws. Which by looking at the photographs which I have produced, I can bring to your lordship's kind notice. What happens is, behind the main building is my building. There is a road of 12 feet they are supposed to leave. There is a 12 feet road and the construction has come up to the end of the road. There is no setback given and he has given a ramp there and the entire vehicles will come and will not get dropped there and right in front of my house. And they have not left any setback. This is the problem, my lord, and it is not as if after completion I have come before your lordship. The day I filed, it was vacant.
This action plan indicated and permitted the ramp to be put up at the back of the property.
First time when they granted, they suppressed the fact of existence of a road. The amalgamation order also, they suppressed. In the affidavit also today they have mentioned. You know, it's an absolute fraud. They cannot do this. And there is a collusion, my lord, among all of them. I'll point out on merits, my lord. It is just not that I get 12 feet road, therefore I should be happy with that. No, there is absolute violation. Honorable Supreme Court in not less than 2 cases or 3 cases have categorically held if there is a violation, you got to demolish. You cannot take a defense that I have already invested, therefore it is a cost on my head, therefore excuse me. Supreme Court said nothing doing. I'll point out all this to your lordships, my lord, how these things have happened. And now, my lord, last time and this time, in between now they have given OC. Look at the attitude, my lord. The matter is pending. Your lordship is asking for, my lord, an affidavit to be filed. On one hand, he files the affidavit. On the other hand, OC is given. My humble request is, let the town planning authority file the affidavit. Till then, there should be no.
The affidavit that you want them to file.
How did they grant this?
They have, who granted the building plan approval?
This is by the municipality, my lord.
Therefore, the building plan has been approved by the municipal corporation.
Yes. Technically, we approved, my lord, then proceeding has to be whether there were violation in the construction or that month.
The plan.
We approved the technical plan, we have approved.
Now, who will certify whether the building is in accordance with the plan or not? You or them?
That the municipality has to.
But I
You
will
are- you are-
react to this.
My lord, even before the
One
regional
request,
commissioner,
One request, my lord. They should not create third-party interest. Then I will have absolute
That will be
difficulty.
subject to the result of the writ petition.
That may be made clear, my lord. Otherwise, the problem is, my lord, every day the improvement is going on and then
Who
tomorrow,
want to argue?
Thursday, I am ready to argue.
Thursday,
That may be clarified, my lord.
Thursday I'll pass.
Well, subject to the result of the petition.
Thursday, I am about in 3
there
days.
there is no interim order at all, my lord.
There is no interim order as on today.
That is how they
There is
have
no
taken
interim order at all.
advantage and played
But
fraud.
somehow they want to
Today,
put
you
up
can argue
the.
today, Thursday, whenever you want.
Thursday
Thursday.
ನಾನು ಮಾಡ್ತೀನಿ ಅಲ್ಲ there is no interim order ಅಂತ ಒಟ್ಟಿಗೆ ಎಲ್ಲರೂ ಕೂಗ್ತಾ ಇದ್ದಾರೆ.
Thursday.
What I am saying is, my lord, taking advantage of that, that is how they have behaved.
My lord, he was,
ಏನಿದೆ ಫರ್ದರ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಎಲ್ಲ ಮುಗಿಸ್ಬಿಟ್ಟಿದೆ.
ಮತ್ತೆ ಸ್ಟೇ ಬೇಕಾಗಿಲ್ಲ ಅಂತ ಅದನ್ನ ಹೇಳ್ತಾರೆ ಸರ್.
ನಾಳೆ 4 ಜನ ಟೆನೆಂಟ್ಸ್ ಕೂಡಿಸಿದ್ರೆ
ನಂಬರ್ 1 ತಗೊಳ್ತೇವೆ ಸರ್.
Petitioner. Petitioners are the legal heirs of original grantee.
What is the next search?
Annexure J, my lord, is the cancellation of the regularization made in favor of the husband of the first petitioner. Lord,
Division ಇಲ್ವಾ ಇದ್ರ ಮೇಲೆ? ಈ 136 ತಾನೆ?
ಇಲ್ಲ 108 ಅಲ್ಲಿ ಅದು DC ಹಾಕಿ DC ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರು. Assistant Commissioner passed order.
Where is the DC's order? On what ground is the grant cancelled?
One is only on the ground that the family of the grantee had more than 4 acres as on the date of grant. Anta.
What is the date of the grant?
No, date of grant is 2000, Lord. I have produced annexure A.
2000.
How?
24 years after the grant issue.
How? And that is not correct, but even this honorable court has held.
4 points. 1 to 7. You notice to the next date of hearing, there's an interim stay of annexure. G alwa? G and
How?
G and H.
G and H. G and J.
J and beda alwa?
Beda, G sir. G. Lord, may I seek a hand delivery, Lord? There is a threat of dispossession.
Number 2, serial number 5, Sri Chandra Mohan P.
Certified copy.
List number 2, serial number 5.
the order passed by deputy commissioner. allotting to the outside, to the outside people, and the access scheme, my lord.
2023 order.
Huh?
2023 order.
Yes. Yes.
Who are you?
Yeah, I filed application for regulation of unauthorized occupational land. My application is still pending. Without concern my application, Deputy Commissioner has passed an order. Annexes C, my lord.
This the petition will be directed to survey copy. AG accept notice for respondents 1 to 3. Realist and preliminary hearing on.
First April. Seal number 8, Shri G.S. Prasanna Kumar.
My lord, 79 AB to LRF order of 2006, then KAT ದಲ್ಲಿ ಅಪೀಲ್ ಹೋಗಿದ್ವಿ ಸ್ವಾಮಿ, ಅದು ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಗೆ ಡಿಸ್ಮಿಸ್ ಆಗಿತ್ತು.
DNP ಆಗಿದೆ.
Please, my lord.
DNP ಆಗಿತ್ತಾ?
Now I'm seeking for the setting aside of that LRF order where which was rejected on 79.
2016 not you're challenging 2024.
21 ನಲ್ಲಿ ನಾವು ಇದು ಮಿಸ್ಲೇನಿಯಸ್ ಹಾಕೊಂತೀವಿ KT ಅಲ್ಲಿ, that also get
ಅವಾಗ
2021 ನಲ್ಲಿ.
ಏನ್ ಮೇಡಮ್? The petitioner AG accepts notice for respondents. The petitioner is aggrieved by an order of vesting as by the Assistant Commissioner under section 83 the Land Reforms Act, which has been confirmed in appeal by the Karnataka tribunal, though not on merits, but by passing an order of dismissal non-prosecution. Miscellaneous petition filed for restoration has also been dismissed by the tribunal. As a consequence, the petitioner is before this court. The order passed by the Assistant Commissioner indicates objections ಹಾಕಿದ್ರೆ ಮೇಡಮ್, objections ಹಾಕಿದ್ರ?
ಇಲ್ಲ.
The order of
ಅದು
Assistant
LRF
indicates
is also ex parte, my
that
lord.
the petitioner had not entered appearance and filed objections. And the Assistant Commissioner has proceeded to pass the order solely on the ground that no documents were furnished by the petitioner to establish that he was entitled to acquire and hold agricultural lands. As noticed above, the appeal filed against the said order was dismissed on prosecution and a miscellaneous petition filed has also been dismissed.
For non-prosecution.
Though in the normal course, other non-prosecution. Though in the normal course, the order passed by the Karnataka tribunal would have been set aside and the matter would have been remanded. Having regard to the fact that the provisions of the Land Reforms Act have been amended and section 79A and B are omitted and proceedings are also ordered to be abated. No useful purpose would be served by remanding the matter, and consequently the proceedings initiated against the petitioner for violation of section 79A and B is declared to await.
Seal number 10, Shri Ranjan Kumar K. Seal number 14, Shri Sumantel Bharadwaj. Sumantel Bharadwaj.
Same.
Seal number 17, Shri A.C. Balraj.
My lord, I appeal for the petitioner, my lord. My lord, annexure F and H is questioned, my lord. Order passed against a dead person, my lord. Annexure F, my lord, is an order of the Assistant Commissioner.
Next year,
Annexure F, my lord, where my lord, one Murugappa, who is being made as a party, is a dead, my lord. And my lord, Annexure H,
36.
we filed a revision petition.
36.
It's 136, my lord. We filed 136-3, my lord. Though the authority, the Deputy Commissioner takes note of that submission, but it does not pass any order. He only sums up saying that it is a civil dispute, go to the civil court. At last para, my lord, page 45. In fact, page 44 may kindly be seen, my lord, in the middle of the order.
there is a contentious taken that ಮೂರನೇ ಎದುರುದಾರರು ಒಂದನೇ ಎದುರು ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪ್ರಕರಣವನ್ನು ದಾಖಲಿಸಿದ ಸಂದರ್ಭದಲ್ಲಿ ಮುರುಗಪ್ಪನವರು ಮೃತ ಹೊಂದಿರುತ್ತಾರೆ ಎಂಬ ವಿಚಾರ ತಿಳಿದಿದ್ದರೂ ಸಹ ಕಾನೂನುಬದ್ಧ ವಾರಸುದಾರರಿಗೆ ಯಾವುದೇ ನೋಟಿಸ್ ವಗೈರೆ ನೀಡದೆ ಒಂದನೇ ಎದುರುದಾರರು ಹೊರಡಿಸಿದ ಆದೇಶವು ಕಾನೂನು
ಯಾವಾಗ ಮಾಡಿರೋದು ಆರ್ಡರ್?
Order is passed, my lord, on annexure on
Take commission-
23/5/2024, my lord.
Status quo, that revenue entries as it exists today shall be made.
Please.
Bill number 18. The order under challenge is at annexure A of land records. Who has ordered for a resurvey of the lands which were coded in 1972, as early as 1972. The DDLR had upheld the original survey that was carried out and annexed by the order under annexure B.
22 order, Mr. 22.
72, but the order under consideration is survey of 72.
No, read the operative portion.
In the revision, it is DDLR's order which is challenged. Under annexure A, the DDLR's order, respondent number 6 order was challenged, which is dated 17/11/2022. But the subject which is there for consideration is the durasti that has taken place in 1972 and 2006, where survey number 41, 48 was forwarded as survey number 1, 2, 3 to 23. Are settled.
ಏನ್ ಕಾರಣ ಕೊಡಿ ನೋಡಿದಿರ?
ಕಾರಣ ಏನು ಕೊಟ್ಟಿಲ್ಲ.
ಫೈಲ್
ಕಾರಣನೇ ಕೊಟ್ಟಿಲ್ಲ.
Copy to be served.
And 50 years of delay ಇದೆ. ಡಿಲೇ ಬಗ್ಗೆ ಏನು ಕೊಟ್ಟಿಲ್ಲ. ಈಗ ಸೆಟಲ್ಡ್ ಪೊಸಿಷನ್ ಬೇಸ್ಡ್ ಆನ್ ಪಾರ್ಟಿಷನ್ ಅಲ್ಲೂ ಅವರು ಕೋಡಿ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. 11 ಸ್ಕೆಚ್ ಪ್ರಿಪೇರ್ ಮಾಡಿ ನಾವು ಮಾಡಿಕೊಂಡಿದ್ದೇವೆ. ಈಗ ದೇ ವಾಂಟ್ ಟು ಡಿಸ್ಟರ್ಬ್ ದಿಸ್ ಪೊಸಿಷನ್.
This order was passed last year,
2024
January.
January.
And I don't know what has happened now.
ನಾವು ಏನಿಲ್ಲ ಅವ್ರು ಮರು ವಿಚಾರಣೆ ಕಳಿಸಿದ್ದಾರೆ.
ವಿಚಾರಣೆಗಂದ
ದಿ annexure A ರಿವಿಷನ್ ಅರ್ಜಿಯನ್ನು ಪುರಸ್ಕರಿಸಿದೆ ಕರ್ನಾಟಕ.
What has happened after 1 year?
ಏನು ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಮತ್ತೆ DDLR has issued notice and is inquiring.
It may be called on Monday, my lord, I will secure instructions.
But ಅವರು
He accepts notice for respondents.
there shall be status quo.
2/10. I don't know what is the status quo.
ನಾವು ಪೊಸಿಷನ್ ಇಲ್ಲಿದೆ, ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಇದೆ.
Instructions relist.
Second. Tilman 30. Jagadisha KG.
To the petitioner, my lord, we are challenging the order of the Tahsildar Dodballapura.
Tahsildar order.
Annexure K. 40, my lord, page 40. My lord, petitioner is in the survey number 220/7 of Kasagatta Grama, my lord, Kasagatta village. My lord,
Without even conducting ಅವ್ರು ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ರ ಸರ್ವೆಗೆ?
survey notice kottilla, my lord. They have not given a notice to survey. Then they've conducted a survey and they've issued an order stating that we have to remove the encroachment. It's not inter.
They accept notice for respondents. Bill is concerned, will then status quo be maintained.
Bill number 35, Shri Manjunath RP.
The respondent number 4, based on a purported will, had approached the Tahsildar seeking change of revenue entries. Tahsildar, by virtue of an order,
What are you challenging?
proceedings under 136/3, my lords. The Tahsildar orders were challenged before the Assistant Commissioner. Page number 26. 29 is the operating portion. The land, 29 is the operating portion. The revenue records were ordered to be restored in name of Sita Bai, my lords. She is late.
What is this MRH 15/1780?
Lords, it's a mutation which has been mutated in name of respondent number 4. It's based on a will, purported will.
Where is that?
Well, we don't possess the copy of the will, my lords. It's a will. On the will, he has made an application before the Tashildar to mutate the revenue records in his name. We challenged
Whose name was the Kata standing?
Sita Bai, my lords.
Sitabai.
Sita Bai.
Sitabai executed a will in favor of?
Will in, he claims that there is a will in favor of respondent number 4.
No, give me the names. Sita,
But, my lords, respondent number 4 is Kumar Naik, my lords, in the current petition.
no, before the assistant commissioner.
Before the assistant commissioner is respondent number 2, my lords.
Then
And he challenges the same before the deputy commissioner.
Krishna Nayak files the appeal.
He files the revision petition, my lords. We filed the appeal, my lords. We filed the appeal, and it came to be allowed, restoring the name of Sita Bai in the revenue records. He being aggrieved by the order, he had approached
Stated Sita Bai.
my lords. Her husband is my uncle, my lords. The property was devolved.
Your uncle.
Yes. My lords, Rama Naik had 3 children. Genealogical tree is forthcoming as page number 23, 24, my lords.
And how is Krishna Nayak related?
My lords,
Kumar
he claims as an adopted son.
Adopted son.
Please,
You claim to be the uncle of her husband.
please. Let's
Uncle ಅಂದ್ರೆ
24 for a moment.
ಅಲ್ಲ,
He's my father's brother, my lords. Elder brother.
Okay. What did the DC do?
Page 21, my lord.
Virtually,
E.
he virtually rejects the set aside the order of assistant commissioner and restores the Kata in name of the respondent number 2, respondent number 4.
Page 21, my lord, annex E, paragraph E.
You should go to the civil court, correct? He's correctly said that.
The parties have not approached this field court.
No, we don't know who you are. You are not the son, daughter, or
Well, we come under section 15 subclause 2 of Hindu Succession Act, well,
that. Suppose the assistant Tahsildar says you don't come under that particular.
Well, it's a
category.
competent civil court which requires to be adjudicated.
So you will have to go, isn't it?
Well,
You will have to go.
please. Both the parties request to approach the court.
He has some document in his favor.
Please, my lords. But Tahsildar ought not to have mutated the revenue records based on a will. It is not his jurisdiction to adjudicate it.
No, I normally entertain challenges for change of kata made on the basis of will, provided the will is to a stranger.
Please,
And the will is to an adopted son.
please.
You are not related to that deceased.
Well, it's some related under section 15 subclause
That
2.
has to be established.
Please.
Class 1 heirs I'll consider.
Please.
I think you should go to the civil court.
I would go, my lords. Let there be a status quo on the revenue interest. Is
If you win,
my lords, still then, my lords, let there be an order of status quo. It would be an outcome of the civil verdict, my lords.
anything else?
I would still redress my grievance before the civil court. Let there be a status quo on the revenue records.
An order of mutation was made on the basis of a registered will. This was challenged by the petitioners herein, who claimed to be class 2 heirs of the deceased. The assistant commissioner accepted the plea and set aside the order of mutation, which led to the filing of a revision. The deputy commissioner has reversed the order of the assistant commissioner and has held that the mutation made in favor of the respondent in MR 15/1718 was not challenged. And he has also gone on to hold that there are no documents to produce to indicate the legal right of the petitioners to claim the change of entries in their favor. In my view, I am regard to the fact that the petitioners are not class one heirs. And their entitlement will have to be established with the civil court. The trial court was justified, the deputy commissioner was justified in allowing the revision and setting aside the order of the assistant commissioner. I find no reason to entertain this petition. However, liberty is reserved to the petitioners to approach the civil court and secure a decree that they are legally entitled to succeed to the property of the deceased Khatedar. What's her name?
Sita Bai.
Sita Bai.
Let's revenue, status quo of revenue records.
Will take notice for 1 to 3.
The assistant director of land records has submitted report for the enclosures of the cart road. That report placed before the Tahsildar. Tahsildar has not taken any action.
PG accepts notice for respondents.
But this is the case where encroachment of road, my lord.
Road.
ಅವ್ರೇನು ರಿಮೂವ್ ಮಾಡೋದನ್ನ ಕೇಳ್ತಾರ.
Yes, my lord. The petitioner, my lord, restricted the, my lord, road to enter, my lord.
Somebody is encroached upon the cart road ಅಂತಾರೆ.
Cart road was encroached by
Direction
the.
response
Yes,
number
Lord.
4
That
for
list
considering
was
a-
prepared by the ADLR.
encroachment.
List was given by the ADLR with the report to the Tahsildar.
Verify that the encroachment or not.
I will.
That is a list and report and survey sketch was submitted.
For 41. Chandrapi.
79 AB. I will take notice.
My lord, challenge annexure D, the order passed by respond number to assistant
Next,
commissioner. Annexure D, the order passed by assistant commissioner confiscating the land to the government under section 17 A and B.
After how many years?
Because no notice was issued, but still I am in possession of land. No inquiries conduct, I have produced entire order sheet maintained by the assistant commissioner. Goes, no notice was served to me, no issued to me.
Notice ಯಾರು order ಮಾಡಿದ್ದಾರೆ?
Notice ಬಂದಿಲ್ಲ, ಯಾವ್ದು ಇಲ್ಲ, ಎಂಟೈರ್ ಆರ್ಡರ್ ಶೀಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೇನೆ. It is against the principle of natural justice.
PG accepts notice for respondent. The petition is filed challenging an order of vesting passed under section 83 of the Land Reforms Act, in the premise that there was a contravention of section 79 A and B by the petitioner in purchasing agricultural land. It is the case of the petitioner that he had absolutely no notice of the proceedings, and without hearing him, the impugned order has been passed. The petitioner has produced the order sheet maintained by the assistant commissioner as annexure C. Perusal of the said order sheet would indicate that there is no mention of notices being ordered or that notices were in fact served on the petitioner. In fact, the entire order sheet maintained basically indicates that the proceedings were being adjourned due to the unavailability of the presiding officer. And ultimately on 25/7/2015, that is nearly 7 years after the proceeding initiated, an order is passed that section 17 and A and B are contravened, which requires an order of vesting to be passed. It is therefore clear that the impugned order is in gross violation of the principles of natural justice. In the normal course, the matter would have to be remanded to the assistant commissioner. However, since section 79 A and B have been omitted by virtue of an amendment to the Land Reforms Act, the proceedings are ordered to be abated. No use of force will be served by remanding the matter, hence proceeding section will stand abated.
Seal number 42, Shri A.C. Balraj.
My lord, I appear for the petition, my lord. Annexure F and H are question, my lord, 136 proceedings. My lord, the 136 3 proceedings, my lord. My lord, the father of the grandfather of the pair respondents 4 and 5 sold the property in favor of the father of the petitioner by a registered sale deed, my lord. The registered sale deed. And my lord, after a long lapse of time, my lord, the father of the respondent 4 and 5, he moves an application before the Tahsildar. Tahsildar issues an endorsement, my lord, saying that not, he doesn't oppose to effect mutation.
Because on
There
the
are-
base of a sale deed that he sought for mutation.
Yes, man, he says, my lord, he is the owner of the property, but he does not produce any document because the grandfather of the respondent 4 and 5 sells the property way back in the year 1949 in favor of the father of the petitioner, my lord. Before the Tahsildar, before the assistant commissioner, he does not make anybody proper parties, my lord. Only Tahsildar is made a party. Within 3 months, my lord, the orders, the assistant commissioner passes order.
Thereafter, we file a revision petition, my lord. From 14 to 2017, my lord, no proceedings were initiated. And finally, see the order sheet, my lord, order sheet as per Annex G, my lord, page 38. Page 42 may kindly be seen, my lord. Page 42, my lord, only on 2 days he works on proceedings and post the matter for final order. And in final order, my lord, just one, after extracting the contention, he says, my lord, there is a document standing in favor of the father of the respondents 4 and 5. So he passes an order for effect.
Page 33 of the Assistant Commissioner's orders, my lord. He produced the sale deed, my lord, RR, LL, Issa Pakka, preliminary register. The documents are produced, my lord.
We are not made parties only.
Page 33, my lord.
Annex F, my lord.
Next year, Assistant Commissioner's order.
In fact, I produced the sale deed also, my lord, Annex A. Is a registered sale deed, my lord, in favor of my
Khata was
grandfather.
also allotted, my lord. Based on the sale deed, my lord, the entries has been taken place.
No, AC order was passed against, where is that, 16/12/2013?
My lord,
16/12/2013.
Lord,
Where is that endorsement? 16/12/2013?
RRT.
Tahsildars, my lord.
Huh.
I have produced, my lord. The endorsement, Sikila,
That is not produced.
that is not there, my lord. In fact, my lord, we are not made parties only, my lord, before the
I
assistant.
don't even know what is the endorsement.
My lord, endorsement, my lord, he says, my lord, it's going to pass. Really, we are not at all parties with the assistant
Application
commissioner.
was also
And
filed
in
that
fact,
that was
my lord, in the deputy commissioner order, my lord, kindly see the order sheet also, page 44, 42. Just, my lord, from 2014 to 17, no sittings, no proceedings were conducted. And just on last date of proceeding, my lord, ಅರ್ಜಿದಾರ ಪರ ವಕೀಲರು ಗೈರಾಜರು ಪ್ರತಿವಾದಿ ಮೂಲ ಪರ ವಕೀಲರು ಹಾಜರಾಗಿ ವಕಾಲತ್ತೊಂದಿಗೆ ಲಿಖಿತ ಆಕ್ಷೇಪಣೆ ಮತ್ತು ದಾಖಲೆಯನ್ನು ಸಲ್ಲಿಸುತ್ತಾರೆ. ಪ್ರಕರಣವನ್ನು ಆದೇಶಕ್ಕೆ ಇಡಲಾಗಿದೆ. Absolutely, my lord, no opportunity to contest, to submit our arguments, my lord, before the deputy commissioner. In fact, my lord, by a registered sale deed, we have purchased this property, my lord. And that document is also produced. 11/1 to 1949, by registered sale deed, we have acquired the property. And right from 1949, my lord, we have produced the encumbrance certificate showing that there is no transaction taken place in
What is
respect
the
of
order
that
that
land.
was challenged before the AC?
Lord, the AC, my lord. The RRT proceedings order, my lord, 16/12/2013.
Yeah.
136-2, my lord.
No, what is the order? What is the endorsement?
That is not produced in this writ. My lord, I have to secure instructions. The order also, it is not observed, my lord. What is the proceedings before the assistant commissioner? My lord?
There's, at page number 34,
Please.
he says that there's a registered sale deed of the year 85.
Right, it
Yes,
is
my
not
lord,
so
10,
much,
8,
there is no,
1985.
no, it is not,
And
it,
also he produced, my lord, RR, LL, Issa.
Lord, it
Akka,
is,
preliminary
it is not a
register.
sale deed of 1985, my lord, it is a sale deed of 1895. In my synopsis, I have said, my lord, it is a sale deed of 1895, wherein the grandfather, there is
Who are
no
you?
1895, my lord, there is no sale deed of 10/8/1985, because I have produced the encumbrance certificate, my lord, for all the years. There is no such entry in the encumbrance certificate, my lord, with regard to this sale deed. It is not at all existing. I have verified, my lord, from the records. That sale deed, that statement of sale deed dated 1985, it is not existing, my lord. It is not in existence at all. There is no such document.
There is a record, name of Lingas was written in the ROR, was also assigned RR number 436.
In my synopsis, my lord, I have stated, my lord, in 1895, my lord, the grandfather of the respondents 4 and 5, he purchases the property. Thereafter, my lord, he sells the property, my lord.
Released.
My lord, I
Immediate
sought,
take notice for us.
my lord, I sought for status quo, my lord. They want to sell away the property.
ನಾಳೆ ನೋಡ್ತೀವಿ ರೀ.
Please.
ಫಸ್ಟ್ ಹೇಳಿ.
Serial number 49, Shri Chidananda P.
Lord, respondent number 3 files an application under Form 7 in the year 1976. His application comes to be rejected in 2011. He files an appeal before the Karnataka Appellate Tribunal, mentioning it as a Form number 7A. The Appellate Tribunal, without looking into that, the application filed by them.
ನಾವು ನೋಡಿದಿರ. Form 7 ರಿಜೆಕ್ಟ್ ಆಗಿದೆಯಾ?
Page number 15, please, Manoj. Your lordships could can find it at page number 15, page para 2. Petition copy.
76 ಅಲ್ಲಿ ಫಾರ್ಮ್ ನಂಬರ್ 7 ಇರಲಿಲ್ಲ.
He wrongly mentions it as form number 7A, please.
To notice, the accept notice for response. Next to the stay of all for the proceedings pursuant to an exterior.
Obliged. Serve ಮಾಡಿದಷ್ಟೇ ನಿಮ್ಗೆ ಒಂದು ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ತೀನಿ.
Serial number 32, only council submission kindly. Hard question. Connection federal ಏನು ಆಗಿದೆ.
ನಾ ಫೈಲ್ ಇಲ್ಲ ಅಂದ್ರೆ ನಾನು ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಬೆಳಿಗ್ಗೆ ಯಾರ್ಯಾರು ಹೇಳಿದ್ರು ಅದನ್ನೆಲ್ಲ ಎತ್ತಿಟ್ಕೊಂಡೆ. What is your prayer?
Prayer, annexure F and G, because state by disorder.
What is annexure F?
J.
What is annexure F and G?
F and G, two out of proceedings has been initiated and the RTC was rejected, but the grant was not rejected. Only against one person. Thereafter, our total 32 persons have challenged before the commission. So the same was again it is preferred the petition on behalf of 17 members annexed J. The same ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಏನು ಅಂದ್ರೆ ಬೇರೆಯವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ. 17 ಜನ ಮೊದಲು ಅವರು ಸ್ಟೇ ತಗೊಂಡಿದ್ರು. ಇನ್ನು ಇದರಲ್ಲಿ 9 ಜನ. ಸೊ ರಿಮೈನಿಂಗ್ ಆರ್ ನಾಟ್ ಎನ್ಕರೇಜ್ ಟು ಮೇಕ್ ಪಾರ್ಟೀಸ್.
Access notice for respondents.
So far as petitioners are
Post along with WP 956/2023.
where is the entry model?
It shall be
Page 120.
an interim order.
17.
Of the order dated 4/2/2000. ಬೇರೆ ಆರ್ಡರ್ ಅಲ್ವೇನ್ರಿ ಅದು? ಅದ್ರಲ್ಲಿ ಇದೆ ಬೇರೆ ಆರ್ಡರ್ ಅಲ್ವಾ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ? ಎಲ್ಲಿದೆ ತೋರಿಸಿ. ಇಲ್ಲಿ ಎಸಿ ಆರ್ಡರ್ 4/12.
Page 121.
No.
Annexure F and G are the entry model. The annexure G is the order passed by the executive. Page 150.
Interim order of stay of all of the proceedings pursuant to next year. Next year, first. G is only an order of dismissal.
G is the order passed by deputy commissioner.
G is an order of dismissal. There's no point in staying it. Annexure F state is automatic.
Here.
AC orders cancels the grant, isn't it?
Equal to ಎರಡು ಮಾಡಿ. Annexure J. Same order, sir. Same order.
77 one date fix.
ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು ನಿಮ್ಗೆ?
States ಅದರಲ್ಲಿ the
Idea number
hardship are
77.
directed to make their submission.
77.
ಅದ್ರಲ್ಲಿ some repeated enquiries ಅಂತ ತಾವು
ಅವ್ರು ಯಾರ ಹತ್ರ ಫೈಲೇ ಇಲ್ಲ.
Still number 85 minutes, 482 matter. Still number
ಅದು
85,
ಯಾವತ್ತಾದ್ರೂ
482
ಡೇಟ್
matter.
ಫಿಕ್ಸ್
The entry model close ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿ. So court had already appeared, approached this honorable court and quashed the proceedings.
ನೋಡಿದ್ದೀರಾ ಯಾರು?
SPP office. SPP office. Stay ಇರಲಿಲ್ಲ.
After tomorrow.
I will inform.
ನಂದು 77 ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ.
Petition was filed to enter the name of the petitioner in the Hatha extract. Respondents have clearly complied with the particular prayer.
And comes for the petition submits that the prayer made in the writ petition does not survive a conflict. Later the above writ petition is disposed and unnecessary.
And 77 ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ.
Serial number 78.
Day after tomorrow.
My lords,
List to serial number 11, my lords. 1 week time may be given.
ಇಲ್ಲದ್ರಲ್ಲಿ 2 ವಾರ ಕೊಟ್ಟಿದ್ದೀನಿ.
Serial number 72, my lord. It's a army matter. He has filed an application seeking grant of land. Date may be fixed, my lord.
ಡೇಟ್ ಕೊಡ್ತೀರಾ ಅದಕ್ಕೂ ಕೊಡ್ತಾರೆ ಡೇಟ್.
Serial number 70.
Temporary grant in the permanent grant in the Oka and authorization. 74 and 74.
ರೆಡಿ ಇದಾರೆ ಕೇಳಿ ಅವರು.
Madam.
Inspection ಡೇಟ್ ಕೊಡು.
76 serial.
serial number
Come from there, come from this. 60
Next week.
2 ವಾರ
ಡೇಟ್ ಕೊಡ್ತಾರೆ, they'll give you date.
ಬಂದಿಲ್ಲ.
Serial number 63.
Serial number.
2 ವಾರ ಡೇಟ್ ಕೊಡು.
Entry model extended wherever there are entry models.
68, my lord.
Day after tomorrow ಡೇಟ್ ಕೊಡ್ತಾರೆ ಅವರು.
Serial number 63, my lords. It's a date given matter for today, my lord. It may be
Motion
taken up tomorrow. Serial number
ಯಾವ
63,
ವರ್ಷದ್ದು?
2012, my lord.
Tomorrow.
Matter was heard.
Tomorrow.
76 day after tomorrow.
ಯಾವ ವರ್ಷದ್ದು? ಡೇಟ್ ಕೊಡ್ತಾರೆ, ಡೇಟ್ ಕೊಡ್ತಾರೆ.
serial number 78, next week, my lord. Serial number
They'll
70.
give you a date.
Serial number 75. The bond will be extended, my lord, and 44 years I'm in possession, my lord. Now, grant is cancelled.
What do you want me to do?
Any date fixed.
ಕೊಡ್ತೀನಿ, date ಕೊಡ್ತಾರೆ.
My lord, serial number 73, my lord. My lord, the interim order may be extended, my lord.
We'll extend entry models wherever there are.
73, IA for vacating stay, my lord.
Number?
73. IA for vacating stay. 1966 ಅಲ್ಲಿ ಬಿಲ್ ಆಗಿದೆ ಅಂತ ಹಾಕಿದ್ದಾರೆ ಸೊನ್ನೆ. 99 ಅಲ್ಲಿ ಅವ್ರ ಮಕ್ಕಳಿದ್ದಾರೆ ರೆಸ್ಪಾಂಡೆಂಟ್.
73.
73. ಎಂಟ್ರಿ ಮಾಡೋದ್ ತಗೊಂಡು ನಮ್ಗೆ ಕೆಲಸ
My lord,
ಮಾಡಕ್ಕೆ
kindly have it on next week, my lord. See, ಹೊರಗಡೆ ಹೋಗಿದ್ದಾರೆ, next week ಅಲ್ಲಿ ತಗೊಂಡ್ಬಿಡು.
Orders ಅಲ್ಲಿ ಬರುತ್ತೆ. Next week.
27 ನಾಳೆ ಹಾಕ್ಬಿಡಲ್ಲ ಸರ್. 24 name order. 75 for order. Entry model.
Sir, ಎಲ್ಲ dates ಕೊಡ್ತೀವಿ.
77.
Ready, sir.
ನಾಳೆ
Sir.
ಹೇಳಿದ್ರು ಸರ್.
73 days, sir.
77.
Court of sir.
ಮೆನ್ಷನ್ ಮಾಡಕ್ ಹೇಳಿದ್ದು.
Sir.
77 ಸರ್. ನಾಳೆ.
Hello?
76.
ಏನೋ ಅಲ್ಲೇ ಮಾತಾಡ್ತಾರೆ.
77. ಹೇಳಿದ್ರು ಸರ್ ನಾಳೆ ವಿಶ್ವನಾಥ್ ಸರ್ ಅದೇ ಮೆನ್ಷನ್
ಇನ್ನು ಅಡ್ವೊಕೇಟ್ಸ್ ಮಾತಾಡ್ತಾರೆ.
ಅಲ್ಲ ಸರ್ 4:15 ಮಾಡಿದ್ದು.
Sir, 73, sir.
ಮಾಡಿ ಆಫ್ ಮಾಡಿ.
24 ದೆಲ್ಲ dates.
ಇಲ್ಲ 77 ಹೇಳಿದ್ರು ಸರ್.
ಕೊಡ್ತೀವಿ dates.
ನಾಳೆದ್ದು ಕೊಡಿ ಹೇಳಿದ್ರು. ಸರ್ 4:30 ಮೆನ್ಷನ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ಸರ್.
ಅವರು ಏನ್
Sir.
ಇಂಪಾರ್ಟೆಂಟ್ ಎನ್ಕ್ವೈರಿ ಇದಕ್ಕೆಲ್ಲ ಆಗಿತ್ತು, ಅದಕ್ಕೋಸ್ಕರ ಅದು 4:30 ಮೆನ್ಷನ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದು. 77
ಮಾಡೋದಿಲ್ಲ, 24th. ಅದೆಲ್ಲ ಡೇಟ್ಸ್ ಕೊಡ್ತೀವಿ ಸರ್, ನೋಡ್ಕೊಳ್ಳಿ, ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ ಎಲ್ಲ. ಎಂಟ್ರಿ ಮಾಡೋರ್ ಇರೋದೆಲ್ಲ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
Sir, one sec. Sir.
Sir, 73 interim order ಇತ್ತು, sir.
ಎಂಟ್ರಿ ಮಾಡೋರ್ ಎಲ್ಲೆಲ್ಲಿ ಇರುತ್ತೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
Date, sir, date.
26 ಒಂದು.
ಡೇಟ್ಸ್ ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ ಆಮೇಲೆ.
Sir, 76 ಒಂದು ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡಿ ಸರ್. ಲಾಸ್ಟ್ ಟೈಮ್ ಹ್ಯಾಂಡಿಕ್ಯಾಪ್ ಸ್ವಲ್ಪ.
ಸರ್ 23, 24 ದೆಲ್ಲ ಡೇಟ್ ಕೇಳ್ಬೇಡಿ ಸರ್. ಮೆಮೋಸ ಇಷ್ಟಿದೆ ಬಿ ಗ್ರೂಪ್,
70.
ಅದು ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಅಂತ ಕೊಟ್ಬಿಟ್ಟಿರ್ತೀರಾ, ಹಾಕಿರ್ತೀವಿ, ಹೋಗಿ ಅಲ್ಲಿ ಗಲಾಟೆ ಮಾಡಿರ್ತೀರಾ, ಅಲ್ಲಿ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಬಿ ಗ್ರೂಪ್ ಹಳೆ ಹೊಸದ್ ಯಾವ್ದು ಹಾಕ್ಲೇಬೇಡಿ ಅಂತ.
ಸ್ವಲ್ಪ 70 ಸ್ವಲ್ಪ ಹ್ಯಾಂಡಿಕ್ಯಾಪ್.
ಬೇಕಿತ್ತು ಸರ್ ಅದಕ್ಕೆ.
ಹಳೇದೆಲ್ಲ ಬರುತ್ತೆ ಸರ್, ಅಪ್ ಟು 20 ಎಲ್ಲ ಡೇಟ್ ಕೊಡ್ತೀವಿ ಸರ್. ಅದೇ ಕೊಡ್ತೀವಿ, ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ ಆಮೇಲೆ ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಚೆಕ್ ಮಾಡಿ. ಸರ್ ಇವ್ರೇ 76 ಸರ್ ಸಾಹೇಬ್ರೆ 24 ನಿಧಾನ ಲೇಟ್ ಕೊಡೋದು. ಮೇಡಮ್ ನಾಳೆ ಸರ್, ನಾಳೆ
ಸೀರಿಯಲ್ ನಂಬರ್ 72 ಸರ್, 72 ಸರ್.
ಅದೇ ಅವ್ರದ್ದು 26ಕ್ಕೆ ಬರುತ್ತೆ, 26ಗೆ ಎದ್ದಿದ್ದು 26ಕ್ಕೆ ಬರುತ್ತೆ ಅದು ಸರ್. ಓಕೆ ಓಕೆ.
ಇದು ಎಲ್ಲ ಆನ್ಲೈನ್
ಹಳೆ ಮ್ಯಾಟ್ರ್ ಎಲ್ಲ ಮೇಡಮ್ ಇಲ್ಲ ಮೇಡಮ್, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ಬರುತ್ತೆ. ಹಳೇದೆಲ್ಲ ಬರುತ್ತೆ 23, 24 ಅದೆಲ್ಲ
65 ನೆಕ್ಸ್ಟ್ ಮಂಡೇ
ಕೊಡ್ತೀವಿ, ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ ಡೇಟ್. ಇವಾಗೆಲ್ಲ ನೋಡ್ಕೊಡ್ಬೇಕು ಅದೇನೆ ಕೊಡ್ತೀವಿ, ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ ಆಮೇಲೆ ಡೇಟ್ ಕೊಟ್ಟಿರ್ತೀವಿ, ಚೆಕ್ ಮಾಡಿ. ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ನಾಳೆ ಇಲ್ಲ. ಮಾಡಿ ಮಾಡಿ ಅಂತ ಒಂದು ಇವರೇ ನಾವು ಕೊಡ್ತೀವಿ, ಅದೇ ಕೊಡ್ತಾರೆ ಅಂತ ಹೇಳಿ ಸಾಹೇಬ್ರು. ಸರ್ ಎಲ್ಲ 2 weeks ಕೊಟ್ಟಿದ್ದಾರೆ ಟೈಮ್ ಕಂಪ್ಲೈ ಮಾಡೋದು. ಲಿಸ್ಟ್ 2 ನಲ್ಲಿ ಡೇಟ್ ಇಲ್ಲ, 2 weeks
ಸರ್. ಸೀರಿಯಲ್ ನಂಬರ್ 75
ಡೇಟ್ ಕೊಡ್ತೀವಿ, ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ ಆಮೇಲೆ ಆನ್ಲೈನ್ ಅಲ್ಲಿ.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 71 ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ಬೇಕಿತ್ತು.
ಎಲ್ಲೆಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದ್ರೆ ಎಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
71 ಅಲ್ಲಿ ಇತ್ತು ಸರ್.
ಹೌದು, ಎಲ್ಲೆಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
ಓಕೆ ಓಕೆ, ಡೇಟ್ ಕೊಡ್ತೀರಾ ಸರ್?
ಮೇಡಮ್ ಹಳೇದೆಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕೊಡ್ತೀವಿ, ನೆಕ್ಸ್ಟ್ ಮಂಡೇ. ಅವ್ರಿಗೆ ಎಸ್ ಸರ್ ಕಳಿಸ್ತೀನಿ.